Hey, what's up, guys? Welcome to Law Splaining the Interwebs. I'm your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. My humblest non-apologies for being late. With me today so far, I don't know if we're going to have more or not, but Richard, how's it going, man?
It's going all right. Do you have any idea how late this is?
Well, normally I would say no, because I do this every day.
I know you must not need sleep, Nick. I got to tell you. Here even 1 hour past 11 p.m. Central in the Eastern time zone that some people forget Michigan is in. It's late, man.
Yeah, it is, and I'm actually on Eastern time today because I woke up in Maryland at 6 a.m. and then flew home to be back in Minnesota. So
More power to you.
I'm feeling it a little bit. I got a nice little 2-hour nap on the plane, but other than that, I've been going the whole time. So
No, I had to be here at minute 1 because I don't know how late I'm going to go.
yeah, well, if you need to dip out at any time, feel free. Feel free. I really appreciate you being here.
Yeah.
So, we are going to delve into something that I love to do, and that is search the mind, the legal wisdom of Legal Eagle. He has had takes in the past that I have found to be wanting, and but I do try to give him a fair read. So if you're curious of my previous takes on Legal Eagle's takes, the last one I did was a video dedicated to his interpretation of the power of the pardon under Donald Trump, and you know, I've that video recently got an uptick in traffic, so that one's fun. But today we are going to talk about a subject that I know rather intimately, and that is the lawsuit of of Kyle Rittenhouse, which Legal Eagle has put out his video on. Now, you've watched this thing, right?
I have.
Okay, I have not. So this is a dry read.
Yeah,
for
and
me.
I wanted to be here maybe to be devil's advocate. I don't know how many people know. Frankly, I don't know how many people know me, but I've been on Legal Eagle's channel. I consider him a friend of virtual legality. He's promoted some of my videos in the past, and interestingly, in terms of my history, I met him essentially doing a response to a video that he did. I don't know how many people remember this, but when YouTube was really putting out all of the COPPA information, or what in my opinion, is misinformation, how you actually operate on YouTube. And he did a video on it. And I had done at that point 8 videos, and I did something that was called essentially, provocative, what Legal Eagle got wrong about COPPA. And in terms of Devin, to his credit, he responded to that and said, "Hey, you want to come on and talk about it?" And we went from there. So, I mean, I think I've watched this video. I think some of it's quite solid. I think some of it's not. But I did want to present at least. I think I know how he got to certain places, and I might be a little softer on him than you.
Well, look, I'm always willing to give him a fair shake. But my ever since and I didn't do a direct video on this, but I've talked about it on live streams. Ever since his take on the Captain Marvel movie, I have been just I occasionally.
I didn't know that one. Does he like it?
Well, it's not about whether he liked the movie or not.
Oh, okay.
There's a deleted scene in the movie. And then in the deleted scene, Captain Marvel shows up. She's looking at a map, and this guy on a motorcycle. Have you seen this deleted scene? You know what I'm
I have.
about?
This is the Smile More, right? And then
Yeah, and then she breaks his arm, takes
yep.
his jacket and motorcycle. So he said that was a justifiable use of force. Based on the battery of the guy grabbing the map, which I don't think is an accurate depiction of use of force law, if I'm going to say so. So ever since then, I kind of I don't like watch his videos or whatever. He's amazing. Like, let me be very upfront. Legal Eagle knows how to work it. The dude puts out very well produced content,
Yeah,
and
absolutely.
he's wildly successful at it, and that's great. I wish nothing but the best. However, when he puts out a video that I have some interest or knowledge on, occasionally I like to comment, and
Sure. No, of
this
course.
is one of those times. But I'm hoping he gets it right. Another we're going to start on that in just a second. What can't I talk? We're going to start on that in just a minute, because I want to hit that while you're here. But to the chat, after that video, I'm going to do some discussion of Dominic Black. It was what I kind of teased on Tim Pool's show, but we never actually got around to talking about it. There's an update in his case, and I'm hoping to provide a little bit of context around that I have heard from someone with a little more knowledge of it than what's just generally available, because it's not being televised, right? It's not. This is the thing where I suggest that we need to have all courts televised all the time. I think that is how we ensure against improper behavior. But we'll be talking about that at the end of the Legal Eagle video. And yes, so with that, let me hit this. Wilhelm Goldbert says, last year Christmas, you honored my grandfather with a toast. This year, hate to be have a request with sad news, but I lost my mother this afternoon to COVID. Words can't express how I truly feel, but I've been on this rackets ride for quite some time, and it would be an honor. Well, sir, look, that's a rough go. No one wants to lose a parent, and I'm going to propose a little toast to your mother's honor, if that's okay, and then we'll move on. So I am so sorry to hear that you're going through that, but you are here amongst friends, and so it's there are worse places to be. But Wilhelm, to the memory of your mother, may the rougher memories fall to the wayside and the stronger, better memories rise to the fore as we remember the life of the woman who built you to the man you are. Cheers, brother. Okay. All right. So with that, oh my goodness. I've got a chat from my dad too. He says, a toast to Mr. Goldbert's mother. May she rest in peace. So there you go. There you go. Opening up with a little bit of emotion. And I guess I should pull up this video. I mean, if we're going to watch it, I should probably have it, available.
Seems a necessary first step.
Oh, and one announcement as I do pull this up. I am starting, I mentioned this, I've mentioned it a couple times, but I am starting a daytime show tomorrow. It will start at 1. Oh my goodness. It'll start at 1 p.m. Central Time. No, stop it, Legal Eagle. Stop talking. Stop talking. I'm not done yet. Sorry.
Thought he was here momentarily.
Yeah. So it will be at 1 p.m. Central Time. It will be 2 to 3 hours. That will depend. And live chat Wednesday will occur at the end of that show for my locals members and Discord members. So if you were there, live chat Wednesday will still happen. It will happen either 3 to 4 p.m. It depends on when we end the show. But that is how that will be. And that is likely where I will be going forward. A 1 p.m. weekday show. And members of the lawyer panel or whatever the heck it's supposed to be called will
We're going to have to come up with a better name than that.
Yeah, I agree. But they will be there will be open invites for discussion on topics. I've already been grabbing a bunch of those topics. There's the Waukesha incident, which is just an awful tragedy. No, an atrocity. Correction by my friend Larry Blydner. It is not a tragedy. Those are accidents. Atrocities are man-made. So we will be covering a little bit of that. I know a lot of people want to talk about this other Kenosha case with the sex trafficked young woman who killed the person who was involved with her, and whether that can be a self-defense claim. So that's on there, and a whole bunch of other topics. And since I'm going to be doing this every day with any guests who want to join, we're going to be able to churn through a lot of those topics. So with that said, let's get this video started, because my poor guest is
You've been up as early as I have.
I'm gonna bring us down just a hair on the audio, and and then that way we'll hopefully not be over the video. But you know what StreamYard needs? It needs a monitor function where I could hear myself with this, but it doesn't have it. So all right, man, you ready?
Sure. Fire away.
Any last words? I'm just kidding.
No, I mean, I think what you'll see in this, spoiler alert, I guess, in terms of flow, is I think you'll find out he starts out strong and then kind of loses steam a little bit.
This man has a nice suit coat on. I like that pattern. I really.
Well, he has. Have you ever listened to his sponsors? He's got all sorts of suit and
like 9 million
fancy stuff sponsors, man.
If any t-shirt sponsors want to sponsor me, I'll wear your t-shirt or whatever. Suits, I guess. It would get so warm wearing a suit doing YouTube to me. Oh God. Okay, let's do this. Here we go. And the one thing I'll do on this one is when I do these, I tend to pause to talk about things since it's not live. So if you have anything you want to add, just like signal me or something.
I need a pause button. Yeah, no, it's all good.
Oh God. I mean, it was good. Now it's a little bit more neutral, but we have another guest. Hey, what's up, Joe?
I'm great. How you doing?
I'm good. Although I saw, I thought you had agents out to get me.
What does that mean?
I was walking through the airport and there was a guy like mysteriously on a cell phone. He had a very wide brim black hat. I was like, it's like, is Joe after me here? Is he
Have you ever seen me in a fedora? Have you ever seen me? I really rock a fedora really well.
No, I didn't think it was you. I thought it was your agent. I thought I thought you were sending people after me.
Yeah, actually, you're so lucky. You're so lucky that I didn't think of it until today, because I had Drex on last night, and
yeah, you guys should have roasted me.
I have deep regret that I didn't think to just re-stream his stream and just tear you apart while you were doing that. Just laugh at you while you were sitting there. And when you came up, I can't believe you threw out facial abuse twice. That was actually someone said they'll pay you $500 per facial abuse reference, and
they have made good on that promise.
And they better, because it's not like it was like something that just naturally came up. It was the most unnatural thing to say when you said it. Was like,
no, I had to work it in there. I was like,
it wasn't neat either. It was like you crammed facial abuse in there.
Well, that's how facial abuse works. Yes. You got to cram it in there. So, anyway, with that,
sorry, Richard, I didn't mean to. He's
no, you don't need to apologize to me.
No, Joe, if there's one thing you should have learned from the last week from the patron saint, Kyle Rittenhouse, it's that you miss 100% of the shots you don't take. And
Indeed.
You missed this one.
God.
You missed this one.
That can be taken like 3 different ways, and every one of them works. That works way better than the ease of you, than the difficulty you had in shoving that comment in there. Because
I just love so everybody's like, wait, what's that? Wait, what's that? Wait, what's that?
What did you say? What did you say? It's great.
Hopefully,
you got to talk, and Viva Barnes didn't. So maybe he realized that Tim Pool is now listed in Urban Dictionary as somebody who talks over his guests.
A lot of people said I should have talked more and etc. And what I will say about the show is their setup is amazing, and anyone would be envious of that studio. And the way that they do the video, I think people kind of fall naturally into this allow the other person to speak format, because they're cutting to different cameras live. And so the breakup of the conversation, while it feels a little disjointed audio wise, because it's like, okay, X person talks, it's not a very natural flowing conversation, but for the camera and for the production, it works really well. And it was weird because everybody just kind of falls naturally into it. Or at least they did there. There were no like lectures about it or anything like that. It was, but they run a pretty cool operation. I mean,
big time.
Would that we all made enough money to make that type of setup? It would be great. It would be great. And hopefully someday we all will, right?
Amen.
That's the goal.
One day I'll move off of a USB mic leaning on top of 3 law books, but you know, today it's not that day.
One day,
a mount, man.
one day I'll have headphones that I didn't pay $10 for a quick check, and I'm gonna be like rising up to the next level.
But it was a fun experience. That was for sure. And they were super hospitable. They gave me a whole bunch of nice whiskey to drink while I was there, and they arranged everything. It was really cool. It was really cool.
Cool. Well, you did great, and
well,
we were all proud to have someone that we know like rise up into that strata. It's kind of cool. So
should I show like Tim was proud of me too. Here, this will be real quick. Where the hell? Okay, here we go. I got to share this. This is from the Tim Pool studio. And you know, it was just great that he was so proud of me. My big brother, Tim Pool. So, you know, that was nice. It was good.
That's great.
I mean, I really looked up to him. So
I bet Tim should frame that one. That's a great shot of him.
Okay, that's enough fun. Now we have to get to the serious business.
Let's get to work here.
Let's see. I hope I shared the audio. If you can't hear this, yell at me quick.
After a 2-week trial, a Wisconsin jury acquitted Kyle Rittenhouse for shooting 3 people, killing 2 during a racial justice protest in Kenosha. At the time, Rittenhouse was a 17-year-old from Illinois who traveled to Kenosha after right-wing social media accounts called on people to protect the city from riots.
I am an EMT if you are injured.
Okay.
Oh, Joe's asking for a pause already.
Yeah, I just want. Did you all notice that he referred to him as Jacob Black, not Jacob Blake? Did you cover? Did you cover?
Okay,
look, it shows you where his mindset is.
But I'm gonna defend Legal Eagle here. When you get in the flow of what you're gonna say and you get going, sometimes you get a name a little bit wrong. So
okay, but it's like to get it wrong that way in this particular instance.
Kind of early and kind of important, but you know, I called Christian one time, which you know, it was anyway.
Fair enough.
So
you do hope you find those things in the early stages, you know, when people are still awake during your video, first minute, you want that to be strong. But I mean, he also, you can see what he's going to do in this video. And again, I find this to be a fairly solid video, but he starts out by framing it against, you know, right-wing media news sites. I mean, like that's in the first 15 seconds. So, I mean, you can see what's going to happen. You already know how this is going to go.
Yeah. That was an interesting thing, how he framed it as right-wing social media accounts requested backup, basically. And that's what Kyle responded to. And that's a fact, not in evidence in the case at all. There's no testimony from either the state witnesses or the defense witnesses that Kyle was responding to a social media request. So I find that to be a little bit odd that that's where he chose to go with that. Okay, on we go.
Come to me.
Rittenhouse acted in the midst of a chaotic protest where many people were legally carrying guns. Bystander videos show that the 3 men that Rittenhouse shot had been in confrontations with him. Rittenhouse has now been found not guilty on all 6 counts arising from his conduct that day.
We the jury find the defense.
5 counts.
7 counts,
well,
technically.
Well, 2 counts dismissed without a verdict. 5 counts not guilty. Right.
Yeah, it's kind of a of all the he got it the most wrong. That one's kind of weird. Like if he would have said 5, you go, oh, okay, well the 5 that remained. If he would have said 7, it's like, oh, okay, including the other 2, but he says 6. It's kind of an interesting one.
It was 6 the morning of, right? So maybe
there you go. Yeah. All right, here we go. Look at it, man. You know, this is someone to watch in this video. If you're going back and watching the verdict, Kyle breaks down, he's in the forefront, but his sister and her reactions are just like, you can see how much this has been tearing that family apart. Okay, here we go.
Defendant Kyle H. Rittenhouse not guilty.
So what happened at the Rittenhouse trial? Why did the jury conclude that he was not guilty? Is it a travesty of justice or a defensible outcome? There's no dispute that Rittenhouse killed 2 men and injured a 3rd, but as we talk about often on this channel, that's not the end of the analysis. And here it was only the beginning. Many people thought that when Kyle Rittenhouse admitted on the stand that he intentionally used deadly force on Rosenbaum and Huber, that was a huge tactical blunder. But
that was not ever a huge tactical blunder. I know, and he's about to say that, I think. This isn't a criticism of Legal Eagle, but first of all, putting Kyle Rittenhouse on the stand is arguably a tactical blunder in and of itself. We've discussed this ad nauseum, but the fact that Kyle said he intentionally used deadly force, that's what you have to do in a self-defense situation. So to anybody out there who may have been included in this, sort of characterization by Legal Eagle, please learn self-defense law. And you can do that by checking out lawofselfdefense.com with Andrew Branca, who will give you
a free book.
Yeah, there is a free book. Well, I don't know if it's still free or if that was a part-time promotion. So I don't
know. I
don't want to oversell that, but people should definitely check that out. And also check out his recent response to the Harvard criminal law professor who got this case and the Zimmerman case entirely wrong.
He's been angry on Twitter. It's been amusing to watch, honestly. Angry Twitter.
I want to point out, if he said anything other than he intentionally used lethal force, he would have shot all credibility and that would have been the most disastrous testimony of all time.
And I think Nick covered it, but Legal Eagle is that's exactly what he's gonna say.
Yeah. Yep. Real quick, how much do you think rough bid on the books? What do you think?
Well, the curtain
20,
must cost like $9.
No, okay, but assuming the books are real, like what, 20, 25,000, right?
Oh,
yeah.
Like that's an expensive library behind him. It's almost as expensive as my Warhammer shelf, but it's not quite.
It's pretty funny.
Are
right?
you positive
you only need like one shelf of those to get through law school, give or take, maybe.
You don't even need,
I don't think you need any. I think you just need one shelf of those. Free Westlaw subscription.
Yeah. I mean,
I needed them.
You like the book research? Some people like to pour over the book.
Yeah, I mean, my days in law school were having the books, going to class, and then reading cases for 4 hours a night out of books.
Well, there you go.
But I love law school. I'm a nerd. What can you do?
You can get bullied, nerd. No, I'm just kidding. All right, here we go. I liked law school, but I always had to go home because since I went late and I had at least 2 kids during law school be born, so it was that must be so hard because I came right out of college and I that was all I was doing for 3 years. Yeah,
I actually came out of my contract law final and went and picked up my girlfriend and proposed to her 1 week into 2 weeks of finals.
You're like, hey, baby, I just figured out how this worked. We got a contract coming. Sign on the line.
I got engaged the night I took my contract's final. So,
wow, very cool.
Got
very
me
cool.
minus. So
all right, here we go.
Intentional use of deadly force is exactly the thing that is privileged when you meet the requirements of self-defense. And this case hinged on whether self-defense applied or not. And more so than most self-defense cases, this case turned on the nuances of both self-defense law and criminal procedure. It's not surprising to me that both sides got lots of stuff legally wrong. So let's talk about the law of self-defense in Wisconsin, because every state has different self-defense laws. And in Wisconsin, self-defense, like many other states, is an affirmative defense. In other words, the defendant has the burden of producing some evidence. They must put forth some evidence from which a jury can find that self-defense applied. This is generally called the burden of production. But then once the defense has made this relatively minimal burden, the burden of proof then returns to the prosecution, which must disprove self-defense beyond a reasonable doubt, which is the highest standard in all of law.
Good job, Binger. I love this picture. It's my favorite picture. That's why I put it so prominently all over the thumbnail. But I want to say this. So I've started releasing segments of the trial with our commentary, but and I'm making a playlist that'll have the whole trial, but segmented out. So opening argument of each party and the testimony of each witness. And I went today and I made the Binger opening argument, and I just made the Richards opening argument, which will release tomorrow morning. But I was easily able to find a ton of high quality Binger footage or pictures of him making, dramatic poses. They're all high resolution. Try and find one of Richards. It's exceedingly difficult to find.
What about when he makes the hard R? Does he during his opening? I
couldn't even find that picture. Like, I could go through the video, and grab a screen grab. But I mean, when you go on Google Images and you search, you can find tons of pictures of Binger. And it's really hard to find a good quality picture of Richards. I haven't looked for
a theory there. The media is just covering the prosecution more.
I don't want to say that that's what it is, but it kind of just seems like that's how it worked out. Is that and maybe it's not intentional. Maybe it's just a subtle nod to the court presence that each of them had. But it was just weird because I'm like, I just want a good high quality picture of Richards going like, come on, or anything. And I couldn't find that. It was tough.
Well, I do think Binger is more, how do I phrase this without getting the chat uproiled? Conventionally attractive than Richards in terms of media poses and photos. So maybe that's part of it.
That was not a good choice. You might want to rephrase that, laddie.
I could rephrase it, but I think it's the truth. I mean, I think he comes across as smarmy and everything else, but he looks more the part of law and order guy in front of the court, in my opinion.
Yeah, no, he does. That was commented on by Barnes. Even said he looks like a high-priced defense attorney, right? Yeah. He's also the thing that I noticed when they went up to a sidebar with the judge. One of the rare times that they did, you find out that Binger is much taller than Sharafi and Richards.
Oh,
and so it's just, these are all kind of interesting courtroom dynamics. But I just noticed that when trying to find pictures of him, it was easy to find high quality pictures of Binger, hard to find of Richards.
I'm enjoying the chat responses to that, by the way.
You're toast. You're done forever.
You totally begged for it. They're gonna call you like Fluffer Man 2004. No. You're gonna be.
What can you do?
I'm sorry. I shouldn't have opened that.
Okay. All right. Sorry. Here we go.
Now, every state has self-defense law that basically says a person who is not the aggressor is justified in using deadly force against an adversary when he or she reasonably believes that they're in imminent danger of death or serious bodily injury. Now, jurors aren't lawyers, so juries receive jury instructions that include all the law that they will need to decide a case, hopefully written in plain English. The lawyers and the judge fight over the jury instructions, which will be the only law that the jurors receive in that particular case. Now, it is supposed to accurately summarize the law that the jurors are applying.
Oh, we've got another guest here. What is happening to this man? The internet is destroying this man. How do you do, Mr. Robert Barnes?
How are you?
Hey, good, man. How are you?
How you doing, Barnes?
Yeah, I had to watch a little bit of the Legal Schmiegel. See how much he can desecrate the law in one clean swipe. I assume this one, because so many people are watching, he didn't screw up as bad.
I have no idea yet. I haven't watched it. This is my fresh watch through. So far, he's doing okay. He's laying the foundation of self-defense law, and he hasn't really gotten into the factual matters yet. So that's what I'm curious about. But again,
Just one of the many differences between me and Legal Schmiegel. These are real bookcases with real books.
I keep learning so much about you every time you come on. The other day, I learned that you owned a T-shirt, and today I learned that you own a short sleeve button-up, which is fantastic.
I got a bunch of Hawaiian shirts, and this hat is after the Duran, which people can follow on YouTube. Does a lot of cool foreign policy analysis.
Oh yeah, you guys had him on a sidebar the other day, right? Like a week and a half ago, something like that. Or wait, no, it's Wednesday tomorrow, so like a week ago.
Yeah, or it's some time ago. Yeah.
Yeah. Okay. All right. Back to this. What a good camera this dude has, by the way, and the lighting is phenomenal. I mean, look at that's pro lighting. Look, I can count his beard hair.
Look,
yeah, and
what
the
you can
green
get with
screen
2 million
is almost good
you
enough
just,
to
you
be
just go
believable.
there. You can invest in your studio lighting there.
Yeah, but
no, I have to have someone competent do it.
I mean, does he think he's a character from Mad Men? What's up with the tie?
It's
you know what I mean. The tie, the skinny tie. I mean, it kind of looks like you have a studio set up that's like a high-end studio with a guy who got the jacket's nice, but the rest looks like it's off the Walmart shopping list.
Dang. I'm going to Walmart the next time I need a suit.
That was biting. That was biting and accurate. But okay, to give props where they are due. I mean, look, the reason he's popular, at least amongst the left, is not just because he's spouting leftist opinion. He does an effective job of covering in a first of all, there's very high production level quality.
Very high.
You can't deny that. And what he does well is he looks like a lawyer, and he does Iraq fairly well if you ignore that he leaves out certain critical facts or elements. But what he decides to focus on, he really answers it like you're like a good solid law student would. He goes through the issue and the rule and the application and conclusion, and he does it in a very neat, orderly, structured way, which makes it easier for his audience to follow. And that's, I think, why he's as popular as he is, because he does come across, and that presents an air of professionalism to him. And I noticed the Iraq was very glaring to me throughout this. You're going to stop and start, so it might not be as glaring. When I was watching one sitting, I was like, this just reads like your classic Iraq type answer. It's just that he skips out really important elements, but we'll get there when we get there.
Yeah, that's because he's not a real trial lawyer. I think he's only practiced a couple of years before he started doing this gig. And I guess he kind of has a private
let's
practice.
calm down on that one, Barnes.
Huh?
I'm just kidding. Look, he's got production value, but I've got production value too.
Exactly. I mean, YouTube also loves him. They push him like mad. I mean, I unsubscribed, and they kept pushing and pushing and pushing and pushing. But it's whenever he wanders in. If it's not a neat, clean legal issue that a first-year law student could do, his analysis tends to be crap. If a first-year law student could do it, as Joe was talking about, doing your basic IRAC analysis,
or
issue,
Richard,
rule, application, conclusion for those watching at home, then he can do okay. But like he once talked about tax law, and it was some of the dumbest analysis I'd ever heard. It just got it wrong, and then wrong, and then wrong again, and then wrong again. So if it's any outside of a real simplified area, he screws it up pretty much.
One last thing is I'm forgetting. You know what? Never mind. We're gonna go right into it. We'll see. We'll see how we go.
And as you can imagine, the language of the jury instructions is extremely important. The Rittenhouse jury instructions summarize the requirements for self-defense in Wisconsin as: the defendant believed that there was an actual or imminent unlawful interference with the defendant's person, and the defendant believed that the amount of force the defendant used or threatened to use was necessary to prevent or terminate the interference, and the defendant's beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent death or great bodily harm to himself. Now,
how does he do that with the highlighting live in real time? That was amazing. Sorry.
So I actually give you the answers to that, because Robert Gruller explained this to me. Because he does that in the middle of his thing. What Robert Gruller has is he has like an iPad. And basically that iPad, the screen that he's sharing, he has like a pen, and he's able to basically mark it up with his little, what's it called? That type of the stylus. Yeah. And he has a stylus, and he's basically able to mark it up while he's talking. And I guess in theory, you could do the same thing with a highlighter, although that probably is done post-production. But
Okay. Anyway, I'm
wanna do it
wasting time. He's reading the jury instructions. This is normal normal stuff. It's easy to read through jury instructions and
You
say
can't
this
go
is what
wrong
they are.
reading the jury instructions.
Can't do well.
Unless you're in the Arbery case and the judge decides not to give you a real legal instruction, says, here's what the law says, and I'm going to let you interpret it, jury, which is what happened today, by the way.
Oh God.
Oh, wow.
I thought, see, when the judge was arguing with the defense attorney over the instruction the other day, I was like, oh, their goose is cooked. Because the judge is going to give the instruction
their goose is back alive and floating. I mean, they have a great appeal, but he decided not to define it. He said he literally just read the statute and gave them no explanation at all.
So he backed off of the. We should talk about this later, but
I mean, his interpretation was that the one he was talking about Friday was a ludicrous interpretation. High chance of reversal. I think he was only thinking about it, thinking maybe it was necessary to get a conviction, and who cares if he gets overturned in a year and a half. But I think he thought twice once the defense sent in, here, by the way, are all the reasons why you're going to look like an idiot on appeal. And he was like, well, I still want the defendant screwed, but I don't want to look like a total idiot. So I'll just play Pontius Pilate and I'll just read them the statute. And the prosecutor was literally arguing the law in rebuttal and admitted she was arguing the law and arguing the interpretation of the law. And the judge let it happen, despite many objections, motions for mistrial, etc. But yeah, so who knows what's going to happen in the Arbery case, because the jury's back there interpreting the law.
Well, that's what juries are good at. So
yeah, exactly. Well, I mean, they always impose their own moral narrative on the law anyway. I've never had a jury that actually followed the law or could remember the law. They decide what's right, what's wrong, and that's it. And law schmaw.
All right, let's hit this. Let's get back into this. Here we go.
In a situation like this, a reasonable belief doesn't mean true. One can have a reasonable belief but still be mistaken. Reasonableness is determined from the standpoint of the defendant in the situation at issue, not after the fact. And as an aside, the law of self-defense gets slightly more complicated when you're applying it to different varieties of homicide and manslaughter, because the mental state required is different for each of those offenses.
That's actually not true.
Yeah, no.
The law of self-defense is uniformly applied. Those individual offenses may have statutory distinctions between their internal methods of defining intent or malice that are required. So this is something that people often get wrong. There is no way to statutorily limit or change self-defense law. They can't. Some people said there was a rumor floating around that if they had charged Kyle Rittenhouse with second-degree homicide, for example, that his self-defense defense would not have applied and he would have been convicted. No, self-defense applies. It is a separate tenet of law. It's got its own statute in Wisconsin, and it is not in any way modified or limited by the degree or type of homicide charge that exists.
Right. It was in a different section called privilege. I think where people are getting hung up on that then is that you do have the first degree and second degree have unreasonability change hands, that's internal to the actual elements of that crime.
Right. And that is something that was not adequately explained. And Andrew Branca did explain this on the stream, but it was not adequately explained by the prosecution or the defense during their closing argument. But that's the difference between perfect self-defense, which is the self-defense statute of Wisconsin and common law self-defense being applied to the situation, and then imperfect self-defense, which is those internal statutory elements of the crimes themselves.
You know, that, by the way, the Arbery jury instructions were very good on. It was much better than the Rittenhouse ones. It explained
I thought the Rittenhouse ones were terrible because of the looping, internal and then external for the self-defense. I thought they were virtually unfollowable.
They were contradictory and confusing, and the prosecution missed a chance to play off of that. In Arbery, the judge explained, I think 3 times, this is about justification. Justification applies to all felonies. Here's self-defense. Here's citizen's arrest. Sure. The other reason why we have legal schmiegel, I blame the show Suits, because he's designed to look like he's right off the cast of Suits. And everybody who thinks Suits is real law, one of the worst legal shows ever, thinks that, would say, oh, this guy looks like the guy from Suits. He must be a legal expert.
Look, but all the lawyers on
like a TV lawyer. There's no question there.
All lawyers on Suits were significantly taller than him.
Yeah, sure, that's true.
But you can read the jury instructions themselves and see how the court modified the general rules that apply to self-defense to apply to each of the different charges in this case. It's all written down in relatively plain English, and it's worthwhile. You might be on a jury someday, and you might be faced with similar jury instructions. Now, Wisconsin doesn't have what's called a duty to retreat. In other words, Wisconsin law doesn't require someone whose life is in danger to exercise all opportunities to flee before resorting to deadly force. But jurors can consider whether someone tried to move away from danger as they assess the reasonableness of a self-defense claim. Juries are still allowed to consider whether the defendant had an opportunity to retreat to determine whether or not it was necessary to use deadly force in self-defense. And Wisconsin law doesn't quite go as far as stand your ground states, which remove any consideration of de-escalating or fleeing before resorting to deadly force. However, as we'll talk about later, Wisconsin does have a duty to retreat where the person provokes.
That's not an accurate depiction of stand your ground states either. It doesn't completely obviate the reasonableness aspect of the use of deadly force. And if you have an opportunity to de-escalate, then your use of deadly force may be unreasonable according to a jury. And so this, again, this isn't his fault. And to be very fair to Legal Eagle, he is not a criminal defense attorney. The area of practice that he does do is commercial litigation. And that's fine. But it's one of those other things that people can get wrong, especially if they get a truncated and often prismed, we'll say, view of these tenets of a controversial thing like stand your ground or the castle doctrine. But stand your ground does not mean that there's no duty to de-escalate, or not a duty, but there's no opportunity to de-escalate, and that therefore any force that you use is de facto reasonable. It doesn't work out that way, because at the end of the day, jurors still have to determine if you pointing a gun and pulling a trigger or stabbing someone with a knife was the reasonable act to do. Whether or not you had to retreat is a completely different question to the reasonableness aspect. So he just took stand your ground and moved a little bit farther than what it actually does.
Also, he's about to get this wrong. Duty to retreat in Wisconsin is only triggered for if there's provocation and you use deadly force. It's not triggered in general by provocation. So he's confusing withdrawal with duty to retreat, which are two different things. So you can
he's not going to do that. He's going to wind up reading the provocation statute and talking about how the language about asking you to leave is the same as a duty to retreat.
He's wrong. They're two different things.
I'm just telling you that's what he's going to do.
Yeah, that's what I mean. I mean, you can tell he's going to get it confused, because it can sound confusing to someone who gets their law from the TV show Suits.
To be fair, and I don't know if this is what he's going to do specifically, but when I read the self-defense statute a couple different times, I would mix up this actual privilege aspect and the loss of privilege that's from the Castle Doctrine section of self-defense law, where you get a presumption of acting in self-defense, but you can lose that presumption. But that only takes place within a domicile or a workplace. And it's kind of confusingly listed in the statute. So he may have mixed that up too. And if you don't do a very careful read of the statute, you'll skip over the part where it says this next part only applies to this thing, because it's in the middle of the statute and then it goes back outside of it when it follows up.
Have you guys heard about courts looking at doing flowchart jury instructions? It's actually started to come up in courts.
I think it would be a great move.
Here, this would have benefited from a flowchart, because there's withdrawal, which is one remedy, which is you give good faith, you give notice that you're withdrawing from, like, you start something, and I call it "Give Me 3 Steps" from the Leonard Skinner song. Okay, give me 3 steps. I'm out of here. Sorry, didn't mean to go that way. And that's separate from if you're going to use lethal force after you provoked the attack. You can still use it if you're at imminent risk, but only if you have the duty to retreat. You exhaust.
Yeah, and he's going to skip withdrawal, and I'll tell you why. It's because the jury instructions skipped withdrawal.
Yeah, they did. One quick thing. That's a good note to any lawyers out there who might be doing closing arguments. Build a flow chart. If you're going to use a PowerPoint, put a flow chart up and show people this is how you get here.
unless it would screw you.
Right. And you don't
use
a visual aid. You don't use
grab
anything.
this over here and you put this over there and you stick this here and have some fun. But yes,
in this case, it would have helped. It would have helped Richards a lot if he could have walked them through the whole thing. As far as if there is no provocation, go down this road. If the
flow chart isn't on your side, just intimate that bringing a gun at all lost the right of self-defense.
Yeah,
just suggest that heavily.
You can see why the prosecution didn't want it, but you can see. But it would have also helped Richards, given the way he thinks. Okay, Mark, all you got to do is read flowchart. Then his factual knowledge would have fit into the organization that was pre-built for him.
I think it would have been great.
Here we go.
The attack against them. Now, at common law, a majority of jurisdictions required a duty to retreat before being allowed to engage in deadly force in self-defense. But today, a duty to retreat is required in only a minority of U.S. states.
Yeah, that is not actually a thing, but okay, we'll go on.
Here is a duty to retreat instruction from Massachusetts. Quote, a person cannot lawfully act in self-defense unless he or she has exhausted all other reasonable alternatives before resorting to force. A person may use physical force in self-defense only if he or she could not get out of the situation in some other way that was available and reasonable at the time. The Commonwealth, that is the state of Massachusetts, may prove the defendant did not act in self-defense by proving beyond a reasonable doubt that the defendant resorted to force without using avenues of escape that were reasonably available and which could not have exposed the defendant to further danger. Again, that's the law of Massachusetts, and it's not the law of Wisconsin.
It shouldn't be the law of anywhere, but that's just my opinion.
And it should go without saying that the Kenosha jury was applying the law of Wisconsin at the time. And we'll talk about the implications of this particular aspect of Wisconsin law in a second. But the final nuance of self-defense at issue is that of provocation. A person who provokes an attack cannot claim legal self-defense, but it's more complicated than just that. The Wisconsin law on provocation states, a person who engages in unlawful conduct of a type likely to provoke others to attack him or her, and thereby does provoke an attack, is not entitled to claim the privilege of self-defense against such attack, except when the attack which ensues is of a type causing the person engaging in the unlawful conduct to reasonably believe that he or she is in imminent danger of death or great bodily harm. Okay, so let's break down this law on provocation, which is an exception to the exception of self-defense, which is an exception to the ability to use deadly force against someone. So let's say you engage in unlawful conduct likely to provoke others. Well, then you can't claim self-defense, except that you can if your provocation causes others to use effectively deadly force against you. Now, we'll get back to this in a second, but the law continues. In such a case where the provoked attacker uses deadly force against the provoker, the person engaging in the unlawful conduct is privileged to act in self-defense, but the person is not privileged to resort to the use of force intended or likely to cause death to the person's assailant, unless the person reasonably believes that he or she has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm at the hands of his or her assailant. So here, you only get to use deadly force to resist the deadly force that you provoked if you exercise a duty to retreat.
Yeah, he calls that provision the duty to retreat.
Yeah, and that's not actually true. It's not a duty to retreat. It's exhausting all other avenues to avoid the deadly force, but that doesn't necessarily mean retreat. So I don't know. That's probably nitpicky. I'm being nitpicky.
I think it's pretty close, but your chat already thinks that I'm, just on legal side here.
Well, look, I mean, you were simping for him a little bit ago. You're like, oh, this is a handsome man.
Like I said, what I suggested is that this isn't the worst video in the world.
No,
but,
I'm just kidding.
This is the strong part. I have to warn you.
Okay, here we go.
Law stipulates that the provocateur must attempt every other reasonable option to escape, avoid, or prevent the attack before resorting to deadly force if they were the ones that provoked the secondary attack. Now, we'll talk about the general law of self-defense and whether it applies under the factual circumstances as we know them in a second. But first, I want to talk about the exception of provocation, because a number of people believe that Kyle Rittenhouse provoked the attacks themselves and therefore couldn't use the privilege of self-defense, that by brandishing a firearm or placing himself in the situation, he provoked the attack. Now,
by number of people, he means 1.5 people in the DA's office believe that he provoked it.
No, I think he means his audience. I mean, let's give him the benefit of the doubt here. His constituency believes that to a great extent.
They do.
Wait, he provoked with the whole gun waving, or that he provoked by walking
I'm
down
telling
the
you right
street
now,
here?
there were articles on MSNBC and CBS and everywhere else that said maybe he's provoking by coming and having a gun in open carry.
But
that's
not legal provocation.
A CBS legal analyst said that.
Yes.
Completely false. But a CBS legal analyst on national CBS News at the 6:30 Eastern time hour went on a 7-minute discussion saying exactly that, the complete misapplication of provocation.
All right, first of all, Joe, I think it's very unfair of you to call Kraus 1.5 persons. That was rude. You should not have done that. But second of all, no, I think that's extremely fair, especially given Legal Eagles audience. These are people who are going to.
But he's trying to explain as a matter of law what provocation is. There's nobody who actually believes that him walking down the street as a matter of law is actual provocation.
Oh no, there are a ton of people. There are a ton of people who believe
there are no legal scholars. There are no legal scholars,
right?
Who believe
Well,
that.
I mean, I don't even know that I agree with that. No smart ones, perhaps, but I mean, literally, the article.
No correct one.
Media.
No,
I had a professor from my law school.
CBS's legal analyst said this during the trial. Said during the jury deliberations. Actually said him going there with a gun could be considered provocation by the jury. It was patently false. But that's the degree of legal malpractice that was in the mainstream press.
I agree with that. I mean, I agree with it being malpractice, but that was out there. I think we have to acknowledge that.
And one thing, one thing that he's doing here, and it depends on what he follows up that sentence with, because I did cut him off. To be fair, I cut him off there, but he mentions brandishing. And the reason I wanted to mention that, I don't know how he deals with that, if he addresses the fact that Kyle Rittenhouse did not, under the facts, brandish the weapon. But brandishing, a lot of people believe, because I've seen it on Twitter, that just open carrying a rifle is brandishing. But brandishing is an act that you do with a gun that is a threatening act of pointing or waving a gun in a particular direction at a person with the purpose of causing a threat, to raise apprehension in the other person of imminent danger. So he says brandishing, and a lot of people, and I hope he clears it up, but a lot of people think that because Kyle had a rifle carried on a sling on front of his body, that he was brandishing a weapon. That is not actually true. So I just wanted to point that out, because we're talking about the legal issues here. So let's see if he does clear that up.
3 issues here. First, is there unlawful conduct? Did Kyle Rittenhouse engage in unlawful conduct that could constitute provocation and therefore prevent the defense of self-defense? Well, Judge Schroeder granted defense motions to dismiss the 2 misdemeanor charges against Rittenhouse. I think a lot of people put too much emphasis on those lesser included offenses. Charges were for possessing a dangerous weapon as a minor and a misdemeanor charge for breaking curfew.
I like what he said there.
I agree. That's not a misdemeanor. That's a fine, effectively. I don't think it was a legal misdemeanor.
It was a civil. It was a civil charge.
Yeah,
it's either charge. In Minnesota it'd be called a petty misdemeanor, but in a lot of states it'd be a civil infraction.
It's like a traffic infraction.
Yeah. But I do like that.
I am curious. Can a misdemeanor in Wisconsin serve as a predicate for saying that that's the unlawful act to satisfy that element of provocation?
Yes. In fact, the prosecution made a poor attempt on that. I obviously was not going to talk about this during trial, because no reason to give them any ideas they don't have. But yes, in Wisconsin, they've determined disorderly conduct by itself. If the prosecution had been smart, they would have pursued that. They would have pursued that he was engaged in disorderly conduct, because the courts have already ruled disorderly conduct itself is an unlawful act that constitutes provocation in grounds that negate self-defense. And that would have appealed greatly to his kind of jurors.
Yeah, that could have been really lethal.
He never did.
That could have been really lethal. That's a big blow by the state.
Yes.
But the trick was
Binger was the gift that kept on giving in his own way.
The trick with the unlawful conduct is the following language in provocation. It's unlawful conduct that is likely to provoke and does indeed provoke. So, and I like that Legal Eagle tackled this the appropriate way here. He said, I think people are putting too much emphasis on these 2 charges. Him being a minor in possession of a firearm, they tried to elicit this at trial, but they were unable to find anybody who found it weird or could have identified that he was breaking the law at the time, including the police. And so all of the testimony at trial is people saw Kyle with a rifle. They saw a bunch of other people with a rifle. They assumed he was lawfully carrying, and it kind of went on with their day. So they tried to get some evidence of that provocation from that, but the mere act of carrying something unlawfully that would otherwise be lawful for someone else is not likely to be a provocative act. You
to
have
his
to
credit,
do something.
To his credit, you're going to see Legal actually makes that point. The fact that he's underage does not serve as a greater provocation than if he was 5 years older. And accordingly, it's hard to understand why that would be a basis that now he's entered into the provocation zone. He actually does a very good, fair job of breaking down the fact that he's underage should not be a factor here. So,
all right, here we go.
Arguably, Wisconsin law has an exception that allows minors to possess shotguns and rifles as long as they're not.
It's not
You like that?
arguably.
You like that arguably?
It's not arguably at all. It's
so
the law.
Here's the other problem. So we're going to get into the provocation stuff. I agree with Joe, by the way, that he handles this part well. But what you're going to see is that I think Legal knows that this acquittal is right. He knows it. He's going to explain why it is. But he does have that constituency. And so there's going to be a lot of hand waving at things about what could be provocation, how this might be systemic racism, how all this stuff goes. But, the words of the law are the words of the law. So, you live with the hand that you've built for yourself. But, I think that's why this video comes across as almost bipolar.
Yeah, that arguably was very subtle. Now, arguably, the law says this. And it was like, no, it does say this. And the judge ruled that it said this. But, by the way, that's coming in the update on Dominic Black at the end of this video. Stay tuned.
Short-barreled. But more importantly, provocation requires unlawful conduct of a type likely to provoke others. Now, even if those two lesser-included charges had stuck, they might not have been sufficient to rise to the level of provocation. Mainly,
those are not lesser included. This is the kind of
that
stuff
was
that drives me
terrible.
nuts about legal
terrible.
schmiegel. He gets paid. He takes a legal term. He thinks, oh man, that's a cute little term. Lesser included is a lesser included crime of first-degree murder versus second-degry murder, as an example.
Well, I totally agree with you, by the way. But they're lesser offenses, and they were included in the charging document, right?
Exactly. At least he's not going to say. I've been hearing some lefties say, they determined it was white privilege. They said privilege in the court proceedings. They dismissed with prejudice, so they admitted it was prejudice. this misapplication of legal terminology.
Look,
unbelievable.
You're here to play devil's advocate, but you're not supposed to be Johnny Cochran of the devil, right? Like, you're not supposed to.
Exactly. No, I'm fully in agreement. I'm fully with you.
All right, here we go.
Because Wisconsin is an open carry state. Mere open carry of a firearm is A, not unlawful, and B, possibly not the type likely to lead to provoking others. Now, I'm oversimplifying here. This is a highly fact-specific analysis, but it's not unreasonable that someone might not find that the gun possession, qua gun possession, didn't lead to provocation. Think about it. Is it the possession of the gun that provokes the attack, or is it the possession of a gun by a minor, or possession of a gun that crossed state lines that lead?
I'm sorry, what did he part wrong?
What did he just say?
Gun never crossed state lines, legal schmiegel.
But if it had, no.
No, actually, I believe the gun did cross state lines.
Now,
correct me if I'm wrong, but I believe
outside of Wisconsin.
No, I believe.
Oh, you mean when he afterwards?
Yes, afterwards he did, and I think this might actually be somewhat important for people who have a defamation claim coming their way about that crossing state lines, because he did, if I remember right, bring that gun back into Antioch with him when he turned himself into the police, and so therefore the gun may have in fact been brought across state lines by Kyle Rittenhouse.
Afterwards.
It depends on whether he might not still have been in possession of the gun at that point. If he puts it down in the car and someone else owns the car, it's not his gun. He's not in possession of it crossing state lines. He's not the one who broke the law.
Though I have no doubt that Legal Schmiegel was thinking about the media lie. That he brought it across.
Obviously.
All he said was, Robert, if it had, it wouldn't be provocative.
You guys are so nitpicky. Gosh.
Okay. Here we go.
I agree with you with the implication. I really do.
someone provoking an attack. If you think it's the former, well, that's not illegal, and the latter probably doesn't provoke an attack. No one says, oh, the reason I'm attacking you is that you're a minor with a firearm, not that you're carrying a firearm in the first place. And additionally, breaking curfew probably couldn't be the requisite predicate because lots of people were breaking curfew and it wasn't leading to mass provocation. Now, it's a closer call when you consider Rittenhouse admitted that he pointed his gun at the victims and claimed that when he was pointing his gun, it wasn't a dangerous provocation.
Patently false.
When did he say he did that?
He never admitted that. In fact, he just contested that.
He's going off of the state's argument that his sarcastic comment to Yellow Pants Guy was proof that he did, in fact, point the gun at Yellow Pants Guy. But he actually testified on stand that he did not point the gun at Yellow Pants Guy, that he merely made a sarcastic comment, and the state refused to accept his sarcasm explanation and refused to believe him. Unfortunately for the state, you don't get to enter into into evidence your refusal to accept the evidence that actually exists.
The other thing actually, there was one moment he admitted to when he was pressed by Binger about that confrontation with Grosskreutz, and when he was sitting on the gun during that moment that Grosskreutz allegedly believed he was re-racking, which he clearly was not re-racking. So Binger kept pushing Kyle about whether or not his gun was pointed at Gage's feet, and he showed him this one picture from a weird angle that it looks like it could have been, whereas if you look from the other angle, it actually looks as if his gun was not pointing at Gage's feet, but at the sidewalk. And I was very irate that Mark Richards, classic Mark Richards, allowed him to badger him until he finally said, fine, I had the gun pointed at Gage's feet, when I don't believe, in fact, he had. But that means that he admitted to waving the gun at one of these people who he's being charged with provoking. So in that sense, there was an admission from Kyle.
Yeah, but it's not what Legal Schmiegel's referencing. Legal Schmiegel's thinking he was pointing the guns at his victims all night long. Because he's just taking a highlight from the prosecution, and that never happened. And because Yellow Pants Man was never shot at that night. The other thing is, to the credit of the panel, by the way, Dark Crypto and others, that information got to Richards about when he's saying you pointed the gun, Yellow Pants Man is pointing the gun down, not at.
Yeah.
And notice Richards made that argument in close. He had not made that point before. He had not even prepped Kyle to make that point when the question was asked about sarcasm, because Kyle should have been prepared to say, no, look at him. He's saying I was pointing, the gun was down. He just means he's talking about me carrying the gun. And I'm just like, yeah, okay, whatever you're saying, fine. But because of the legal panel's work and that Crypto and other people's work got to them, it's still weird to say thanks to Darth Crypto for a criminal case for help. But that's why Richards, in my view, knew about it to make that argument and close that Kyle never, that even the Yellow Pants Man is not saying he pointed the gun at anybody.
Darth Crypto said that on my stream, and that's why I take credit for freeing Kyle Rittenhouse. You're all very welcome.
There you go.
Yeah. And we know that they were watching some level of social media because they also use specifically Posobic's tweet, and I don't know where that originated, that Kyle would have to be left-handed or holding the gun left-handed to do what they said he was doing with the gun.
They did, that did get to them fast. Yeah.
Yeah.
Yeah. It was Darth Crypto and other people was the lead on that. There were several other people. But Posobic putting it out, the being on Good Logic and the panel's discussion. I know that, in fact, the defense team was watching a good bit of the panel's discussions and reviews.
Do you think it pained Mark Richards to be watching Posobic's Twitter feed?
Yeah. It was fed to him. His associate was good. Wisco, I think that's her last name.
Yes.
She was very thorough. She was the one who handled all that. She
was also great. Like that's one thing she deserves so much praise for just dismantling and unmanning Krause. When he tried to bring up the nonsense about the drone, she just was like, nope, not how that works. Here's the file name. Here's the timestamp. It was like, oh God, I'm drowning in evidence. This is glorious. But
that's great.
Yeah, I think they would have benefited from using her more. And to be honest with you, throughout in selective witnesses and some other people. I think she would have known how to object better than maybe Richards and Corey. But she was very on top of it. And my experience with her was Richards relied almost exclusively totally upon her for like documents, discovery, information, evidence, etc. So I know she was following a good bit of the commentary, and that was great because a lot of points that would have got missed in close were Richard's made, in my view, thanks to other people contributing to it in the court of public opinion.
I look, and she definitely did a great job. The one failing of Wisco, though, is that she never created a neon sign with the word "object" on it that she should hold up to Richard and Shirafisi. So that I
like
knock
a
her
Wile
on, but in all other
Coyote.
respects, she was great.
Like a Wile E. Coyote yipe sign, but it just says "object" every time. Okay, here we go.
Now, you could argue that pointing your gun at someone is assault or misuse of a firearm, but that probably doesn't work.
I mean, pointing your gun at someone is assault. Let's be very clear about that. You can't argue that pointing your gun at someone is assault. If you point your gun at someone and they didn't ask you to do it, that is assault. Do not do that. Yeah. You're not going to argue your way out of that one very well. Alec.
You know what? On behalf of all commercial litigation attorneys out there, cut them some slack on that one, okay? We would say arguably. That's how we say it. It's arguably.
By the way, that's one of the key aggravated assault charges in Arbery. There is him pointing the gun. In fact, it's probably her most, like, they never did hit him with a truck. They never did say the N-word over his body. All that turned out to be media lies. But I thought the best argument prosecution made in close was highlighting they thought he pointed that McMichael pointed the gun at Arbery twice, maybe even more than that. But it was their main. It's the evidence that people don't, you point a gun at someone, that is assault under, and if you cause someone to have fear of imminent bodily harm, that is assault. And so but you knew he was going to get, he had so much stuff wrong. Even his best video has like a dozen errors.
Someone in the chat said, not in Wisconsin. Look, there's common law assault and there's statutory assault. Common law assault is when you put someone in apprehension of imminent danger, and pointing your gun at them is going to be common law assault pretty much every time. So here we go.
If the reason that you're pointing the gun at someone in the first place is for the purposes of self-defense. And in fact, there are Wisconsin cases to this effect. Though,
sorry, I'm not going to stop this every 2 seconds, but even if you're pointing your gun at someone for the purposes of self-defense, that is still assault, and the self-defense is your affirmative defense to the crime of assault, which you are admitting to. When you make an affirmative defense, you're saying, yes, I meet the elements of this crime. However, I have an affirmative defense which allows justification of my commission of these elements. So
how did this guy pass substantive criminal law?
Because he might not have had to.
If you said these kind of things in an exam answer, in aggregate, it would be fail, because you're getting basic legal concepts, the difference between a affirmative defense privilege exception that the government still has to prove beyond a reasonable doubt versus what is a constitutive elements of the offense themselves, which is what he's
criminal defense lawyers are such snobs about criminal law. Snobs about it.
Look, and I'm sure if I talked about commercial litigation, Legal Eagle would have a lot to say about the things that I got wrong too.
He's not very bright there.
Come on. Let's talk about contracts of adhesion. Let's go. That's drama, baby.
He would get half that stuff wrong too.
God, please, can we, as a society, talk about adhesion contracts and just how garbage they are? No, Jonathan Lindsay said that's being nitpicky. Yes, it is, but it's really important to notice, or to again,
law. It's like people tell me those are loopholes. No, that's called the Constitution.
Right. If you're a criminal defense, or if you're taking criminal defense law in your college class, in your law school class, and you write down that pointing your gun is not an assault if it's self-defense, you will get docked points on things like that. And if you write that in a brief, the judge will start looking at the other paragraphs that you wrote a little bit closer. Don't do it. Don't do it.
It's what happens when your law books are just pixels on a green screen.
Okay, here we go.
On the other hand, Wisconsin courts have an interesting history in analyzing the provocation exception. For example, in a 1975 Wisconsin Supreme Court case, the court held that a defendant was a provocateur by virtue of openly bringing a gun into a tavern. The Wisconsin Supreme Court held, quote, the defendant himself testified that after being slapped, he went out to his car, bought a shotgun, loaded it, and returned to the tavern.
This is a really interesting case, by the way. I read through it during the trial because it was brought up at trial. So here, let's let him keep going.
As he was entering the tavern, he was grabbed from the side by someone and he pushed that person away. He saw Freddie Jones start toward him and he started shooting. He stopped after 4 shots and after Jones was out of sight. The defense
Freddie Jones came towards me, so I just started blasting. Sorry.
defendant requests that the court grant him a new trial in the interest of justice. We find no merit to this contention. When the defendant left the tavern, got his shotgun out of the trunk, loaded it, and returned to the tavern, he became the provoker. Additionally, there's an 1883 Wisconsin Supreme Court.
So that's wildly distinguishable. I mean, like wildly distinguishable. And it's put here in this video to suggest that the provocation question is closer than it is with respect to Kyle Rittenhouse. And so that's why I object to it. It's one of the big errors, I think, in this video, because you can't just skip ahead. You have to explain to your lay audience that actually not being armed, going and getting armed after essentially a conflict has started is wildly different than what Kyle did.
It's not only distinguishable from Kyle Rittenhouse's case, it's distinguishable from how he described the case that he was going to read. Yep. Right. He said by merely being armed, by bringing a firearm openly into a place, it was considered provocation. It's like he wasn't merely bringing a firearm openly into a place. He went to go get a firearm in response to a conflict that you mentioned was already started. And presumably when you leave that conflict, it's already over, because he was able to get away from the conflict, go to his car, have time to escape or do any reasonable action other than re-enter that bar with a firearm and just start blasting. It's wildly disparate. Okay, so now we've got State versus Clifford.
You should give him credit, though, that, you know, he managed to find a case within the last 140 years to the one that's closest on point to going where he wants to go is only like 140 years ago. You know, it's not like he wants to go back 200 years. So what do you want from him? That's the closest he can find.
And I love the quote he pulls from it. If one points a loaded gun at another and the other grapples with him to prevent the shooting and is shot, it is murder. And again, none of these facts are in evidence except maybe, and it shouldn't be in evidence, but maybe the idea that Kyle pointed his gun at Zeminski, which is still distinguishable from this case because the other would be the other or the another that he pointed the gun at. So that would still be distinguishable, but let's see how he treats it.
Case it says, quote, if one points a loaded gun at another and the other grapples with him to prevent the shooting and is shot, it is murder. And this is especially important in the context of the Rittenhouse shooting. Even Rittenhouse's testimony seems to indicate that Rosenbaum didn't lunge at Rittenhouse until he raised his gun at Rosenbaum, and that the reason, or at least one of the reasons that Kyle Rittenhouse shot Rosenbaum is that he feared that Rosenbaum would take his gun away and use it against him.
Yeah, that's the right facial look right there.
Okay. He skipped a portion in his it's clear on camera, but he skipped a portion in which Kyle Rittenhouse raises a gun at Joseph Rosenbaum as he is already running from the encounter because he is being chased by someone and seems to believe that he might be in danger from this person at the time that he was running.
Not once testified to that fact. No, it's the question of, well, if you, depending on when you start the time frame, anybody can look like a provoker if you slice it in a specific way.
Yeah. Yeah. If you slice it at the point where he's like raising the gun, so he's already turned around, his momentum in that direction is basically halted. That's sure. You can do that. And this is a pretty big mischaracterization.
It's a lack of context completely.
And if you want lack of context, let's also just like point out he kind of omits anything about Zeminski firing a gun behind him. So while Kyle is running away from Joseph Rosenbaum, he actually hears a gunshot coming from behind him in the direction of Rosenbaum. And the reason he's turning back and quote unquote provoking Rosenbaum is because he thinks he's being fired on. So when you leave out the whole Zeminski firing a shot in the air to sort of, you know, alarm Kyle, it changes the entire nature of this little running scene that he shows here. But I don't think
he'll mention it later. I mean, he gets as close as possible to saying this is right in this video, but it's so messy in terms of what the purpose of your communication with this video is, to talk to a lay audience about how this happened. It does this kind of weird looping thing of lacking context and then redescribing it, and then lacking context and then redescribing it. And I just find that so messy for educational purposes that it bugs me there, even though I think a lot of this arrives at the appropriate place.
It's a messy for educational purposes, but it's beneficial for his purposes, which is the
like I said, I think he's CYA.
He wants to make it blurry. He wants to make it blurry.
CYA here for the MSNBC viewership. I mean, it is.
Yeah. And frankly, for the YouTube promotion, or like the YouTube algorithmic promotion.
I can see that as well.
Yeah. That's not a bad thing, right? Like making videos. You gotta respect it. He's good at it. Here we go.
And we'll talk about that in a second. And obviously you'd have to run a provocation analysis in every instance where Kyle Rittenhouse used deadly force. It's not a one size fits all. You have to.
Actually, you don't. You can. That's one way to approach the problem, but you could simply suggest that the initial provocation would then extend automatically to the subsequent events. And this is a point that he could take more towards his side, that if he had provoked that, and I will firmly argue that if they could have shown that he provoked the encounter with Rosenbaum, they could have gotten a jury to believe that that provocation was sufficient to show that his state of mind was not that of a self-defender, but of an active shooter, and they could have gotten him convicted on the other charges. So
yeah, again, the prosecution did a poor job of actually arguing that in close.
Yes. Yeah, and we know that they did a poor job of arguing that because we saw the order of operations of the final judgments that they made where they found Rosenbaum to be the last one, whereas anyone looking at the facts and ignoring the closing arguments would say the jury really needs to hammer out the Rosenbaum issue first. And if the state had made as part of their argument, look, if you can find that he provoked the attack against Joseph Rosenbaum, then you can carry the idea that his state of mind was that of a shooter, not of a defender, throughout the remaining encounters. This is a man out there to go and shoot people and cause carnage on the streets of Kenosha, not a guy who got wrapped up in some bogus claim of self-defense that he constructed after the fact. And they should have made that sort of argument as the state. I'm glad they didn't, but they should have.
Absolutely. It's one of the benefits to mid-tier state lawyers, where they're politically ambitious but have mid-level skill sets and mid-level experience, is a binger. He's good at being swarmy, good at being sleazy, not bad at telling a story, but he's not skilled enough to know how to tell that. Like if, Kyle could have faced a lot worse prosecutors that would have done a real number on him, that would have put him at much more risk and exposure given his defense lawyers' limits. But
why they didn't charge him with disorderly conduct? Why they didn't charge him with a misdemeanor assault or something, or maybe just another disorderly conduct against Yellow Pants guy? If they can elicit the type of testimony that they plan to elicit, they had other charges they could have brought against him.
Well,
would have
they could have even argued some version of felony murder, like they're doing in Arbery. In other words, they could allege it was aggravated assault. The first felony was all part of a continuation. He's responsible for everything there. You lose self-defense, a felony murder, etc.
Yeah.
And that might have been easier. I mean, the provocation theory only came up halfway through, right? I mean,
to look at
I think they always planned on doing it, but their evidence kept falling apart for more and more aspects of it.
I nailed the pause face on this one. That's
that's a beautiful one. Yes. Should save that one. That should be the use that for the thumbnail, whatever you call that. Yeah, the
I'll just clip that.
Exactly.
Okay, here we go. Eagle Loan says stop helping the PAs. That there's no help. He's done. There's no they can't.
I wouldn't be talking about this if there was any chance of pre-prosecution. That's finished.
Yeah.
Kyle cannot be criminally prosecuted, period, again.
No. And
they would talk about federal charges, but I can't imagine
that. The FBI already cleared him. There's no federal charges to be brought. The only way he gets into federal trouble is if there's some tax issue with the money because of what his current advisor, David Hancock, is trying to do with the bail funds. But there's no federal risk for what happened in Kenosha. The FBI's already cleared him. Eastern District of Wisconsin's already said no.
And even if they tried to bring some charge that was unrelated to the initial charges based on the facts of that night, they would have a lot of trouble doing that because they've already raised these facts as sort of the nexus of the totality of the charges, and they've already litigated the issue. So
double jeopardy covers any charge that could have been brought related to these matters.
Right.
As a prosecutor, you don't get to like charge half and then come back later and charge another half. Double jeopardy attaches and covers it entirely. That's why like conspiracy. You almost want a conspiracy charge in some cases, because what can happen is anything relates to that conspiracy, you have double jeopardy if you get acquitted of it. So they made that mistake in some cases I've dealt with. We got acquittals on the conspiracy charge. They wanted to look at other things, but their conspiracy was covered like 12 years. It meant every other charge they could have brought in those 12 years they couldn't bring. It was done because of the acquittals on conspiracy. So Kyle's in the clear on criminal cases. He has no risk anymore.
What about the exception of leftists are really, really upset by this verdict? that exception to double jeopardy, because I remember reading on Twitter that's an exception to the double jeopardy.
It's not a strong one. It's not a strong argument, but they may make.
Well, you know what they're doing. I mean, which I will see. Maybe Legal doesn't go there, but good numbers of the left in the legal professional community is using Rittenhouse's case to argue that they need to change self-defense laws in America. That's where they're going to go.
Which is
it's so damaging to the black community, because the black community relies on self-defense laws and a broader and broader self-defense laws, because they're the ones who are facing violent situations. The vast majority of black community are law-abiding folk, and they're the ones who need to have broad self-defense laws. They don't have to worry, like, wait, do I have to get a yardstick? Is he close enough that I can shoot this guy? They need to have broad interpretations of self-defense more than anyone. So if you care about the black community, you're not trying to cut back on and slash away self-defense laws.
You know, they say that like a progressive tax is progressive and a flat tax is regressive, because regressive things disproportionately impact the lower economic class. Self-defense is a regressive benefit in the fact that it benefits disproportionately lower economic classes. Higher economic classes can afford private security. They can afford to live on their own distinct properties. They can, like me, I live on 8 acres out in the middle of nowhere. I'm not dealing with the same issues as someone who lives in an apartment building in downtown Detroit, right? And so self-defense is much more important for someone who's in an urban dense area than it is for someone who's in a rural spread out light residential, if we want to use SimCity 2000 terms. But I want to really quickly read this super chat. Steve Sursosimo says 15,000 current watchers at 1:30 a.m. Eastern. A lot of people appreciate you as much as I do. Hey, thank you to everybody who's here. I know it's late. The late show is fantastic, and and I appreciate you guys being here. And again, daily shows start tomorrow at 1 p.m. Central Time. But we're gonna get back to this, and all of the super chats that come in today, I will read them during the show. But I want to make sure and respect my panelists' time as much as possible on the Legal video. So here we go.
Every instance individually. And if the jury had found that there was nothing unlawful that led to provocation, or if there were illegal things going on, those weren't the ones that were leading to the provocation, their analysis to this exception probably would have ended there, and they would have found that provocation didn't apply. It's only where there is provocation do we get to the next questions. But assuming that that first hurdle had been met, you get to the next one, imminent danger. Even when someone provokes an attack, they can regain the right to use deadly force where that person reasonably believes that he is in imminent danger of death or great bodily harm, and he may lawfully act in self-defense. Since this is essentially the same standard as self-defense in the first instance, given that the jury must have thought Kyle Rittenhouse acted in self-defense, they probably would have found that this exception to the exception applied, even if they got to this question. And so if they got over those two first hurdles, they then would have had to get over the third hurdle, which is the duty to retreat. That's the final issue in terms of whether provocation can apply. And
it's actually not the final issue. The duty to retreat is one of two possible final issues. And this was the jury instruction that was not included. The duty to retreat and the ability to regain upon retreat and communication of your desire to disengage from the conflict was not the jury instruction that was included. The other jury instruction is that if you have exhausted all reasonable means to of retreat, then you no longer have a duty to retreat at all. That means that you can do that prior to retreating. So I don't like the phrasing of it as duty to retreat, because if your back is against the wall, you don't have a duty to try and find a way through the wall. But that's probably nitpicky.
Yeah, I like to call this the Leonard Skinner "Give me 3 steps" rule. Which, like, sorry, just kidding. I was doing my best Robert Barnes there. So
yeah.
To somebody in the chat who's asking who the girl was crying, that's Kyle's kid sister, who was the girlfriend of Dominic Black when the jury scene.
And the
girl
chat
behind
is
him with dark hair.
And the chat is not allowed to make any simpery comments about her.
Oh,
She's
yeah, that's
16.
probably why the chat was. Oh, yeah. I have to remember the mindset of the Ricady chat.
No, and they
look. They have
sorry,
legal
guys.
mics on, so here come the Sims.
No, they may not know about it, but there are people who should know about that, who have made comments about her attractiveness. One, not really appropriate during a murder trial. 2, she's 16, and you should go ahead and check that out before publicly making statements about how hot the 16-year-old is, especially when you're north of 30. You
Wait,
weirdo.
you're saying I'm 16?
No, Kyle's sister.
Wow.
It's
Way
not
to
always
make it all
about
about you,
Legal
Legal
Bites.
Bites.
Just
Way to
kidding.
make it all about you.
Though I will say, Kenosha's female cops are disproportionately good looking.
Don't talk about Officer Bay that way, Barnes. Officer Bay belongs to this chat. You can't have her. Okay. Welcome, Legal Bites. Thank you for joining us. We're in the middle of this video, and we're still going. I keep getting good pause faces on Legal Eagle here, but
he is to head into the stormy waters.
Yes, he is.
Ooh,
he's
boy.
about halfway through, and from what I heard, his steam runs out. They have to switch from coal to garbage or whatever, and it just doesn't burn as bright. But here we go.
Assuming the first 2 hurdles are met. The third clause says that the person who provokes the attack cannot use or threaten force unless he believes that he has exhausted all other opportunities to escape. If the jury got to this question, they could have felt that he had no choice under the circumstances. We don't know, and one of the prior issues might have precluded even getting to this question. But if the jury did reach this question, then they felt that Kyle Rittenhouse either had no opportunity to escape or had exhausted all of those opportunities. If that's the case,
real quick, just a bit of legal education on here. When you're the duty to escape is exhausted under the law when your quote unquote back is to the wall. That is a term from the Supreme Court. Back is to the of I think either several states or maybe even the federal Supreme Court. But your back to the wall is the term that they use, and many courts have found that when you're on the ground, automatically your back is to the wall, because the wall is just now horizontal. And so that's not an issue with Legal Eagle. This is just a point of education. Your back is to the wall when you are no longer able to retreat, not when you're literally on a wall. You can be on the ground.
And you could see somewhat how he's lost the plot here insofar as we're now like 3 hypotheticals in as to what he has to be imagining the jury is thinking. So there's a lot of mays and shoulds and coulds and cans. And even he knows that because we don't have any information about whether the jury reached any of this. So he's guessing on all of it. And it becomes a problem because by assuming that there is a provocation even in play, he's telling a story about how the jury arrived at an acquittal that in all likelihood isn't accurate at all, but we couldn't possibly know whether it's accurate.
Yeah, it's very possible. And I would even argue likely that the jury looked at the video from the drone and said, I don't see him raise the gun. I know that they've said it.
I don't see any other acts of provocation. I mean,
yeah. And so then the provocation argument is entirely a red herring that the media has latched onto very, very heavily. But he's at Inception levels right now. You got to wonder if in his mind, like time is moving really slowly or whatever, because he's 3 layers deep, and that's very dangerous.
And
you can tell he's struggling with it.
The thing about his analysis of provocation is like he actually I was actually kind of starting to agree with him on provocation, where he's like, I mean, there actually isn't that much there showing that that he was provoking anyone, because he was able to, walk around with his rifle like anybody else. A bunch of other people had guns there, and in an open carry state, just walking around with it isn't enough. And so, but then he then is like, well, assuming that provocation was at play, like assuming that they did find provocation, like,
Let's go
no,
another
I'm
layer.
sorry. Like if your analysis is that there probably isn't much evidence here for them to find provocation, you should probably move forward saying probably there wasn't provocation. So let's analyze it without it. You can then extend it and then say, okay, but let's say they did find provocation. Here's some ways that they could reach this verdict.
Assuming he stabbed Rosenbaum in the leg right before he ran up there, when they found that, then they might say, okay, what's his new duty now at this point?
Well, Rosenbaum communicated.
Kyle says, "Come at me, bro." Yeah, I mean, yeah.
let's go.
Yeah.
Look, what Kyle said was, "I heard what you did to those kids," and Rosenbaum said, "No, I've actually reformed and joined a convent. I'm now a nun." And Kyle said, "No way, you're only a nun for access to the children." That's what happened. That's very provocative.
Oh my goodness.
Did you guys also go over the fact that he just completely blew past the threat by Rosenbaum? Like, didn't even mention it.
Well, I don't know. We got pie, right? We're talking about lack of context, and we're not going to see anything about Rosenbaum in this video. I will tell you that right now.
I got 12 minutes left for him to bring up the threat.
I'm going to stay awake, Nick. I mean, we're going
Iraq
at every frame of pause levels here.
He's finishing the R in his Iraq. He did the issue. He's finishing the rules. He's about to come to the application.
He is finishing. See, this is when we talk about the educational purpose here, and then I'll stop and we can watch the video. You're talking to a lay audience ostensibly for the purpose of explaining how this happened, that they don't understand, that this is a grave injustice. That's his audience. And how did this happen? So going down for 3 minutes or whatever, a theoretical pipeline of what provocation analysis could have been, when the educational component is probably they didn't find it, which negates the rest of all of this, is what you should tell your people. That's where I have a problem. He tries to have his cake and eat it too throughout this video. I understand why he did it. I am sympathetic to that, but it creates a major problem with actually educating your audience.
If he has his cake and eats it too, he won't fit in these slim cut suits very long. But here we go.
Whether Wisconsin had a general duty to retreat might not have changed the overall outcome here anyway. Anyone who says that this is a simple case of self-defense or that it's cut and dry is definitely wrong.
Objection.
Wrong. I say it is.
Wrong.
I say it is.
So here, okay. So I want to plug my Twitter for just a moment here. You can go to @Hoglaw. You can see me talking about this video, and I talk about it with Legal Eagle. He comes on. He puts 20 tweets on my thread talking about this. And what he's going to get to in the second half is this notion that actually you can see it as murder or self-defense, depending. And I say that's the simplest of self-defense cases. Let's assume that you're exactly right in that analysis. You're not anywhere near proving something beyond a reasonable doubt at that point in time. And he knows that. He acknowledges it. He'll acknowledge it at the end of this video. But he wants to be on the side of saying that this isn't easy, when from a legal perspective, even he in this video all but says, yeah, it's easy. You can reasonably see someone is acting in self-defense here. You can't possibly win with a prosecution on that behalf.
The other thing to note about this is, my Discord, I was talking to my Discord today as I was driving home from the Twin Cities, and they mentioned that within minutes of this video going live, he had a pinned comment about his walkbacks. There are a couple walkbacks that he did from the video in the pinned comments, clarifying some of the things that he was talking about. So what my opinion is, based on the production value of Legal Eagle's videos, I think they have a practice where he recorded this, it went to an editor, and probably it probably went to an editor prior to some of the other stuff maybe coming to light or whatever. I'm not sure exactly what the timeline is, but as he had time to think about what he said in the video, he was already ready to make those sort of comments. But editing the video would have been really difficult. He would have to get the same suit. He'd have to set the green screen back up. All of that's a big pain. But
he did this after the verdict came out. He shot this after the verdict came out.
Yeah, but
so
I'm
he
saying
saw everything. He saw all the evidence. He saw all the arguments. He saw the level of provocation that was proven or attempt to be proven by the state. So I can't give him that pass here because he had to have shot this sometime between last Friday and today.
I just
Again,
wanted to go
he
on
knows the
record that
acquittal is
you are more
appropriate.
hostile to legal than me because I'm a gentleman. I think he should come on my stream so I can tell him how I really feel. No, that would be great.
That would be great.
Let's see if
I invited him onto my channel and he hasn't responded.
let's see if he has any chat text history with Fluffer Boy.
Oh,
Ooh, that would be really interesting. Yeah, we'll depose the deposition of legal. Isn't it true that you emailed Flufferboy 2004 on the date of November 22nd and said, "Hey, bro, did you screw this thing up? I thought we had it in the bag." Tall Skinny Geek says, after a brief review, Wisconsin's age of consent is 18, and the closest thing they have to a Romeo and Juliet law is very narrow. Is Dominic Black at risk here? Chat would be, but we act like 12-year-olds, so reasonable doubt exists. I don't know the ages of Dominic and Kyle's sister when they were dating. I have no idea. Not going to get into that. I actually don't know. No, yeah, it was Mackenzie or whatever that he was dating. But that leads to another assumption that intercourse occurred and all of that stuff. So we're not going to get into that because we don't have any details on it. And you are a disgusting individual for saying it. I kid. Oh my goodness. What the hell is happening here? We've got all this. We've got all this law coming in here. What's up, Kurt?
So what bullshit's going on over here?
Oh, here we go. There we go.
You know
there
what?
we go.
You have to keep quiet, good sir. I haven't watched this video yet.
He
did
a whole deep dive.
I
on
tell
it.
you what, I have to tell you what. In the back half, legal, really, he pulls it together. It's, it's wonderful legal analysis. A little shaky in the first half, but the back half is where it's all at. You're in for
like
treat.
the judge in Kenosha. I don't believe you on civil law.
I don't believe you.
Okay, well let's get into that back half, which is something that Binger says quite often.
But so far, we've talked about the exception to the exception, that is provocation. Let's now talk about whether the original exception, self-defense, applied or could reasonably have applied in this particular case. Let's talk about the facts as we know them from the trial. Now, warning, these videos are graphic, but let's talk about what the relatively uncontested testimony and...
Uncivil.
Yes.
I need your help.
As always, what can I do?
You provided a disclaimer to your chat. And now that you're here, I need you to provide a disclaimer to my chat about this video. Uncivil just gave it, Legal Eagle just gave us a trigger warning. I saw your trigger warning on your video.
Yes.
So can you please?
It's a little late for that at this point, though, isn't it?
Better late than never. I need your help.
Okay. Content warning. Nick's stream may include images and sounds of Legal Eagle.
Thank you. Look, I apologize for my negligent omission of the content warning, but hopefully you've received an email version of the updated terms of service, and now you are on notice and everything's fine. Back into it.
And these videos shows. Rittenhouse and his friend Dominic Black testified that they went to Kenosha to protect a car dealership called CarSource. The two owners of the dealership told jurors that they never asked anyone to protect CarSource.
He called that relatively uncontested, by the way.
Yeah, which is, I mean, either something is
all the
contested
contested
or it's not. You can't have relatively uncontested.
It's relatively uncontested.
Like it's either contested or it's not.
Wait, so we've got all cops are bad. Is that a PCAB? What's PCAB on the van there?
Oh,
Or is that supposed to be an A, but it's sloppy?
I think it's supposed to be an A.
Pretty cops are bad. They really hate Officer Bay. Very rude. Okay, let's go.
During the protest, a small group of 8 to 9 people were gathered at the dealership.
He says 8 to 9, but Corey Washington, who was there, says 24. I just want to point that out.
Kyle Rittenhouse that night was separated from the rest of his group and jogged towards one of the CarSource parking lots. Kyle Rittenhouse apparently sees Joshua Zeminski is nearby, armed with a pistol. Rittenhouse continues to run towards CarSource. Rosenbaum chases Kyle Rittenhouse. Rosenbaum throws a plastic bag behind Kyle Rittenhouse, which lands on the ground. A shot is fired from someone else about 100 feet away.
No,
Joshua
not 100
Zeminski.
feet. Not 100 feet. Zeminski fired it. Zeminski there is like 4 car lengths away. I'm sorry. Whatever.
That's a weird one for him to mitigate. Like, it's not a disputed fact that Joshua Zeminski is the one who fired that gun.
Right.
And that doesn't weaken his position in any way to say that. In fact, it may strengthen his position. So
no, because it was coming
No,
from
it
Zeminski.
doesn't.
Yeah, it was coming from Zeminski. Then Kyle's justified in turning back with the gun and waving in the direction of Rosenbaum and Zeminski.
Well,
maybe.
So
and
he's
also,
coming
and
from
also
a different
saying
direction.
that
He has
it's
no justification.
saying that it's 100 feet away. I mean, first of all, I don't think that's accurate. And second of all, like when you just kind of say that generically, you kind of just toss that out. That just sounds like, oh, like someone down the road like randomly shot a gun. When
Yeah.
it's like, no, it came from behind him as he was running away from this man. Like that's an important factor in this whole scene for Kyle's state of mind here.
Yes.
It is. And by the way, this is a good time to mention that all of the panelists' links are in the description. Make sure you go check them out, subscribe to them. And by the way, Richard, congrats on getting to 50K subscribers today.
Yeah.
Well,
Nice.
yeah, no, I think I owe you a thanks. Thank you for retweeting that. I think a lot of people on this did. So that's very kind of
I'm
you.
a
And
hair's
yes,
breadth away myself
it's
now. I'll chase you
50,000
down.
50,000 2 days before the 3rd anniversary of virtual legality. So I'm very thankful.
You deserve it,
That's
man. You produce a
awesome. That's
quality
awesome.
product.
Not only
100%.
quality, he produces quality and quantity. It's like a
Dude.
double whammy.
And speed.
We've had
Yeah.
a good week. Unfortunately, Activision Blizzard keeps giving us topics, so we got to cover them as much as possible.
All right. And enough shilling, even though I started it. Let's get back to the video.
Kyle Rittenhouse turns around and stops as he gets to some parked cars and shoots the unarmed Rosenbaum 4 times in quick succession, once in the back.
Oh my God! Unarmed, once in the back.
Yeah.
Just stop it.
Yeah,
Just stop it.
that is a little, again.
Leaves out the fact that, well, I mean, he mentions at some point that Rosenbaum
Later
lunged at him, but here it's an important point while you're reciting the fact. It's an important point that he turned, he looked at him, Rosenbaum lunged at him, he reached for the gun, and in fact, his hand was at the gun, if not on the gun.
And when you say once in the back,
information.
And really important is when you say once in the back, it's implying he's standing and shooting straight down from his back through his nipples, whereas he's actually shooting. That's what it sounds like. You know, he's standing over him. He's down already. I know he's down. I'm just going to put one extra one in this guy just to make sure he's never going to be a threat to me.
I'd actually argue it's even worse if you don't know the actual context, even if you can't see it on the video. It sounds like it's his literal back. He's not even approaching him.
It was really surprising to the baby that that Legal Eagle was, or that Joseph Rosenbaum was nursing when the bullet came through the back and through the nipple, and the baby had to chew on the bullet. Very, very, very awkward. No, am I mistaken, or he actually gets into the nature of unarmed self-defense at some point in this, doesn't he?
He does mention the fact that they were unarmed and not using deadly force. So that was great. That was a pause.
He adds an editorial comment specifically saying that there was not deadly force facing Kyle.
Yeah.
In the real back half of this video, he has a number of opinions that are thrown in kind of helter skelter.
Rosenbaum, Huber, and arguably Huber. I'm like, okay.
Look, I love when I drop a male breastfeeding joke that involves a baby consuming a bullet through a nipple in the chat, and it takes like 20 seconds for them to catch up to that. Oh God,
I will never mention a man's nipple on your stream ever again.
I mean, maybe not any nipple, perhaps.
Look, hey,
hashtag
can we say that? Not all nipples. Nope, we cannot do that. There is no nipple ban in this chat. Okay, here we go.
Is away from the scene. A loose crowd starts to follow Kyle Rittenhouse. Rittenhouse falls to the ground, sits upright, and points his gun at one person.
Did he skip the part where he got hit in the back of the head and hit with a skateboard? Because I seem to
describe it as tripping.
He tripped. Yeah, he fell. He's a clumsy kid. He's a clumsy kid. And
it's not a mob. It's a loose crowd that's following him.
Right.
It's preposterous.
That's insane.
Kid. I'd like to see you do better with the adrenaline going at 1,000 miles an hour in your brain.
If you don't want to use the word mob, you know, I can see somebody actually wanting to be neutral, not wanting to call it a mob. You could say it's a group of people that are following him or something like that. But
it'd be more accurate
in
to say
context with everything that
chasing and
we've seen
trying
so
to-
far.
I mean, you could try to claim trying to capture him if you wanted to use the little Binger language,
Right.
but they're chasing him, and it's a mob.
Yeah.
Maybe they do or don't have a rope. Maybe they're
Yeah.
justified or not justified in having a rope, but they're looking to lynch a kid.
It's
These
just a
men
group
were
of
heroes.
people. Group of people engaged in a spontaneous marathon. And
Yeah,
you know,
yeah,
it's just
exactly.
I mean, the streets are clear, you know, why not? Give it a go.
Mr. Barnes, he was an active shooter in their minds. These men were heroes. They were trying to disarm a shooter. God, his cadence. Oh my God. If I could uppercut a cadence, I would have done it.
It's like almost NPR cadence, which drives me nuts.
Yeah.
Like most podcasts cadence. I can't listen to it.
It's the most condescending cadence. Like, I know you are all idiots, and that's why you're listening to me.
It's the pillow talk he's used to doing with Little Binger.
Oh my goodness!
Oh, here we go. Here we go. You get Barnes on at 2 in the morning, and this is what you get.
The pillow talk is with Judge Kroger. How dare you? No, this is a big point though, because like, to be fair to the analysis, Kyle Rittenhouse does trip. He does trip, but it's in the context that he has been hit in the back of the head at least one time. And he deflects the skateboard, but that thing could have hit him too, while he's running. And like, to leave out the context that he was struck twice prior to tripping by this mob is just that little bit of detail that you can kind of leave out and string along the people who are watching. And it's like, but it's really important to know that this guy was just clocked in the back of the head, at least by a fist. If nothing else is true, we know that one guy comes up and just right in the back of the head. And if you've ever been hit in the back of the head, it's very disorienting. If you're not expecting it, especially. So here we go.
Person who backs away. He shoots at a man who does sort of a half jump kick, but backs away after the shot.
Doesn't say kicks him in the face.
All of the.
I told you.
Okay.
I told you the back half was rougher, Nick. I told you.
Because we're at the application, which means you incorporate the facts into the rule. Joe has been hammering on the fact that he's using this Iraq analysis, and the most important part of application in Iraq is incorporating facts into the law.
Some facts may be omitted.
Yes, that's look. My retweet of this said that it is great Iraq, except for the fact that it's basically there's omission. It's mired with politics and omission. So,
all right,
there's your mission.
It is.
Here we go.
At roughly the same time, Anthony Huber hits Kyle Rittenhouse with a skateboard. Rittenhouse fires a shot. Huber picks up his skateboard and runs away. Another shot is fired in either the direction of Huber or Gage Grauskreutz. Huber drops to the ground.
See, look where he's pointing.
Wrong.
Look where he's pointing. He's not pointing.
There's not another shot fired.
He got that completely wrong. Well, I mean,
Yeah.
What happens is the second time Huber has attacked him with the skateboard, hitting him near the head and the neck. Then Huber grabs the gun, and as he's pulling the gun away from him, which to Richard's credit, he did a good job of emphasizing it close.
Yep.
As he's pulling the gun away from him is when he is shot. Not that then later there's another shot, and maybe it hit. That's the one that hit Huber. Maybe there was no later shot. That's just completely wrong.
Right.
Yeah, and there's not even audio of a later shot, because after Kyle shoots Gage, we will hear 3 to 4, I think, separate shots that don't come from Kyle. It might be as many as 6, but I think it was 4 shots that do not come from Kyle. So there are other shots happening at the timeline. No one knows where those shots are pointing from, going towards, but there would be grounds to say there were other bullets in the area, or there were other shots fired. But to say that a shot happened between the time that Huber was actually plugged and the time that Gage takes a bullet in the arm is just factually incorrect. There is no shot from any party during that time frame. And it's a short time frame, so that's not unreasonable at all in this situation. Very weird. Why would he? I can't. And again, Like, even if you take him as a biased sort of source, there's no benefit to including that shot in the analysis. It's just a basic.
He's telling everybody. I really didn't watch or read much of the trial. I just got a couple of clips together, and I did some Wikipedia.
My researchers watched it.
I read the jury instructions, and that's it.
Yeah, he read the jury instructions. He saw some video footage. He read some articles on it, and that's it. Like that's how he got the but the car source 2 guys, said that they didn't invite anyone. But like without talking about like, okay, let's talk about those guys. Let's talk about their testimony on the stand. Let's talk about the fact that the jury probably did not trust a single word that came out of their freaking mouths because you could tell that they were lying, that they were being totally evasive.
Because the jury just got off the phone. No, I'm just kidding. I was about to make a very, very non-PC joke.
Do it. There we go. Did you try turning the computer on and off? That's where you were going.
Look, they were just calling to inquire about the car warranties of the jury. Right before. No, that was no. I guarantee you, the jury did not believe those guys.
Yeah.
There's no way the jury. Like, first of all, the defense did a very good job on cross, and when they brought whichever one, Sal, I think, when they brought him back to the stand on the case in chief for the defense, like they destroyed their credibility. No jury would have believed those guys at all. No person watching that trial and like watching it, like if you read a transcript, you might believe them. You watch that trial and you go, yeah, these guys are terrified of what they're about to say. They don't know what they're going to say. Even if you don't go to the point of they were lying maliciously, you go, these guys are unreliable because they're scared. They're nervous. They don't look good on the stand. And nothing about their testimony was believable. So
in their defense, they didn't know whether to perjure themselves about their tax fraud, their insurance claims, or about their liability risk. They were like, which one do we got to lie about now?
Oh no!
I'm the inventory manager. Ask me questions. I'm the inventory manager. I'll give you just as insightful answers.
Kurt, as the inventory manager, how many cars did you lose that night?
No clue.
How many cars do you even have?
I don't know. Do we have cars at this car lot? Don't know.
Have you ever had a car in inventory ever?
Not that I recall specifically. No.
I don't actually deal with those details.
My dad does that. My dad does that part. So wait, you're the inventory manager. Your dad does the inventory? Yeah, he's good at math or whatever.
Yeah. Well, is your dad technically the owner when you got that small business loan for it being owned by your mom? I mean, that's why they were trying to go over here, over here, over here.
Yeah, because those SBA incentives for female-owned businesses, you definitely don't want to be caught lying about those.
Exactly.
This, I only when you're talking about these guys now we get to appreciate how many different forms of terrible witness there was in this trial. I think that's part of what made it so enjoyable. Between the whole wait, when you asked me if Kyle was there, on August, what time? Okay. Was he where?
Monday,
which
Thursday? I get days confused. But Tuesday, 24th, 27th, 20. It was a long time ago. I can't remember.
Yeah, Kyle.
Have you seen Kyle? Seen Kyle?
I don't know. Kyle? Did I talk to Kyle? When did
Kyle
I talk to Kyle?
Yeah. I don't actually know what I'm doing here. I just walked in here.
So that was one form, and then you had Gage Grosskreutz, who he's talking to the DA, and the DA is like, "So how much medical experience do you have?" I have 6 months. And where did you? What type of gun? I always carry a gun with me wherever I go. So,
but I never want to use it against
that.
Yeah,
form
that
of parable.
That's still great. Why would you say that? I don't know. What
acting?
Why say that? What's the point?
Oh, I don't know. Yeah, but I do want to ask you this while we're here at this moment on the video. This is a pet peeve of mine. I brought up before. I want everyone here to acknowledge there is never a point that Kyle trains his gun on Gage. If you go back 2 seconds to the position that Kyle's in, you'll see his gun is not pointing towards Gage, it's pointing towards his feet and the sidewalk. And this is something that Binger got Kyle to admit to, which was not even true. And it's important. The reason this is an important point is because if Kyle's gun is aimed at Gage's feet, Gage has justification to try shooting him. And if it's not, he doesn't. And that's why, and that's why I think it's a really important thing that I want everyone to be crystal clear on, that Kyle admitted to something that did not happen. The video evidence is 2 seconds before this, where you could see the angle of the gun and where it's facing. So
although
duck fart.
But you can't really discount the fact that he admitted to it, though. You
No,
know, that is
it was bad prep by Richards, and
Right.
the other bad
Yeah.
prep by Richards was on Yellow Pants Man, where Yellow Pants Man is pointing down, not pointing at, and he would have if they would have prepped him, they clearly didn't review the tape over and over again to review where all the ways Binger could come at him, and it's just good fortune, frankly, that Binger was not well prepared to actually cross Kyle. He did a very mediocre cross of Kyle, and Kyle did a great job, but the way in which the biggest risks for Kyle were risks that never came to fruition, not because Richard prepared him well, because we know he didn't, just on those 2 screw-ups that were easily preparable to correct to make sure it didn't happen, because Binger was not good at crossing Kyle, period.
Okay, Duck Fart says, common sense, don't advance on a person with a gun, set yourself and remove the threat from a controlled position. They gave up situational awareness for emotional reaction. Kyle was in a disadvantage for a long period after the initial situation. Yeah, that's accurate. Okay, let's get back into this. We gotta finish this before poor Richard. He's like awake so
all right,
long.
I'm just blinking and kind of rocking back and forth. It's all good.
It's fine.
Now you guys know how I felt during the streams.
So is Kraus.
I was like, oh, this is Legal Bites time right now. It's like your normal day right now, right?
Yeah, it's morning for me.
All right, here we go.
Round. Grosskreutz then puts his hands up while armed with a pistol. As he's making a move toward or to the side of Rittenhouse, Rittenhouse then fires at Grosskreutz, hitting him once in the bicep.
Towards or to the side, ignoring the fact that he testified that he stepped towards Kyle Rittenhouse. Just want to point that out.
And
now, this is
a gun at him.
And pointing the gun at him.
Yep.
Of course.
And now Gage is no longer bisexual.
What?
He just said bicep.
He did.
Oh, okay. Look, I'm not going to pick misspeakings.
Go.
Misspeakings are not misstatements, okay? Let's give some grace to this poor sap.
Simplification. There are a lot of other facts. But at base, this is a confusing and charged situation, even with video footage. And it's not.
No, it is not confusing or charged with video footage. The video footage is what has always exonerated Kyle from the get-go. What the hell are we talking about? Like, oh, even with video footage. No, the video footage has made this less. If there was not video footage, Kyle would be in jail right now, most likely. The fact that there was so much video has actually been a testament to how excellent his self-defense claim actually is. It is not confusing. From the get-go, this was the most clear-cut self-defense claim you may ever encounter in your entire life, and the only thing that muddied it up was the prosecution being able to sneak in the middle of trial drone footage to make a claim based on a detective using pinch to zoom on his iPhone that there was provocation. Without the detective falsely claiming he saw Kyle raise his gun at someone with an unverifiable pinch to zoom, you don't get provocation, and this case would have been over 2 days earlier.
If we didn't have video evidence, nobody would have ever believed that his self-defense was as flawless as it was.
No.
This is like, no one. We would have said you're lying. It's like, what you think you're like Batman or something, that every shot you're going to take is perfect? That's what we would have thought if we didn't have this video. This video shows a testament. Frankly, I can't believe he's as good as he was that night. I think he was incredibly lucky, but his trigger discipline and that he only hit the people he's intending to hit, never hit any innocent bystander when he's freaking out and surrounded by a mob and holding to the last second. The guy has every time. The only people who are shot by him are people either holding his gun or aiming a gun at his face, and that's the only people that get shot by him when he's in this mob and he's dazed and he's been hit by a skateboard and a rock and all these other things. That's an amazing testament to him that we never would have believed if we didn't have so much video footage showing what a remarkable job he did with perfect self-defense.
Well, and I think because this is my job on this stream, if we want to give give the benefit of the doubt to legal on this, you could describe the situation on the whole, Kenosha, the street, the run, everything else, as confusing and charged. Remember, he established that self-defense is putting yourself in the shoes of Kyle Rittenhouse. Confusing and charged, if you want to find acquittal, is useful terminology for what that night is for a young man running to the police line. And so to me, I agree with you that the video shows self-defense, but I don't think there's a problem suggesting that the whole situation was charged and confusing and looking at it from that perspective.
Look, everybody has to swab the poop deck sometime, and you drew the short straw tonight. It's great.
Usually that's me. It's all you, baby. You take that one.
No, it's great. But no, real quick, another announcement. Nathan DeBruin reached out to me. That is Photo Chad. And
Awesome.
I have made contact with him, and we will be scheduling an interview with him at his convenience.
Nice.
This was short notice and late at night, so he wasn't coming on today, which is fine. But I am working on that. So to anybody curious, we'll have him on the show as soon as possible. Here we go.
When are you getting Kyle on here?
I have not reached out to Kyle just yet, but I will be soon. Because the problem I have with reaching out to Kyle is I do not think he should be doing any of the interviews that he's doing. But if he's going to do them, I want him to come on here and talk to us. But I also when he went on Tucker, I'm like, what the hell?
Very interesting interview. I mean, I highly recommend it. It's very interesting.
Actually, I during the daytime show tomorrow, I actually want to watch the Tucker interview with the panel, whatever panelists are available, and talk about it. Because I think it was I think there's some interesting stuff going on. And I would like some legal partner analysis on that. So here we go.
Not an easy case in either direction. So was this self-defense? You can look at those facts and see a murder. You can look at those facts and find self-defense.
Done.
You can look at it and see a murder only because you've omitted some very important facts.
Exactly.
I look at it and I see an elephant.
Exactly. No, you can look at the facts that he put in the video and see a murder.
Yeah.
But if you look at all the facts, you're probably not going to see a murder. Just thinking.
Two diametrically opposed beliefs can both be reasonable at the same time. There are a ton of open questions here. Was the use of force proportionate in every encounter? Was the use of force reasonable in every encounter?
Yes.
What did the medical examiner say, for
those
example?
reactions? But the videos and testimony show a chaotic situation and people acting quickly. Now, no blanket assertions can be made. You have to run the self.
No, blanket assertions can be made. They can be made by just both sides, by the way, can and do make blanket assertions. It's very easy to make them, but they certainly can be made.
Defense analysis for each incident individually, including the shots fired at the people that weren't Rosenbaum, Huber, or Grosskreutz. With the provocation argument aside,
the only person that the shots were fired at that wasn't Huber, Rosenbaum, or Grosskreutz was Jump Kick Man, and those were fired and missed. And let's just leave out the fact that the prosecution and the defense, by the way, we need to call out maybe the defense on this. They allegedly knew the identity of Jump Kick Man as well before trial. And I don't know what the strategy would be over not naming him and bringing the prosecution to task, but that has apparently come out. I have heard. I guess I don't actually know that because I'm not the defense team. But if that's true and they bungled that, then that's a colossal mistake.
And here's where it might be useful, if you're legal here, to point out that self-defense applies to third parties under the Wisconsin statute.
Mm-hmm.
Yeah.
Sure.
Yeah, because again, if your theory is that he pointed a gun at Zeminski, then Rosenbaum is actually potentially, assuming you can show that he had been witness to that event, he's justified in attempting self-defense against Kyle.
Right. He's going to talk about that as well.
Oh, excellent. I can't wait.
One might look at these incidents in question and decide that they were self-defense. After all, in the latter two incidents, Kyle Rittenhouse was fending off what was arguably an attack with a skateboard, and in another, the man admitted he drew a gun on Rittenhouse. But one might also reasonably conclude that one or more of these incidents were not self-defense and were therefore murder. After all, in the first instance, Rosenbaum, an unarmed man, threw a bag of clothes at Rittenhouse, which didn't...
Objection, facts, not in evidence.
Yeah, it's not bad clothes.
Yeah, actually,
we don't know what was in the bag.
We have no testimony that clothes were in the bag. That's a really weird one to say. We know that there was a water
bottle,
a water bottle that according to testimony that's in evidence, was empty. That's the best we have, is that it was an empty water bottle. We know that there was maybe ammonia, but not a sufficient mixture to make a gas bomb. That was kind of contested, but Balch said that he did not find both elements, ammonia and whatever the other thing was. Chlorine. Yeah. So very weird. No one testified that clothes were in there at all. So what, again, and it's these basic factual mistakes that someone who knows the case is going to say, hey, wait a minute, now I can't trust anything. But the layperson who doesn't, and this is the problem,
doesn't know any better.
Right. This is a problem with misinformation in general. Oh, he threw a bag of clothes. Clothes aren't very dangerous. Well, yeah, but let's say that water bottle might have been full. You throw a full water bottle at a basketball game and you get charged with assault with a deadly weapon. It's that has actually happened in the past 12 months. So it's an interesting distinction. That's why both sides spent so much energy trying to identify what was in the bag. But here we go.
Rittenhouse, after which Rittenhouse points his gun at him, and then Rosenbaum moves at Rittenhouse, or apparently towards the gun, and Rittenhouse shoots him 4 times, once in the back. And yes, I'm aware of Rittenhouse's self-serving testimony about the preceding incidents.
Self-serving. Oh, wow. You motherfucker.
Just say Fifth Amendment now. Just say Fifth Amendment. Say it.
Mother fricker.
This will be all he'll be offering about the statements about I'm going to kill you, by the way. This is the extent of it. So if you're waiting for it, this is it, my friend.
Look, when you suggest self-serving testimony in a legal context, you are suggesting that they are lying. You're suggesting that they have, after the fact, post facto, determined a proper course of events that will most benefit the person, and you're giving no credence to the reality on that they are professing. Like that, there's no indication that Kyle's testimony is self-serving. In fact, the idea of the threat from Joseph Rosenbaum comes from not one source of Kyle, but 3 sources, and one of them being a state's witness. And look, I know that Ryan Balch was not a helpful witness for the state, but the state determined that Ryan Balch would be a more helpful witness for them than a harmful witness for them. And that's why they called him on direct. You would never call a witness on direct unless you think you have to get their testimony to benefit your case. So they took that risk. They fucked around and found out, and that's what they got. They got the fact that Ryan Balch was sitting there saying, yeah, actually, this guy said, if I get either of you alone, I'll kill you. And he said, yeah, Kyle's right there. He would have heard it.
And this is exactly the area that he made the Fifth Amendment violation, where he was saying that Kyle was staying silent for this time and assessing what story would fit best, and that's exactly when Binger walked down that road and pretty much breached his civil rights and his right to the Fifth Amendment. And now Legal Eagle is basically saying the exact same thing. It's a self-serving. Now that he's watched everything, that's where he's concocting this story of his, which he doesn't need to concoct because it's all there on video.
I keep noting how he talks about how reasonable minds can think this and reasonable minds can think that. The major problem, I think, is that he's not giving any facts that would allow a reasonable person to come to the other side of this equation. He's only giving the facts that are bad for Kyle, which he does in spades. But he doesn't mention anything about the threat. He doesn't mention anything about these other things that are so good for Kyle. So it's like, well, how are reasonable minds supposed to come to different conclusions when you're not giving them the facts?
Well, no, I'll do one worse for him. With the fact set that he's presenting, he's still forced to admit that reasonable minds can disagree. Even though he's giving a heavily biased fact set, he says, with these facts, reasonable minds can find either conclusion. But if he gave the full fact set, he wouldn't be able to say that, in my opinion. But let's persist on.
What I'm saying is that reasonable minds can differ. And Rittenhouse also shoots at, but misses the unarmed jump kick man. And the latter incidents involving Grosskreutz and Huber happen perhaps a few hundred feet away from several dozen police officers. It's not surprising that the people who pursued Rittenhouse thought he was an active shooter who needed to be stopped. But the only question in this—
Right, that is surprising. There was no shots going off in the prior minute and a half. Why would they think he's
a few hundred feet when your life is on the line is quite a bit of distance.
Look, every active shooter I've ever heard of was actually retreating, not shooting the entire time until they got knocked down. So, I mean, it's fair.
This particular case was whether Rittenhouse's actions could possibly have been reasonable. Because remember, the standard is that the jury must find that there is no reasonable doubts that it wasn't self-defense. It's possible, if not probable, that both Rittenhouse and the people he killed were simultaneously acting in self-defense. The fog of war is a real thing. Reasonable beliefs can—
The fog of war is a real thing?
I think that's his way of saying that everyone gets confused, so you could be wrong about the reality as long as anyone in your situation would reasonably come to that conclusion you did. I think that's what he's trying to get at. But
this motherfucker's playing StarCraft while we're doing legal analysis. That's all I gotta say. What
I actually like this point. I think it was missed by a lot of folks.
I do actually agree that if we were to sort of, and we did this at one point during the live streams, that we were talking about one of the many live streams we did. I remember talking about, looking at it from the perspective of Grosskreutz and Huber. Could you argue self-defense? And I think that you could argue. Whether or not that would actually be a winning argument is another matter. But you could actually argue it. So I do kind of agree a little bit with what he's saying. But it's like I keep finding myself throughout this video being like, okay, I kind of agree with what you're saying, but then you kind of twist it, or you like weave into like some kind of like political thing that it's like I can never fully agree with what he's saying here.
Yeah, and the problem is it's analogous to Arbery, is that they didn't have probable. Wisconsin common law arrest. They couldn't arrest him because they did not have probable cause that he had committed a felony. They hearing somebody scream, "Oh, that person's shot somebody," generally doesn't suffice for that legal standard. So they could have all been prosecuted. Had Huber lived, he could have been prosecuted. Grosskreutz could have been prosecuted. Jump Kick Man could have been prosecuted. Zeminski could have been separately prosecuted. But the assailants that night could have all been prosecuted because I do not think they had a right to arrest, and that makes them the attacker.
Rosenbaum actually couldn't be prosecuted. Rosenbaum couldn't be prosecuted because he's committed so many offenses against minors that he's actually immune from prosecution against adult victims. So it's a weird product of law when you assault so many minors that there's nothing else that the state can do to you against adult victims. So he might not have been able to. I just want to say,
Robert, what Robert said here, I was arguing with the panel here about this before. I do not believe that they had justification to try and arrest him. The guy is clearly running directly to the cops. He's not firing any guns off. And I've heard many on the panel here say, yeah, if everything had turned out 180 degrees the opposite way, they could have had justifiable self-defense or defense of others. And I don't understand it. He's running straight for the cops. He's a block and a half from them. He's not firing his weapon. He's not even like training his weapon around in any direction. There's no reason to think of him as an active shooter. And this was clearly, and to my mind, it was a lynch mob trying to kill him before he could reach the cops and reach safety. They were afraid he was going to reach safety. They were not afraid he's going to hurt someone. And that's why they're hitting him over the head and trying to knock him down before he can get in range of the cops. So
I don't know if that's true.
Yeah, I disagree with you, Joe.
I think the facts can be parsed either way. I mean, it's
again, if we were to imagine this the other way, then they'd have the same reasonable doubt burden as well. I don't think you can. If you're
what would be their probable cause for an arrest? Because they instigate the violence, so they are in a provocation circumstance, so they don't have self-defense unless it's a lawful civilian's arrest, a lawful arrest, and even there, it still may be excessive force, using a skateboard, for example, pulling a gun, you can go back and forth on. They're arguing in Arbery, just pulling a gun on somebody is excessive force.
Although there would be in this instance, there would be the added facts of probably having heard the shot itself and then seeing this guy running with people chasing him, holding a gun.
At least with Grosskreutz, he didn't provide any testimony as to why he had probable cause that Kyle had committed a crime.
No, he didn't. He threw himself under the bus on somebody,
and then he's followed him, and then what Kyle tells him isn't enough. Isn't the kind of confession that could equal grounds for citizen's arrest. So under Wisconsin law, I just don't see how any of the people, unless Huber knew something different, but even there, a skateboard on the head, that's probably excessive force.
No, I don't agree with that. When a guy has a gun, I think that's probably reasonable.
Grosskreutz testified that he heard Kyle say that he's with the police, not that he was going to the police. That doesn't give him any greater justification to try and arrest the guy.
He just doesn't. If they had witnessed it, the closest would have been Zeminski and his girlfriend maybe have probable cause, but then you have to ignore the fact that Zeminski's provoking things by shooting the gun in the air. So and you have issues there. So that's where I didn't think many of the people there showed that they had probable cause to believe Kyle had committed a felony sufficient
do you still think that if Kyle's a murderer? Let's just take Rosenbaum. Kyle provokes him, whatever it is, raises his gun at him, does all the bad things, murders him, and everything from there follows exactly the same way. Do you think that those two don't have the right to come after him?
They don't. They have to have personal knowledge of it. They have to have knowledge that's sufficient to meet probable cause. And,
but again, if we're imagining
I still think you can get to
right.
I still think you can get to defense of
others. They have plausible self-defense. If we're imagining they're being tried, do you think that the state can prove that they don't have a self-defense right, that they can get over?
Well, I mean, you're talking about two different things. You're talking about citizens arrest and you're talking about defense of others, which are two different things.
Right. I mean, my argument is because they instigate the violence, they don't have self-defense unless it was necessary violence for a citizen's arrest. So that's how it ends up being like Arbery. The two they're closely interconnected. They need a lawful citizen's arrest and necessary force for a lawful citizen's arrest in order to have self-defense. They don't, because they don't have the probable cause for a citizen's arrest.
Because the probable cause is a necessary element in order for them to have a justifiable citizen's arrest. And if you don't have justifiability, you don't have your self-defense anymore, or defense of others.
But what about looking at it from a defense of others perspective as opposed to?
I think they're the same. Self-defense, defense of others. If it's not justifiable,
no. I mean, as opposed to a citizen's arrest. I think that if you see somebody that you think is threatening other people,
imminent harm, imminent bodily harm,
imminent harm. I think you're there. I think you're there because if
I think there's a decent argument to be made.
Yeah,
I don't know that it would win, but I think you can make the argument.
If you believe Rittenhouse just engaged in a murder and he's running, there could be a lot of reasons that he's running, but he might be running to try to get to a better position or running towards other people. There's reason to believe he's still an active threat, even if he's not shooting anyone at that exact moment. If he just shot someone 10 seconds ago, I think he's still is an imminent threat now.
None of these people saw it. That's the problem. They have to have probable cause that happened, and it has to be reliable information.
Maybe. There's an argument that once he fires a jump kick man, that he becomes an active shooter.
But that's a guy jumping on him while he's on the ground shooting up. So
I didn't say it was a strong argument.
Is that probable cause of a crime, or is that this person's an imminent threat to multiple people? It's like, because this actually does come up when people get involved in somebody else's bar fight. And generally, you got to be real clear on one side clearly being in the legal wrong. You having probable cause of that such that you can initiate force. The law disfavors it because the law doesn't like third parties jumping into a bar fight and escalating it. So that's why I would say generally, if the state had prosecuted Grosskreutz or if Huber or Rosenbaum had lived, I don't think they would have had a self-defense argument, and I don't think they would have had a citizen's arrest argument. So because of they didn't have probable cause of sufficient facts that were clear enough to warrant it. I mean, you look at the McMichaels, they had a lot more facts than any of these guys had. And a lot of people think they're going to get convicted and think they should be. So that gives you some illustration.
I just love that there were two chats in a row, and the first one says Barnes is right, and the second one said Barnes is wrong. That's how this look. I think we can all agree on this. all of the possible claims for murder and self-defense or whatever of everybody else involved are much murkier than Kyle Rittenhouse.
Yes.
And another thing,
and they're all relevant as to Kyle and his self-defense claims.
And another
they're
thing
all
that is
irrelevant, you said, right?
Yeah, they're all irrelevant as to Kyle.
Yes.
Right. And another thing that Legal Eagle doesn't say here is that at the end of the day, what is most important for this analysis is going into his state of mind, not anyone else's. He kind of sort of gets there almost. He sort of touches on it, but he never says the only state of mind that matters here is Kyle Rittenhouse's.
Let's see how
Kyle should file a civil suit against Gage Grosskreutz for pulling a gun on him.
Let's see how Legal Eagle touches me.
How do you think that would go if he filed a civil suit against?
No, we're just going to slide further into the darkness, Nick.
Be mistaken. The jury was accurately, based on the law, told that they had to determine whether Rittenhouse's belief was reasonable based on the circumstances. And this reminds me of the story of Gabby Giffords and Joe Zamudio. When Giffords was shot at a political rally,
This is completely irrelevant to Kyle Rittenhouse's
This reminds me of the
It's not going to get better.
This reminds me of a mass shooting incident that was really dangerous that has been the basis of libeling a range of conservatives over the last 5 years.
Okay, here we go.
Rally, Joe Zamudio, who was legally armed, came running to help when he heard the gunfire that injured Gabby Giffords and killed 6 others in Tucson. By the time that Zamudio came to the scene, unarmed civilians had already tackled.
Came to the seam. We heard that. That was the seam.
Hey, you were giving us crap for pointing these things
out. He said
I've never mispronounced a word on my channel.
I'll ban all of you. I'll ban everybody.
You need us, Nick. You need us. Let's
Zamudio
face it.
later said that in his confusion, he was within seconds of shooting one of the people that was helping, not the shooter himself. This is an issue that champions of Rittenhouse should grapple with. If Rosenbaum or Huber...
Oh my, yeah, that's the picture. That's the moment. That pissed me off. I saw this.
This is a neutral analysis, guys.
This is totally neutral. Totally neutral. We're not trying to support one side or the other, just giving a neutral recitation of the facts. We're not a partisan hack in any way.
Rosenbaum in his underoos there, wearing his little superhero flying cape costume there, and Grosskreutz. This is how he's giving his even coverage. He's going to show you the pedophile, the burglar, and the domestic abuser.
Look, every time Mark Ruffalo looks at JoJo's bulge, he gets a little excited. Here we go.
Or Grosskreutz had killed Kyle Rittenhouse, they might have been justified in using self-defense under the law. Again, reasonable minds might differ on this, but any system that incentivizes rule by the last person standing, that is, killing the only person who might dispute your claim of self-defense, that seems, well, suboptimal.
That's not what we do at all.
Not in any way even close to self-defense law. And it's
whoever
also
standing last wins. Sure.
That and tell that to the guy in Minnesota who shot the 2 burglars in his house. Tell that to any number of people who have claimed self-defense over their deceased victims and have failed, because most self-defense claims, as Andrew Branca, a leading expert in the field, has said, most self-defense claims are bogus.
Yeah,
most of them are not correct.
Well, and this isn't a scenario with this much video that we're talking about. Oh, we don't know what happened. Right. It's a characterization of exactly what we know what happened. This isn't about who's the last standing. And in those circumstances, there's nothing that the people that died could add to the conversation anyway. In terms of Kyle's defense.
Oh, I thought you were going further. Sorry.
Yeah, we were all giving you
In terms of Kyle's defense, was the period. I thought it was
period on that.
I thought it was a comma. It was my error. Here we go.
To this point that my notes simply say vigilantism is bad.
You have notes? First of all, this isn't.
There's no way that wasn't scripted, by the way. There's no way reaching over to it and say at this point. We're
going to leave these papers over here.
Saying it.
We're going to leave these. Yeah, you're reading off his teleprompter.
What's this folksy moment that he's doing?
If we don't think that someone who makes $10,000 to $30,000 per video has a teleprompter at this point for his notes, I don't know what to tell you. But vigilantism.
Waiting for him to pull Joe Biden and say, "End of statement." End of
quote. Vigilantism is not an issue here. The vigilantism did not occur in this case by any honest recitation of the facts in record.
Except maybe the assailants.
Because, right. I mean, yeah. Gage Grosskreutz.
Kyle was a victim of vigilantism by members of the pedo Antifa left that night.
So I'm not sure how much longer I'm going to hang on here, but I will say my piece on this part. That this is where everything before now I thought was relatively strong and fading. This is the part where he's going to start adding in his societal commentary. So vigilantism is bad. We're going to start talking about racism and other things, and we're going to get those editorials about whether deadly force was used or not. And I had the interaction with him on Twitter about how problematic I found this particular portion of the video, because he steps out of the shoes of lawyering. He steps out of the shoes of talking about what this case is. And most of what I really had a problem with this weekend is the notion that you should use a trial and a defendant's life to push for whatever your political cause is. I don't care. And that this is a very poor vehicle for that. And I think he loses his audience or he confuses them, because he's going to talk about all these things even after he's talked about the specific facts of the case, regardless of how you feel he did with that recitation. And I agree with you. And this is going to go on for the next, what do we got? We got 7 minutes left, give or take.
Yeah.
This is what he uses the next portion of his video to do, is talk about all those tweets, those hot button topics, the news, in a way that I think is not great for a lawyer in his position with his platform to do.
And to be very clear, this is the one thing Richards and Shirafisi did exceptionally well. And it was a conscious decision. They did not make this a cause. They did not make this about a greater societal issue. Richards has testified to it, and it's pretty clear from how they conducted the trial, agree or disagree with their tactical decisions. Their overall strategy said the focus in this trial is on the client, not on the societal concern, not on defending liberty or the Second Amendment or self-defense. They didn't do any of that. It's evident that they left, and that might in some instances be to Kyle's detriment, might not, we won't know, but they left out on the table the potential argument that Kyle had an absolute right under the Second Amendment to carry his gun as part of the militia. The militia under Heller, under Scalia's opinion in Heller, Kyle's a member of the militia because he's 17 years old, and that's actually in the U.S. Code that 17 to 45 able-bodied males are in the militia. So he should have the absolute right to carry whatever firearm he wants. Of course, until the gun charge is dismissed, then it's a different thing. They didn't do any of that. They said, our client, self-defense, this is where we go. This is the justification. We don't need to bring a greater narrative into this case. And I think that was a very smart decision. And it was also one of the things they intimated in post-judgment interviews, that the best thing that they did was get rid of Linwood and John Pierce, whose entire motive was agenda-driven, either some greater political agenda or some greater personal agenda for those two attorneys. And God help us if Kyle would have been represented by John Pierce and Linwood at this trial. It would have been a fucking disaster.
And that's actually the first thing he said in his interview, is that when he met Kyle, he went up to him and he said, if you're looking for someone to make a whole cause out of this, I'm not your guy. I'm not going to play that role here. And I'm going to play it straight, as far as this is your kid in the situation. Everything you did here was perfect self-defense. And it's not about cause or movement, or you're not the face of anything here. You're just a kid on a stand. So,
yeah. All right, let's get through this last 7 minutes so I can get to my Dominic Black news.
And I stand by that. I also worry that is becoming a controversial position. Net, bringing guns to a protest is bad. Anyone that brings it, not just Kyle Rittenhouse. But there's a large strain of people that say that Kyle Rittenhouse shouldn't have been there, and that's the reason that he...
None of those people should have been there. They were causing a fucking riot, you weird mung. What are you talking about? What is wrong with you? What is this? Oh, Kyle Rittenhouse shouldn't have been there. There's a fucking riot full of unlawful actors. They shouldn't be there. Stop doing this. Stop putting an undue burden on Kyle Rittenhouse to not be in response to a bunch of unlawful mongrels. What are we doing? Oh! My apologies.
can't use self-defense. And by most accounts, Kyle Rittenhouse meets the definition of a vigilante. But whether Kyle Rittenhouse...
What?
No, he doesn't.
What are you talking about?
In fact, I mean, that frankly that's borderline libel. Yeah. Because arguably vigilante is not so much an opinion as it is a statement. I mean, that's close. You can claim it's an opinion, but there's factual components of it, especially at this stage. I mean, there's no evidence at all he's a vigilante. None. Zero. None. Nada. None whatsoever. That's not even an arguable point. The prosecution never even made that claim throughout the entire trial. It has no factual basis whatsoever. But Legal Schmiegel can't help himself because he can't wait to get with Little Binger and have their little fluffer boy conversation.
If Kyle sues Legal Eagle, I'll be so happy.
Definition according to Merriam-Webster, which I don't know. I mean, they're actually a pretty liberal source at this point, but they define broadly vigilante as a self-appointed doer of justice, which I don't think he's doing. I don't think he's trying to do justice here. That's exactly what Mark Richards
performing a police.
The definition of vigilante is they'll probably change it now. Probably.
Yeah.
It just says Kyle Rittenhouse. That's all.
Vigilante is someone who wants to get revenge on somebody else for something that happened. That's
how I understood it. Also,
self-appointed. He was asked to be there, so there's that.
Yeah, definition from Oxford Languages is a member of a self-appointed group of citizens who undertake law enforcement in their community without legal authority, typically because the legal agencies are thought to be inadequate. The problem with this, of course, the ultimate problem with this is that legal authority is derived from and not excluded from the citizenry. That's why citizens arrest is still a thing, and it follows the same structures as lawful arrest by a peace officer. This is a big component of the McMichaels case, but you don't need a statute for citizens arrest. A statute on citizens arrest is actually a limiting statute, not an enabling statute. It is a restriction on your ability to conduct a citizens arrest. Absent of a statute, you have the same lawful authority to conduct arrest that a peace officer would have in a similar situation. Now,
in Wisconsin, that's what it is in Wisconsin. It's all common law defined.
Right. And that's not legal advice. I'm not saying that everybody should go out and citizens arrest everybody or anything crazy like that. But the reality is that the citizens arrest statutes are limiters to what is understood, because the state derives its power to arrest anybody from the citizenry. That is a power that was original. The police, this is weird. And Barnes, maybe you can help me out with this as a student of history, but police originally did not act as interventionist peace officers. What they actually did was they served warrants. They served at the service of the court or the service of the magistrate to go out and do a thing. It was a cleanup duty. It was not an intervention duty. And we've changed that definition. The intervention was on the citizens because they were armed, and the citizens and the community policed themselves largely. Is that accurate?
Yeah, a lot of communities didn't even have police. It used to be the case that if you formed a police force, the city would be liable for any riots that occurred, any damage from riots, because the police was there to stop the riots. And so there were a lot of cities that didn't form, because at the time, cities generally didn't form police forces. And that was not a commonplace universal phenomenon. So, yeah, and the right of the individual to exercise the law was considered normal. The idea that the state should have a monopoly on the use of force, or the monopoly on the right to bring someone to justice, is a statist idea that's actually foreign to American and English common law.
All right, welcome to the stream, Runkle. How's it going, buddy?
Hey.
I just arrived back from a trip to the States. Oh man, travel sucks now.
Yes, it's terrible. As someone who flew today and yesterday, I hate every second of it. So we're just a couple minutes, 6.5 minutes left in this video. So we're going to resume. Here we go.
House should have been there in the first place isn't relevant to the questions of whether he legally met the definition of self-defense in the first place. Just simply possessing a gun by itself doesn't prevent the application of self-defense.
Good.
And there are, of course, larger social issues here as well. Many have claimed that it would have been impossible for a black person to kill 2 people, injure a third,
we're going down a bad road,
and live to walk away from the scene.
First of all, no, stop it.
He's got more, Nick.
He needs to stop this line right now. The hypothetical mythical black man who has defended himself but doesn't actually exist in this situation cannot be measured. It's an immeasurable alternative, and it's a frequent use of political punditry to create a hypothetical straw man to bolster your argument.
And it's patently false. On the same day Kyle was acquitted, a black man was acquitted for shooting at police officers.
Yes, he shot a cop.
Yeah, exactly. So the idea, in fact, I would say disproportionately, there's someone who did a whole Twitter thread on high-profile cases of black defendants who were acquitted using self-defense. Long litany of them. I would say you look at it proportionally, lawyers that I know, it's more commonly used by black defendants than even white defendants. So the idea that, or at least proportionate to the population. So the idea that black defendants do not benefit from self-defense and couldn't is a complete lie. He's injecting this for racist purposes to say somehow this was white privilege, which is absurd. But the worst nefarious is that he's trying to undermine self-defense, which actually disproportionately benefits African Americans in this country.
Exactly. Okay, here we go.
House did. And then, of course, to be found not guilty. And we can probably evaluate whether this is true or not. One way to look at this is by studying the data on how juries perceive self-defense. A study by John Roman found that homicides with a white perpetrator and a black victim are 10 times more likely to be ruled justified than cases with a black perpetrator and a white victim. And the gap is larger.
Look, I don't want to get into statistics on crime, but there is a reality between the how do I word this without getting banned off of YouTube? Because I don't think that these statistics tell the whole story. There's a whole lot that goes into it, so don't misinterpret. But there is a disproportionate amount relative to black offenders versus white victims than there are to white offenders versus black victims. And the most disproportionate amounts is white offenders on white victims and black offenders on black victims. But to come to the conclusion that self-defense claims largely favor white self-defense claimers versus black alleged perpetrators kind of actually fits the statistical model for the perpetrators of the crime versus the victims of the crime when you flop the races. And again, it's weird and risky to even talk about that. And I do not want to in any way imply that those statistics tell the whole story, because they do not. But those statistics are a reality that must be incorporated into any reasonable data analysis. And to ignore the context of those statistics is a problem.
And it's pertinent to note that either of those scenarios isn't applicable to the case that we're talking about in this video.
Exactly. Yes. Thank you. That's probably what I should have said.
Kyle was the guy defending a minority immigrant woman-owned business against white perpetrators who were screaming racial epitaphs all night long.
And if you do assume that this is just, racism is the sort of the reason for that disparity, why would you want to bring everything down to the worst scenario where, they're always saying, oh, well, what we need to do is bring everything down. If a black guy wouldn't have gotten away with it here, isn't the answer that the black innocent defendant should also be acquitted?
Yes.
Yeah.
Correct.
We need more wrongful convictions to fix racism. I don't understand that.
Yeah, it's a weird tack, but well, let's move on.
In states with stand your ground laws. And after accounting for a variety of confounding factors, such as whether the victim and perpetrator were strangers, the gap is smaller but still significant. Cases with a white
After accounting for whether the victim and perpetrator were strangers. Okay, so you eliminate the overwhelming majority of cases in which the victim and perpetrator knew each other, which takes race out of the question almost entirely. So thank you.
Perpetrator and black victim are 281% more likely to be ruled justified than cases with a black perpetrator and white victim. But systemic issues like that weren't on trial here. You don't adjudicate those kind of systemic issues in a criminal court of one individual. The issue is whether.
Then why bring them up?
Yeah, right.
So again, we talked about this, right? So
yeah.
I look at this and say legal has arrived at where he needs to, which is they're not meeting their burden of reasonable doubt. Acquittal is effectively the right decision, but he knows his audience isn't going to quite go for that. And so all of this is gravy on the turkey of what he's putting forth in the video to try to get out from effectively crucifixion by his own folks.
All right, here we go.
Defense, or more specifically, whether the prosecution disproved the possibility that he used self-defense. And for what it's worth, there are lots of people who think that Kyle Rittenhouse's actions were not self-defense. There are lots of other reasonable people who think that Kyle Rittenhouse's actions were self-defense. Now, I doubt all of those people.
Okay,
There's a distinction between those who watched trial and those who did not.
There is, but okay, so during the first part when he said, like, this is subtle to me, and maybe that I don't think this is nitpicky. I think this is intentional, not by Legal Eagle, but by his editor. During the part where he's saying there are people who think it was not self-defense, he's showing a scene of Kyle shooting Joseph Rosenbaum. During the part where he says there are lots of people who think it was self-defense, he's got an unrelated picture of several cops on the side of a truck from a. Is this even from the night? Is this even from Kenosha? Where the hell is this footage from?
I don't think there's a veggie grill in downtown Kenosha.
Why is this footage even in here other than to, like, again, I don't think that Devin had anything to do with this particular clip, but his editor is entering into the idea that subtly that people who believe that Kyle Rittenhouse is justified are either pro-police or are police or somehow involved in. It's a weird thing to do because when all of the other footage is from Kenosha, this doesn't seem to be. So I don't know why that's there.
Have you ever taken a person named Devin seriously?
No, never in my life. And that's an unfair characteristic, and I stand by the fact that that's okay.
Well, and you're right on the veggie grill. It doesn't look like there's.
What was that, Runkle?
I just looked up veggie grill. It doesn't look like they've got anything in Wisconsin at all.
Look, Wisconsin has never heard of a vegetarian restaurant in their life, unless it's just a cheese store.
Exactly. It's the capital of brats and great sausages.
Oh, here we go.
Of the trial then spent days poring over the jury instructions like the Kenosha jury did. But the thing is, if reasonable people really could conclude that this was self-defense, then it means that the prosecution didn't prove self-defense beyond a reasonable doubt. That's the definition of reasonable doubt. Now, that being said, an acquittal doesn't mean that Kyle Rittenhouse didn't do it. It doesn't mean...
You know what? I take a little bit of issue with this because an acquittal in a normal case doesn't mean they didn't do it. You can't prove that they did it. But an acquittal in a self-defense case, we have to acknowledge, is a step up.
That's with a ton of video. There's no question he did it. The question is what the law thinks about it.
Right. And this is, again, you can never get to certainty in a jury verdict ever. But the idea that, okay, we put forward the idea that he defended himself. We admit to all of the underlying facts of the crime. He pointed the gun either recklessly or intentionally, depending on the criminal act, pulls the trigger and discharges a weapon into someone. Okay, we've got that. We know he did it, but his justification for doing it is self-defense, and the jury will never know. I mean, I guess the jury could have come to the conclusion irrationally that he didn't pull the trigger, that he wasn't the guy who killed Huber or something like that. But we have to assume that they did come to the conclusion that he did do the act and therefore that he was justified in doing the act, or rather that the state failed to show any reasonable doubt as to the justification. But if the state can't show or can't get beyond reasonable doubt as to the justification, as the burden is shifted, we have to realize that that's a higher acquittal than just merely failing to reach beyond a reasonable doubt on the underlying murder. Sorry, go ahead, Barn.
Here's the other reality. Beyond a reasonable doubt sounds nice. There's not a single jury that acquits you that thinks you did it, even if they think you did it by 51% to 49%. You know,
No.
it's nice language. It gives a an excuse to feel good about your verdict. But I've never known a jury and in the hundreds of mock juries, if they think 51% chance you're guilty of murder, you're convicted. When they say not guilty, they mean you didn't do it or you were legally justified in what you did, period.
Look, and a great example of this is Derek Chauvin, right?
Yeah.
Because if you go beyond a reasonable doubt standard, and I personally think Derek Chauvin is guilty, to put everybody out there. Look, I don't think a police officer should be kneeling on anybody for 9 minutes. That's just my personal belief. You don't have to agree with it. That's fine. But I thought that guy was going to be guilty forever. But here's the thing. If you go beyond a reasonable doubt, there's no way that Chauvin should have been convicted under that standard, because you have too many questions about the fentanyl in the system of George Floyd, his excited response sort of thing that can lead to cardiac arrest and stuff like that. All of that is reasonable doubt. It was raised at trial. It was competently raised at trial. And under a beyond a reasonable doubt standard, I don't think Chauvin actually gets convicted. But the reality is, I think it's exactly as you say. Juries function on a preponderance of evidence standard, despite the fact that they're told to be beyond a reasonable doubt.
There was no basis for second-degree murder on Chauvin. There was no. They never reached any.
I think there are definitely issues there. But can we note how much in style, even hair, Little Binger and Legal Eagle look alike and dress alike and style alike?
You know what I almost did for this video? I almost swooped my hair up and put on a suit. I almost did it, and I was like, not tonight, but maybe tomorrow.
Someone should take some of the meme makers out there should take Legal Eagle's head and stick it on Binger when he's Little Binger when he's got the gun in the finger.
All right, here we go. Back to it.
That what Kyle Rittenhouse did was right, and the pathology of Kyle Rittenhouse's hagiography is another issue entirely. And it certainly doesn't mean
hagiography. Did you hear the hagiography?
Just
the
means
pathology of his hagiography. Yeah, he said that.
He said the pathology of his hagiography.
Oh, the hagiography.
Yeah. So he's got an issue with folks aggrandizing Kyle, and I think that comes up more in his tweets than it does in this video.
Mm-hmm.
But that's what he meant by that phrase: is that there's a portion of society that views what Kyle did as heroism, and he's got a real issue with that.
Because it was Kyle hero, Legal Eagle not. Kyle Hero.
No, Barnes. How did you feel it?
Oh my
Kyle
God.
Hero, Legal Eagle 0. You gotta have the rhyme. Look, rhymes make it true. I learned that from African American culture. And I am
no, from Hocus Pocus Out of Focus.
No, look, Binger,
Please.
Hard R
Words
Binger
don't
with
fit.
the N-word pass definitely is privy to African American culture. Otherwise, he would have never been able to say the N-word on the stand. Come on. No.
Oh my.
No, I'm
You had to go there.
Look. No, that's an interesting thing, because originally I was like, I don't know if we should celebrate this guy as a hero or not. But the more I think about it, everything Kyle did, the worst you can say about him is he was maybe naive. Like, in all honesty, he's maybe naive, but he's out there. He's trying to help people. Not only did he testify to the fact that he's offering medical to whomever, but we actually have evidence that he provided first aid to someone who was a protester who was out there on the quote unquote other side that night, that he did provide first aid to for the cut on the hand. When situations come up that could be affrontive, he diffuses them and leaves the situation. It doesn't look like in any way this kid is trying for confrontation. He does appear to be trying to help his community. And so then the actions that he does subsequently, I've come around on this and think that it was actually heroic. I do.
Oh, absolutely. And I think all of it was. Were we supposed to let our communities just get burned all summer? Let people's their whole livelihoods and their dreams just go up in smoke? Let furniture storemen get the crap kicked out of them, as happened in Kenosha on the front of their door? I don't think so. So, I have no sympathy with the criminal sociopath. I consider it sad that it took a 17-year-old to stand up for somebody, because the governor should have had National Guard there. The police should have been present there. Adults in the community should have had their rears out there. If enough of them would have been out there, a lot of these sociopaths would have stayed home. But what a 17-year-old kid did was heroic and was deeply American. And his only crime was his naive idealism that the other people there weren't the sick, criminal sociopaths that they were. And let's be honest, the world is better off that people like Rosenbaum are no longer with us. I have no tears for him.
Let's also face it that the reason he was prosecuted and the reason that all the elitists on the left were screaming for him to be convicted is because they don't want other people to do what Kyle did. They want that when there's looting and there's rioting and there's arson, they want all citizens to stand down, cower in fear, and basically, bend the knee to BLM. That's why they wanted to make this example out of him.
Go ahead, Richard.
Well, I don't think it's necessary to have an analysis of the case where you have to go so far as to say Kyle is someone to be looked up to or is a hero. I don't really have an issue with anybody having their own opinions on these kinds of things. I think what I have an issue with from the legal eagle side of things is effectively the assumption that if you feel very strongly that this is self-defense, which I do, I feel that the acquittal was completely justified, that puts you into a pathology of hagiography of Mr. Rittenhouse. And I think that you can believe that this was a case about a specific set of facts and a situation where we can call it naivete, we can call it whatever we want. I don't love the choice he made to go. I disagree with the panelists a little bit on that. And I think if we're talking about society, I think a lot of people would do worse than Kyle did in the same situation. And I think that's worth considering when we talk about it on kind of the more societal basis outside of things like this video, which should be focused on the trial and the acquittal at hand. So I think my big point is you don't have to go so far as to say Kyle is a hero to believe fulsomely that the acquittal is entirely justified.
Well, completely agree.
I don't think that agreeing that Kyle shouldn't have been there and saying that he's a hero are mutually exclusive, in all honesty, because I agree
can believe
with
those two. You can say that he had no business being there, but then he was a hero when the incident arose.
I've maintained from the beginning of the trial, my son's 14, and in 3 years, if he wanted to go to one of these things, I would pile drive him straight into grounded, forever. No, you cannot go. No, you cannot go. I will lock you in a closet. You cannot leave this house. Whatever it takes to keep my kid away from something like this, I will 100% do because of what happened to Kyle, right? I don't believe lightning would strike twice in that situation. I'd be very fearful for what would happen. So I certainly don't agree with his decision to go. However, we have to deal with the fact that he was there, and the way he conducted himself while he was there, I do think was heroic. So, that's where I come from. Again, my preference is that Kyle stayed home that night. And then subsequently, my preference is that every one of the rioters and looters also stayed home that night. And my biggest question for Kenosha, Wisconsin is, where are the fucking dads? Where are the dads? Why is it in the hands of 17 to 25-year-olds out there? Like the oldest guy out, other than Grambo, the oldest guy out there is what, Ryan Balch? That guy's like 26 or whatever. Army infantry.
I thought Rosenbaum was older. Wasn't he like in his 30s?
Well, look, but that's a perpetrating pedophile. I'm talking about the defenders. I'm talking about the people who went out to serve the city of Kenosha in their own minds. Is like this group of people who like, you know what, we're going to go out and protect a couple businesses and that'll be cool. Where are the dads? Where are the people who are going to stand there? Like, you don't even have to be armed and just stand there and say, hey, knock that shit off. What are you doing? Do you think like Gage Groskowitz is not going to respond to a dad, or Anthony Huber? These guys don't have jobs. They're embarrassments to humanity. They're the definition of neat or whatever. I think a group of men from the community standing outside being like, look, guys, knock this off. I don't think they need the guns. I think the kids, the youthful adults and the kids out there, I do think they needed guns to assert their authority. You get a bunch of 45-year-old men from Kenosha out there to say, hey, what the hell are you doing? Why are you burning down our town? I think that stops this shit away. Oh, and let's just ignore the fact that the police backed off at the orders of the mayor.
And the governor refused to send in the National Guard despite request.
Yeah.
Well, he was happy to do so to try to intimidate the jury during deliberations.
Right.
I would say that Kyle's biggest crime may be that he's like almost every 17-year-old. I think he probably walked in there thinking, I can't die. I think a lot of 17-year-olds just assume they're going to live forever and that nothing terrible is ever going to happen to them. And I do think that that was his poor judgment.
Yeah, he's idealistic about other human beings. That's why he didn't. That's why he was in shock at the whole interaction with Zeminski and the rest. With Rosenbaum, he's like, okay, some people are just off. He thinks most people are good people, and that even if they have different politics, or that they're clearly not there to hurt him. Why would they hurt him?
That's sort of my take too. Yelling friendly at people,
Yeah, friendly for all the time.
As if that's going to stop a lunatic when you yell friendly,
right? But I mean, his only sin was believing in other human beings' decency. That was his only. That's the only thing that put him at risk. Was he believed that most other human beings are decent?
I don't know that I would believe that he had that firm belief because of the fact that he was there to prevent people from doing terrible things to people's businesses and homes and whatnot, right? I mean, so he did have some amount of belief that there are terrible people out there.
What's fascinating is even people that make threats to him, he just blows off. Even people that are doing arson, okay, I'm going to put out the arson. He doesn't see them as dangerous as they are. He sees them almost as confused, misdirected people, not as criminal sociopaths. He doesn't understand them in that sense at all. Sees them as maybe sick people who need a little help, but not scary, frightening, dangerous people who can't wait to be predators and abuse you just for the sake of it, just for their enjoyment of it. That was not a world he understood, and that's why when he goes down there by himself, if he thinks that there are a bunch of people waiting and eager to hurt him, he's not running down there. And that's why he says friendly, friendly, friendly when Zeminski shows him, flashes his gun at him. That's still his reaction. Hey, you're confused. I'm not a bad guy. Why would you try to hurt me? You see him all throughout the night. It's almost shocked that he still has to this day. It was his belief in other human beings that led him there. Okay, we'll help keep things calm and keep a few bad actors from stealing some things and keep a few bad actors from burning some things, but these are criminal sociopaths and violent revolutionaries by their own political affiliations that enjoy violence for its own sake. That was not a world he was familiar with, that he had any understanding of at all. And that was the only thing that put him probably the most at risk that night. Dominic Black was more aware of that. That's why he's staying up on the roof all night. It's also not a coincidence. One point the ship has sailed now, but you look at that photo, there's only two small vulnerable people in that photo. One of them's Dominic Black, who would have been killed that night had been out in the street. He's up on the roof. The only other small guy in that photo Kyle gives away his body armor. This is not a guy who thinks anything bad's going to happen.
Yeah.
He thinks if people understand he interacts with people, that they will reciprocate that. That maybe they'll get a little out of hand and be a little edgy, and they're just misdirected. And this is why he's saying he likes Black Lives Matter and BLM. He doesn't see it for what it is. He doesn't see these people for who they are. To this day, he just sees, okay, a couple of crazy people try to hurt me that night. I mean, he's still very idealistic about other human beings. And that was, but I don't consider that a crime. Well, not only that, I don't consider that a sin. I consider it put him at risk, but that's something the world would be better off if more people saw the world like Kyle Rittenhouse did than definitely with Joseph Rosenbaum's in the world.
And I think that continues with him hiring Lynn Wood too. He didn't really realize what that was.
John Pierce. And frankly, the people who are running his life right now, and David Hancock, who's a bad faith actor, who's behind a lot of this stuff right now that's going on.
Sporkwitch says, cowering is exactly what they want. This is the same ideology of Hegel and Marx. These riders are no different than the Chinese Cultural Revolution that slaughtered on the path to installing the CCP. Read Irresistible Revolution by Matthew Lohmeyer. All right, let's finish this video. I'm pausing it way too much. I'm letting you guys talk on my show way too much. Embarrassing.
The jury didn't think that the prosecution proved self-defense beyond a reasonable doubt. And while you can't necessarily infer it from the jury's decision, it might be the case that Kyle Rittenhouse did nothing legally wrong. But under the most favorable interpretation,
I mean, you can actually infer that from the verdict.
Not only can
that's exactly what you can infer from the verdict.
Yeah,
maybe not morally, but legally, yes.
It's the most logical conclusion that you can possibly infer from the verdict is that he did nothing legally wrong because he wasn't convicted of anything.
Five not guilty suggests that strongly, yes.
Yeah, here we go.
Of the facts, Kyle Rittenhouse brought gasoline to a match party, and people are now...
No, he did not.
No, he didn't.
So after
he
going
literally
through
brought
this
a fire
whole thing,
extinguisher to an arson party. That's what he did. And then he brought a gun to a pedo and a criminal sociopath party that wanted to cause a lot of harm that night. And I'm sorry your pedo pals are dead, legal.
right. And this is something that's kind of frustrating, because after, it's like I like I said earlier, like there are parts where I almost want to agree with him, and then he goes and like twists it. Like earlier, how he was saying how, you know, with provocation, you can't really get there because everybody, you know, he's in an open to carry state. There are a lot of people that have guns there, et cetera, et cetera.
It's good stuff.
But then he goes and says this, which is totally opposite from what he was saying before. It's just
he mixes,
it's very frustrating.
And this sort of crap agitates the crazy Rosenbaums of the world who are still breathing. And this is what makes them go off and become violent, because they feel like, you know what, this kid did bring his kerosene to, or whatever he called it, to a match fight, and he got off scot-free because he's white, et cetera, et cetera. And that's what sets off the real crazy lunatics into doing violent things.
No, I want to back off what you're saying. Like, I don't think that Legal Eagle is instigating a bunch of pedos to go out and murder people. I think what Legal Eagle is doing here is very, very, I'll say he's very consciously energizing his base of supporters and the specific ideology that they have, which I don't think they're the Rosenbaums of the world, right? Like, Rosenbaum uses the internet to look at, you know, naked pictures of children. He's not watching Legal Eagle videos. There's a strong distinction there. The Legal Eagle people are the people you see on Twitter they're these mid to low information people. They get enough of they get their information through a filter, and that's fine for a lot of things. You know, for the majority of your life, getting your information through a filter is pretty okay. But when you're going to espouse commentary about a serious subject like self-defense, you need to get all the facts. And he's appealing to that audience here. I don't think he's actually empowering the Rosenbaums of the world in this case. I think he's empowering the type of people who would call Rosenbaum JoJo because they don't know that he raped a bunch of kids.
And that doesn't roll over. That doesn't roll over with more and more of that into agitating those. When he says this, and he's empowering Pedro Pascal to make his idiotic JoJo things, and that gets people angry that there was never any justice for JoJo. You think that doesn't get someone like that this Brooks guy to go do what he does? Really? Very
hesitant to lay direct criminal horrific acts at the feet of a 3 times attenuated speaker. That's just me, because I say a bunch of things that people like. I've been very critical of specific individuals on my show, and then other people are like, "Oh, you're empowering someone." In fact, an anime voice actor who's a complete fucking cuck, by the way, said that I was. I would be.
Reaction.
Look, I would be responsible for a mass shooting at an anime convention based on my disagreement with some other voice actors, which is absolutely ludicrous. So if I support the position that Legal Eagle here is empowering pedophiles to go out and proliferate violence amongst minors, then I would have to similarly support the idea that me saying Monica Rial is a horse-faced liar is going to support some weirdo going into an anime convention and shooting it up with a machine gun. And I can't do that because it's not true. That's just where I am.
Mostly who he's empowering is people who watch Suits and think it's a really good legal educational show. You know, there was an intern once applied to work for me, and she said, you know, I asked, you know, its favorite legal show. She said Suits. She thought it was really informative. That was the end of the interview. I mean, that's the kind of people that he mostly inspires. Mediocre-minded people who like the pretext of expertise for their bullshit opinions.
No, I think the most nefarious thing about this is the fact that it misleads people to think that by watching this video they have gotten educated on the subject. Mm-hmm. And that they understand the full picture, that they understand the you know what the trial was about, you know, how the jury reached their conclusions. That is the most nefarious part about this, because then they walk around thinking that they've got the full picture, and that they can that they can have discussions based on that.
And I think that the nefariousness here comes from, I take great pains when I'm doing a legal video to say, here, here's the stuff. And if I'm going to editorialize, I basically disclaim it. I mean, I have a sentence that says, all right, and let me talk about how I feel about this, which is what he's done. The transition here is now I'm going to talk about bringing a gasoline to a match party, right? Which is completely superfluous to the Kyle Rittenhouse trial. But if we assume he's just being honest about himself, he cares about this. He cares about how it looks. He cares about vigilantism. He cares about whatever else he cares about here. And there is no delineation. So what you get is this notion that the law might have led to acquittal. But my God, isn't the system broken? Isn't the law terrible? Isn't something fundamentally unwell? Because we know all of these injustices. We know matches and kerosene and whatever else I'm going to talk about right now, which is a little bit more for another couple minutes. And that to me is essentially violative of some ethical code of, if we're making these videos, separating out the legal concept, that educational concept, from what I want to talk to you about and what I feel. Because you didn't have a bright line, and now you think maybe you're still talking about the law.
Yeah, I think that's very apt. Okay, back to the go ahead.
Nick, I just want to respond to what you're saying, because you actually made me think through my earlier comment, and I thought that you displayed remarkable intellectual integrity by basically
especially since I'm like 7 whiskeys in.
It's very impressive. It's very impressive. And I was actually thinking about your comparison to yourself, talking about Monica Rial, and that's not instigating any sort of violence against her. So it would be unfair to flip it around 180 degrees on Legal Eagle and accuse him of doing something of that kind. The distinction that I would draw is that when you're talking about Monica Rial, you're not talking to a crowd who's looking to go out and lynch her, as opposed to over here, we're talking about a situation that there is this ongoing, festering friction that has taken violence, taken form and manifests in the form of violence, in the sense of, and the whatever percentage of BLM protests have become violent looters, arsonists, rioters, which is not something that we're seeing with respect to Monica Rial. So if you say something like that about something, that's not something that would foreseeably manifest in a way that would be somewhat violent and potentially dangerous to other people, as opposed to what we have seen from mainstream media and this constant stoking of divisiveness and justifying and saying that that claims that there are no justice here. That is exactly what has become the rallying cry of the fringe lunatics. And I'm not saying at all that all the BLM people are fringe lunatics. I think probably a good percentage of them are good-hearted people, but there are amongst them some psychos. And accordingly, I do think that constantly stoking up the division and saying there's been no justice here, I do think that we've seen how that manifests, as opposed to the stuff that you're talking about, which has never manifested. And that, I think, is a great distinction.
It's a great distinction, Joe. And I think you have made a prima facie or a facial case of abuse. And in fact, if people want to learn more about it, facial abuse in their Google might actually get there. Facial abuse brought to you by Timcast IRL on YouTube. Here we go. Back to the video.
Dead as a result. He made a bad situation worse. And let's face it, if someone uses non-deadly...
Fucking damn it. He did not make a bad situation worse. Why? I just spent beautiful political capital equating you to me. I took you and I lifted you out of the sewage and filth that your suit was in, and I'm like, no, you can hang out with
Monica
me.
Rial and make a bad situation worse now? Is that
shining
what you're
angel?
Nick, I gotta be honest. Where did you think the gasoline and match party analogy was going?
Look,
he's 7 drinks in. He didn't think it through. He's 7 drinks in. He didn't think it through.
I'm throwing this man a lifeline, and he is refusing to take it.
Force against you while you are carrying a gun, it's more likely to turn deadly. Rosenbaum, Jump Kick Man, and arguably Huber used non-deadly force.
Wait,
what? See, I told you. I warned you this was coming.
Okay, let me just say this. Jump Kick Man, a kick to the head of someone who is on the ground is deadly force, not 9 times out of 10. Literally 10 times out of 10. I will give you with confidence in every state this legal advice. If you are on the ground and someone is kicking you in the face, you are 100% justified in deadly force. And I will gaslight and challenge anybody to find a case where someone is being kicked in the head while on the ground and uses deadly force and goes to prison for it. I don't care how much provocation they do.
But that's the beautiful part about leaving out that fact, right? About leaving out the fact that he was actually kicking him in the face. All he said was jump kick man kind of like jumps over him.
A half
like,
jump
you know,
kick. A half jump kick.
Yeah, it was
because you can have a jump kick apparently.
So, you know, if you just ignore that fact, then yeah, you can say it's not deadly force.
Just, hopping over.
For the record, Hoglaw doesn't endorse 2 a.m. legal advice. From Miss Cicada.
Especially while 7 whiskeys in.
While 7 whiskeys in.
2 a.m., 7 whiskeys. I don't care. Sue me for malpractice all you want. If you are on the ground getting kicked in the head, you shoot the motherfucker kicking you in the head. I will defend you for free if you take that advice. And I don't care how many pro hoc vices I need to get in what forum. We're going to win that case. Jesus Christ. Here we go.
Which would not in the abstract trigger a reasonable belief of imminent harm.
And just real quick, Rosenbaum also, hands and feet kill more people than rifles every single year. Hands and feet are absolutely deadly force. The question is, are you subject to serious bodily injury, which is any level of head trauma or any permanent disfigurement or any broken bone? If someone stomps on your fingers and breaks them, they are technically engaged in serious bodily injury. Now, I wouldn't take that one to the bank, but a broken arm, a broken upper arm, a broken femur, a broken tibia, based on someone snapping your knees. I mean, you're talking about serious the things you would go to a hospital for immediate treatment are serious bodily injury. They're built into the standard. This idea that fists and feet are not capable of serious bodily injury is nonsensical and frankly ignorant of self-defense law in every jurisdiction.
Yeah, actually, a little side note there on the Arbery case, they specifically made that instruction today that fists can cause serious bodily harm and are grounds to exercise self-defense. Of course, one other caveat that he, of course, ignores, legal schmiegel, all 3 people when shot were armed, in my opinion. One was trying to grab the gun, may have had his hand on the gun based on the nature of the wounds. The second person did have his hands on the gun at the time he was shot.
After using a skateboard.
And after the skateboard. And then the third person, of course, had a gun himself. When you grab somebody else's gun, you're armed. I mean, that's so all 3 people who were shot, in my view, were armed with actually dangerous weapons when you're grabbing somebody else's gun. Because
But they had a strap. He had a strap. It's impossible to take it away from someone with a strap. How can anyone possibly do that?
From the
never in history has a strap been compromised.
And from the same people, I mean, the good thing with Huber's, with the way Richards went through it, you can see that gun's going away and away from Kyle. How much longer, if he hadn't pulled the trigger when he did, what would have happened is anybody's guess. But that's the other aspect. I mean, these guys were, of course, armed by the way they were using their physical force, but they were also literally armed by the law, by their grabbing the gun, which he's managed to completely pretend didn't happen throughout this entire.
He hasn't mentioned that ever. Here we go.
Harm, which is not to say that unarmed people can't exercise deadly force or create a reasonable belief of imminent deadly harm. They absolutely can. Indeed, it appears that the jury believed Rittenhouse's testimony that they were going for his gun or grabbed his gun in an attempt to take his gun.
It wasn't just his testimony. There's photographic evidence of them grabbing the gun, but
and also other witnesses' testimony.
Yeah, specifically Richie McGinnis, who the state used as a witness and to write their complaint. Here we go.
And use it against him, and in a huge stretch in Rittenhouse's speculation, take his gun and use it against others.
That's not actually a huge stretch. That's not a stretch in any means, because even if they're using it against Rittenhouse, if they're using it against Rittenhouse recklessly, for example, then it is used against others by definition of the reckless endangerment standard that they tried to apply to Rittenhouse, even though every bullet that he fired quote unquote recklessly at Rosenbaum, hit Rosenbaum, and then the only other two didn't hit anyone else at all. So
and if you wanted a profile of an active shooter personality psychologically, Huber and Rosenbaum are the kind of personalities who do in fact fit it in terms of the possibility of escalating violence. They had been escalating violence all night. They've been going higher,
and their
higher.
entire lives. Don't forget that.
Yes.
But okay, here we go.
Now, those arguing that but for Kyle Rittenhouse being present with his gun, these shootings wouldn't have happened are right. However, but for causation, or what we call sine qua non causation, doesn't rise to the level of guilt.
What? I mean, just you learned a few Latin words and you're just going to randomly throw them in? You fucking idiot. This guy is such a, what we call sine qua non.
What we call
oh my God.
Yeah. For the record, guys, lawyers do not use sine qua non. They would just say but for.
Ever.
Yeah.
I've never heard any
like
lawyer
literally
say that.
we have transgressed or transversed or whatever from sine qua non to but for causation, and every lawyer on the fucking planet that speaks English in the United States would say but for. We would not say
Also
sine qua
Canada.
non. And yes.
If a lawyer ever said to me sine qua non, that would be like saying petrificus totalis, because I would be locked, stock, stunned. Like, really?
I mean, it's just a lawyer trying to pretend that he has this special lingo and language to show off his fake pedigree. Though I got to give you credit, Nick. You're great at where you pause this, because this is another great legal future thumbnail.
I'm going to have to go back through and just make a montage of all of his stupid faces. Everywhere that I find that he has taken a moment to, or that we've taken a moment to pause. But okay, here we go. We got to, I got to let him talk.
Poor Richard.
Beyond a reasonable doubt. It's necessary for a conviction, but it's not sufficient. Now, I've seen lots of people say, quote, the jury reached the right verdict. Now, there is a strong version and a weak version of that statement.
No, there's only one version of that statement.
Weak version is that the jury was correct to find that there was reasonable doubt that Kyle Rittenhouse didn't use self-defense. However, the strong version is that...
What?
He just
I
got
don't know
that
why he
wrong
calls it the
because
weak
he's an
version.
idiot.
Yeah.
Anyway.
I don't know.
The jury proactively found him innocent or even a hero. But assuming we're going with the weak version, it's entirely possible that the jury...
He has created a false distinction between these two versions. These two versions don't actually exist.
They don't. Let me tell you a story.
Yeah.
So if you go into that Twitter thread I had with him, I talk about this. I say that you admitted that that the acquittal is right for all practical purposes from a lawyer. He goes on for a number of tweets talking about the fact that, yes, that's accurate, give or take, but that no one can say whether or not the metaphysical truth of self-defense actually existed on behalf of Kyle Rittenhouse.
What does that mean? What does that mean?
I don't know that I responded to that particular tweet, but what he's aimed at is this notion that human beings can't know really whether that was self-defense or not, and that a reasonable mind could believe that it's not, and yet still hold fast to the fact that the prosecution didn't meet its burden.
I mean, do we want to get into like Plato and like whether a chair is a chair, like the chair,
it's philosophical,
like, or like different versions of a chair? Like
it is fully philosophical as a
Look,
stance.
we're past 2 hours, so I'm going to use a slur, but I think it's appropriate. That is an utterly retarded comment. The idea in this case that we cannot discern that the jury found self-defense is nonsensical. There is no world in which the jury exists with the facts of the case presented to them that they think anything other than self-defense is an acquittal for Kyle Rittenhouse. Again, we talked about this a little bit earlier. No jury thinks he didn't pull the trigger. No jury thinks he didn't point a gun at someone or have the gun point at him and consciously make the decision to fire a round in some state. In fact, you would have to disbelieve not only Kyle's testimony that he acted in a way to stop the threat that he was having come at him, and that he stopped the threat utilizing consciously deadly force, you would have to disbelieve every other piece of testimony and every piece of video evidence that was introduced to determine that the jury came to any other conclusion than self-defense. That is a ludicrous misstatement, and it doesn't comport with reality in any way, and he should be ashamed of saying it.
I agree with everything you just said. Just never go full R, okay? Never go full R.
Look, sometimes things are retarded. So there we go. That's not derogatory to anybody who is mentally disabled. That is derogatory towards things that are retarded.
Towards legal.
Here we go. Look, I'm using it in the French way, right? I just mean late to the party. Here we go.
The verdict accurately reflects the law of Wisconsin. I've never seen a politician run on a platform of installing a duty to retreat in the law. If Wisconsin had a duty to retreat, the outcome of this case very well might have been different. Stated differently, if this...
No, it would
he
not.
Was running.
He exercised his duty to retreat throughout the entire encounter.
At no point in any of his interactions can you look and say, oh, there's an opportunity there for him to have done something different.
And it ignores the reality of the jury instructions, which literally include what he defined. I took umbrage with his definition. I said there's this distinction there, but Legal Eagle defined the jury instructions as including a duty to retreat. That was point 3 that he put earlier. It's got its own subheading and graphic. He says point 3, a duty to retreat. Again, I take a minor nitpicky exception with the language that he used, but he ultimately intimated a duty to retreat in the law as part of self-defense. That was applied in this case. For him to come out now and say that a duty to retreat would have changed anything, no, the provocation instruction includes the duty to retreat. If the jury had found provocation, they must have necessarily excluded the duty to retreat at that point.
Dominic Black and this 323.
So here we go.
I came late. Did he say that he didn't watch the video or watch the trial at all? Or
No,
he is not mentioned either way, but yes, that is a reasonable inference. Here we go.
Had occurred in Massachusetts, the law could have militated a different result, though admittedly, maybe reasonable minds might differ on that as well. Maybe Kyle Rittenhouse retreated at every possible opportunity. But I will leave it to you and by proxy your politicians as to whether that is a good thing or a bad thing. Though I'll point out that for those that are happy that Kyle Rittenhouse was found not guilty, they should recognize that logically, they should also be in favor of an alternate reality where Gage Grosskreutz shot and killed Kyle Rittenhouse.
No, not necessarily, but we must consider the possibility that Gage had a colorable claim of self-defense, albeit not necessarily the same level of claim. And he may have had the same level of claim, but this is a different factual question that was not fully explored by the jury trial and cannot reasonably be ascertained to the same degree because Gage was not on trial. This is a false equivalence or false dichotomy. It is a logical fallacy, and he should not be intimating it here.
And we've had that vote here before.
The actual facts would militate against Gabe Grosskreutz having a self-defense.
Don't you
and that
use
would also
militate on this stream. Oh,
and that would also be a proper use of the word militate, which he managed to also butcher just a second.
Here we go. Agree with any of that.
Here we go.
Baum, Huber, or Grosskreutz all provoked a response from Kyle Rittenhouse. Rittenhouse's use of deadly force probably gave them the right to use deadly force right back.
Again, probably, but here we have this interesting thing where he's creating facts that were not actually in evidence. We don't have any idea of Huber's state of mind at all. We can only come to the inference that it's possible that Huber thought he was rushing towards an active shooter. But since Huber's dead, we don't have any testimony. He didn't text anybody as he's running at Kyle Rittenhouse with a skateboard. He didn't talk to anybody. So we don't know. And maybe that's unfortunate, but it's reality. We can't make any assumptions about Huber's intent in regards to Kyle Rittenhouse. Gage Grosskreutz did testify in some way that he thought he was reacting to an active shooter. But more importantly, Gage Grosskreutz testified that he initially approached, and this mitigates that, he initially approached Kyle Rittenhouse thinking that Kyle was in danger from Anthony Huber. And to ignore the absolute crippling and devastating fact that Gage Grosskreutz, an EMT who is opposed to Kyle Rittenhouse, feared that Kyle Rittenhouse would suffer serious bodily injury in the form of head trauma from a skateboard attack from Anthony Huber. To ignore that bombshell fact from the trial is to ignore one of the most critical elements of defeating the self-defense claims of, or reinforcing the self-defense claims of Kyle Rittenhouse against Gage Grosskreutz. He did not, or against Anthony Huber and then subsequently Gage Grosskreutz. He did not say that he was chasing down an active shooter. He said he was chasing down Kyle Rittenhouse to protect him from the second guy that died, which is the fact that came out at trial from Grosskreutz is an embarrassment to Binger and Krause. Here we go.
Under the same laws. Under current Wisconsin law, if Kyle Rittenhouse is not guilty by reason of self-defense, Gage Grosskreutz would also have been not guilty if he had shot and killed.
You can't say facts. That. You can't conclude that. You can say, you can claim that. You can say that he can make an argument, but you cannot conclude that based on the facts that we have in front of us.
Or based on the fact that he said on video, I'm going to the police, and Gage on the stand said, I heard him say, I'm with the police, in which case, why the hell is he trying to shoot the police? So.
Yeah.
And his own admission is he couldn't say he has probable cause that Kyle committed a crime in shooting Huber because by his own admission, he saw Huber as threatening and attacking Kyle, and that was his reason for going forward. Of course, with Huber just might have confused Kyle with one of his family members because he had a history of attacking and threatening his family members.
His last words, and those of you who think that, there's no evidence that Huber was trying to stop an active shooter, right? His last words were like, I thought he was an active shooter. That's probably what would have come out on
his last words were actually, I thought he was my brother and he wouldn't clean the fucking house. Here we go.
Kyle Rittenhouse. And keep in mind that in this scenario, Kyle Rittenhouse is dead, and it would have been Grosskreutz setting the narrative. And to the extent that you think Grosskreutz would have crafted his testimony to support an argument of self-defense, consider that Kyle Rittenhouse probably crafted his story in exactly the same way.
His story.
Except for the fact that the crafting of Kyle Rittenhouse's story comports exactly with the numerous, not only not beneficial, but not even adversarial video accounts of what happened.
You could maybe say that there's a chance that he crafted his story if there was no other evidence to support it, right? If it was just a he said trial and it's just
how dare you assume their genders, you bigot.
Well, no, I'm saying in this case, it's two men, right, that are involved, Gage Grosskreutz and.
Look, I don't know if Gage is a man.
You're still assuming.
Okay, well, anyway, whatever.
Very, very rude. Okay, here we go. We're almost done.
So the ultimate takeaway here is that these incidents are murky at best, occurred in a jurisdiction with very broad self-defense and firearm laws. The prosecution had a very high standard to meet, and while we didn't cover it in this video, the defendant put on a very good defense. The rest?
He did not.
Yes,
the defendant did not put on a very good defense. The self-defense laws in Wisconsin are not very broad. Actually, they're shockingly unbroad for a state that does have, he's right, they have very broad gun laws. They do not have very broad self-defense laws. It's not like Mississippi or Alabama or Texas, which have strong stand your ground laws. I think Florida and Louisiana both have pretrial dismissal motions built into their statutes for.
Yeah, I think Andrew said he thought Wisconsin was middle of the road. I think that's what he described it as.
It's par for the course. It's like 40 other states have as generous self-defense laws as Wisconsin. Massachusetts is the outlier. I mean, though I would say the only thing you could definitely prove in this case is that I think Legal Eagle's eyebrows are taped on.
But what you want is a stand your ground law akin to Texas or Florida, where you have a pretrial motion to dismiss in which all you have to do is show by preponderance of the evidence to a judge, not a jury, that you have made a colorable claim of self-defense. And if you win that with no duty to retreat, if you win that pretrial motion, the entire case is dismissed without ever going to jury trial, without presenting witness testimony or anything else. You can do it entirely on the affidavit of the defendant. And that's an amazingly different scenario than what you have in Wisconsin, in which if you shoot someone, you're likely to go to jury trial with no motion to dismiss, no motion for a directed verdict. And like the difference in that is astounding. So, okay, sorry, here we go.
I will leave to you. Now, if you'd like to watch something legal that's much more lighthearted, I'd recommend my mini documentary Bad Law Words Good, where I explore all of the most common legal and linguistic comments that people throw around in everyday life incorrectly. It is a hilarious and educational.
Do you cover your incorrect usage of words? I mean, that's what I want to know.
Romp through legal misunderstandings, logical fallacies, and law and order.
Oh, Jesus Christ. I got to stop. I'm done. He's done with talking about Kyle Rittenhouse. I'm done. Like, I'm going to burst into flames if I keep listening to him talk about that video. Okay, to the pen.
And something that just drives me mad here is where he's sort of going, oh, crafting the story. We saw the cross-examination. Like, we saw Kyle hold up under a cross-examination that was the best Binger could do. Maybe not the best cross-examination I've ever seen, but Binger was giving it his all. Like, he was trying real hard. And we also saw Grosskreutz just fall apart. There was nothing left of him. He got demolished. So if we're talking about like who's crafting a story here, it's not like these two are standing as equals in this field. Grosskreutz is clearly on top of, Mount bullshit.
And it's impossible to know what happened in the jury room, but it's important, if you were to go to an appeal on this issue and you were to say, like, let's say Kyle gets convicted and you appeal and say, or you make a motion for a directed verdict and say, or JNOV, I guess, and you say no reasonable jury could conclude this. One of the biggest bullet points in your motion is the fact that the state's witness, a complaining witness and an alleged victim, says that he didn't shoot me until I stepped towards him, drew my gun and pointed it at him. Like, that is the that is your highlight in the JNOV on that issue. Is there's no way a reasonable jury can conclude that he assaulted with a deadly weapon Gage Grosskreutz, because he laid out in his own testimony as a state's witness, as a complaining witness, elicited on cross-examination, that he was in fact the perpetrator of that act and that the defendant was acting in reasonable self-defense. So, again, it's exactly what Runkle is saying. Kyle Rittenhouse went through cross-examination. You can't say that he crafted his story because the state was allowed full cross-examination. In some states, you might get a limited cross-examination. You may get a limiting instruction that says you can only do cross-examination based on the issues that were raised in direct. That might be reversible error, but a judge could in fact do that. You could limit the scope of cross-examination. They didn't do that here. In fact, the judge warned Kyle Rittenhouse prior to him taking the stand, if you take the stand, I am not going to limit in any way cross-examination. You will be fully open to any question that they ask outside of the pretrial motions that have limited character evidence and such like that. So to intimate that these people are on the same footing is absolutely absurd. It's a misstatement of law and reality.
And it also ignores the fact that Kyle's facts are also corroborated by video and by other witnesses that, for example, he didn't actually know. Like, he didn't know Richie McInnes. He didn't even know Balch, right? Like, he had met him that night and hadn't spoken to him since.
And by the medical examiner evidence in terms of the conduct of Rosenbaum.
Yes. So nothing about the medical examiner talking about the soot on the hand and nothing. And that the fact that he didn't talk about any of those witnesses, any of those expert witnesses, really leads me to believe that he did not watch any of the trial.
No.
If
well,
the
that's why he
defense
thought
rests,
clothes. He thought Rosenbaum threw a bag of clothes. I mean, the guy,
if the defense-
he's legal. He'll always be legal, Schmiegel. I got to opt out. Thanks, everybody. It was fun.
Robert,
3
the 2 a.m. Robert Barnes is the best Robert Barnes. This is like a whole new level.
Look, vivabarneslaw.locals.com. Guys, go check it out. The link's in the description. You get fantastic stuff from Robert Barnes and Viva Fry. Like, that's a twofer. It's almost unfair. It's like cheating. It is cheating. Don't subscribe to them.
How can we compete? We can't compete. That's why we took them in. So that
I
we're
can
not competing.
look. I can compete because I do naked hot tub streams, but I don't know how you guys compete.
I do not do that.
I'll take that under advisement, I suppose.
I most definitely do not do anything close to that.
Yeah. All right.
Look,
well, it is 3:40 a.m.
Get out of here, buddy. You've stayed way past what I thought you would.
It's funny. In the back of my head, it's like, I'll stay till 1. I'll stay till 2. How much longer can this video possibly last?
And that's how I ended up spending all of trial watching or streaming with this channel until 4 a.m. most mornings.
Timers. And it's like, well, I'm enjoying the conversation. I do want to thank you for letting me play a little devil's advocacy here. As I said, the back half I thought was significantly worse than the front half.
No. And I'm glad you were here doing the devil's advocacy because one thing that's critical is Legal Eagle does make some very good and salient points in this video. He gets a lot of the law right. The problem is as you've said, even as devil's advocate, the places where he gets it wrong is this is a lay audience. He knows he has a largely lay audience, and he has some duty to go ahead and express the correct interpretation of some of these laws, or at least provide the surrounding context and clarification to be a little more careful with his words. And that's a valid criticism for a guy whose channel is as big as it is. And he has the resources to make, he to his credit, he presents an air of non-political video. Like, for the most part, he does. And
especially if you're not paying attention to like the overall kind of broader set of videos that he's making, because I think certainly over the course of the end of the Trump administration and things, it's like, all right, okay, I get where Legal Eagle is coming from, which is fine. But yes, that might be me. I get so concerned about leading people in the wrong direction. If you follow my channel, one of the things you'll hear me say is don't just take my word for X, Y, or Z. Go look at Legal Eagle's video. Go look at Nick. Talk to other people, because lawyers have differing perspectives on all of this stuff. But I also try to make it very clear when we've left analysis and gone into perspective land. And that happens quite often, right? I'm doing a lot of corporate messaging analysis. I'm speculating on, reading between the lines on things, and I try to tell people that. But that's what really bothers me, I think, about especially the back half of that video, is just eliding that difference, suggesting that there is veracity in what are largely his opinions, which he's allowed to have, and which probably mirror his audience base, but not separating out what I think it's clear in subtext he's arrived at, which is that looking at all of this, acquittal seems right. I think even he would say that's the truth. And then he analyzes why that feels wrong or whatever he wants to do. But
it's interesting that he doesn't end up saying that, right? Like, he leads you all the way to the trough, and he doesn't ever say, now drink from it, but think about the world in which the trough doesn't exist.
He doesn't. He doesn't separate it. There's no other way to read that paragraph about it. Reasonable minds can think both, and if that's the case, the prosecution can't win. But he doesn't say the words. That's absolutely true.
Yeah.
All right,
buddy, I really appreciate you being on.
This was fun. I don't know how much I can do the late nights, but this was fun.
Well, again, I'm going to be doing a live show every weekday, 1 p.m. You're welcome to all of them, any or all of them.
Right?
So 1 p.m. Central Time. Yes.
And so remembering that.
Look, I'm going to send out the invites into our chat.
Great.
So
thank you for having me. I'm going to go to sleep.
Go get some rest, buddy. I really appreciate you being on here. Thanks. Guys, everybody go subscribe to Hogue Law, Virtual Legality. You will not find legal coverage like that anywhere else. And thanks a bunch.
Thank you so much, guys.
Later, Hogue.
All right. Now, we need to talk about Dominic Black.
Yes, everyone's been waiting.
I know. I was supposed to talk about it on Timcast.
And it's like 3.5. I waited 3 hours and 40 minutes.
So Dominic Black had a hearing yesterday. Dominic Black is, of course, he is charged with 2 counts of the same crime. Dominic Black is charged with illegally providing a minor with a firearm. And it's under the exact same statute that Kyle Rittenhouse was charged for the illegal possession of a minor of a deadly weapon, right? It's the same statute. The exception to the language in 3C is the exact same, except the 2 clauses are reversed. So it has the hunting statutes first, but then it says or in the same way, the long barreled versus short barreled distinction. So it's substantively the exact same law. However, it's the criminal act is to give a minor a firearm or a deadly weapon of any kind, right? That specifically that ends up causing death elevates it to a class like H felony or whatever stupid felony lettering system that Wisconsin uses. Now he's been charged with 2 counts of it because 2 of them ended up in fatalities, even though that is probably not the proper charging, right? The proper charge. There was
still one gun that ended up in 2 fatalities. That should be one charge.
There's one act of me giving a gun to someone else. Yeah. The fact that they used it for 2 homicides doesn't equate to 2 charges under my read of the law. But that's
well, why
Thomas,
is this not? Why is not a directed? Why is this not summary judgment the same way that Kyle got it?
That's Thomas Claire Binger, who is the prosecutor in this case, is interpretation of the law, and Judge Schrader is a judge of this law. Now, Joe, you ask a very good question. So he had a hearing yesterday, and at that hearing, they discussed exactly what you're talking about: dismissal, right? Dismissal on the grounds that this law was, or that this particular set of facts, it's the exact same set of facts.
This gun is an exception. It's basically this gun is an exception to the law and you can give it to anyone who's 16 or over based on the statute.
Now I'll tell you why it was not dismissed yet. Dominic's lawyer has not brought the motion yet.
So it's going to happen.
Can you imagine though, like not bringing that motion the day of?
Is he represented by Richards or
no? He's not represented by the parties involved, and we won't get into the reasons for that. Personally, I think they should hire Sheriff Easy since he successfully argued the underlying motion in Rittenhouse's case. But I don't know. I don't know if there's conflict issues with that. I think those conflicts would be resolved at this point in time. Personally, like it to the extent that a conflict may have existed prior, I think now that Kyle's case is over, there would be no significant conflict between Dominic and Kyle now. But I wanted to ask the panel, do you guys see any apparent conflict in like a Sheriff Easy representing Dominic Black and Kyle Rittenhouse now that Kyle's case is adjudicated?
I mean, typically with criminal cases, I think you can't represent more than one defendant in one case, right?
No,
but I mean, I don't
not
know if
that simple, but as a general rule, that's a safe.
It's generally a bad idea, generally speaking, at the very least.
Here's a theoretical situation.
But I think,
I'm sorry.
hold on, I think in this case, maybe because of the fact that Kyle's case is already ended, like unless there was some sort of information that between the 2 of them that's bad for Dominic that he would have learned through representing Kyle. Like that's the only thing that I could really think of.
Yeah. So
Joe, go ahead.
Maybe there's a defense that Dominic Black would have that Kyle stole the gun without his knowledge. He didn't realize that it was the gun that he had there in the safe. That maybe that's, for all he knows, Kyle took the gun from somewhere else. It wasn't his gun that Kyle took. And for Sheriff Easy to have Dominic Black make statements to that effect, that would be imputing some sort of culpability on Kyle, which has not yet been raised. And
but
as
that's gone now.
his former client, let's say now Kyle, let's say there could be charges raised against him that Kyle stole the gun.
But you'd already check that, right? Like you talk to them, and if you were considering hiring them, and be like, "Hey, is this a possibility?"
What I would say is, I think it's okay, but you should get a CYA letter from
yeah. Oh yeah, yeah.
You get a cover your ass letter from Kyle. But yeah, and I don't think that's going to happen. I don't think that's going to the way the plea is going to play out. In theory, that's the only problem that I could see, is that he might finger point at Kyle, and that would look bad. That as his former attorney, now he's going to have a new client who's pointing a finger at his former client. So that's the only thing I could see.
So there's two issues here. One is in a criminal case of an apparent conflict, waiver does exist, right? Like you can provide both parties knowledge of the apparent conflict, and those parties can waive it. That's not an absolute bar to a conflict existing, but it's a bar to most conflicts. And then the second thing to consider would be the possibility of those federal charges that we've talked about. I'm not sure what those federal charges would be. And without the feds actually making federal charges, we wouldn't know. But if they were to somehow come up with a scheme to charge both Kyle and Dominic Black of a federal gun trafficking charge, I could see maybe a conflict there, but I don't think it's readily apparent. So that's a possibility. But let's get to the news. Yesterday, they had a hearing. Binger is the attorney. Binger walks in. This is maybe the most offensive thing. Binger walks in with a neck scarf on. I have to look. We have to focus on the fact that he's wearing a neck scarf of some sort.
An ascot?
But like,
an ascot?
I don't know if it's an ascot, because like an ascot goes down right into your jacket, but a neck scarf to me is like in Greece when the women have like the little, like the ties on the side. What? And with Binger, I frankly don't know which one he's got. But he comes in, he's gussied up, and he's got a little swagger to him, according to my source. He's got a little swagger to him. And
are we getting pictures? Are pictures coming?
I don't have pictures, unfortunately, but you don't need them. You can see it.
Yeah, I can see it in my head.
Here's the thing. They talk about this issue, and Binger says to the judge and defense counsel, if you dismiss these charges, I will appeal your read of the statute. And for whatever reason, I wanted to get y'all's opinion on this. The defense attorney decides at this point not to file, but to rather continue. Now, I don't know if this is the defense asking for the continuance, but the hearing gets continued until January 10th of 2022. And the motion to dismiss is not actually made. What do you guys think about that?
Why? I guess maybe he just wants to make sure he's really sure before he pulls that trigger, just in case it gets. But why not make sure, make him take it to appeals.
Yeah, that's what I say. Make him take it to appeals, because if the state is gonna, first of all, he may be bluffing. He might be bluffing on this. Second of all, if he's gonna appeal it, he's gonna appeal it whether you do it now or whether you do it later, right?
Well. And it's always better to be the previous winner on an appeal. So why not say, hey, sure, yeah, let's go to appeals, and you can try to overturn the verdict. I don't understand why you wouldn't bring it. I'm not seeing it.
I'm asking you now. I mean, couldn't he appeal the verdict? You're saying he's going to appeal the Kyle decision as far as the Kyle dismissal.
No, he would appeal the Dominic decision if the judge were to go ahead and dismiss Dominic Black's case.
Why is he not going to appeal the decision on Kyle? To dismiss
I don't think he can.
Why not?
Yeah, that's a decision by the jury.
No, I'm talking about the charge that was dismissed, the sixth charge that was dismissed. He could still appeal that.
No, maybe he would. Maybe he would go ahead and appeal it. If you guys want to talk for just a second, I got to go to the bathroom. I'll be right back.
Here we go. We're not getting the music because I missed this song. I wanted to hear this song. Did you know he has a song?
I didn't know he has a song.
He has a bathroom break song. That's like someone wrote for him the music and the lyrics. It's like you're sitting here watching Ricada stream and he's busy streaming in his bathroom or something like that. Like it's like talking about him taking a whiz and now he's forgetting to wash his hands. It's like this whole long 2.5-minute thing that one of the geniuses in his audience here created
That's
for
awesome.
him. And that is
I feel like that's probably not what he wants us talking about right now.
He totally does. Are you kidding me? Are you kidding?
I mean,
have
he
you just
does
met
actively choose to put that song on, though, right?
Yeah.
Like no
Yeah,
one's forcing him to do it.
It's really great. So this is Ian. So you've seen me do the whole shill thing. He's not here now. This is the time. Legal's tried her hand at it. Honestly, she's kind of schwach.
What do you mean? Have my hand at what?
The whole shilling thing. The whole shilling for others. Shilling for others. This is an art form. So I want to see how you guys. We should have a shill off. Which of you two can shill for the three of us best?
I might have a tough time with that. I'm not a great shill.
Oh my gosh.
No, I mean, no. I mean, this is the way that I like to say it. I like to say, hey,
here we go.
If you're watching this and you're enjoying this and you want to see more content like this, it makes sense to subscribe and to hit the notification bell so you can see when more stuff like this is coming out. That's how I do it.
I tried to stop her. I tried to stop her.
I leave and I'm like, oh, here, discuss this deep issue with Dominic Black, and I come back and I'm like, there's shilling of channels going on. What the hell is happening?
No, okay, good logic,
You're such a
Mr. Joe Neerman. No. He tried to get people. He tried to get us to do a shill off to see who could have the best shill. And Runkle was like, I'm not comfortable with doing that. And I said, well, I'll just tell you how I try to get people to subscribe.
Here
to
we
my
go,
channel.
guys. Don't listen to
content
my
first.
ridiculous panel. These people, listen to me. You're here. This is my channel. Listen to me. Go. Subscribe. Everybody's links are in the description. Go check them out. Legal Bites, you're streaming at 11 Central tomorrow, right?
Yes, noon EST.
So you can go look. If you subscribe to Legal Bites right now, tomorrow when she's streaming, it'll pop up in your little subscription feed and you can go check it out. I'm going to try and make at least part of that show. It fully depends on when I'm awake. You guys got to go check out Good Logic. He does a show right before mine, 9 p.m. Central Time. If you have the evening off, you can start with Joe and finish with me. And Runkle, you got to subscribe to Runkle.
I'm like the warm up. I'm like the priming horse. You start with
You're the
Joe.
opening act right there.
You start with Joe and finish with the stud breeder.
Now, Runkle, do you do a lot of streaming or do you mostly do video on demand stuff?
Mostly video on demand stuff. I need to get into the streaming more. I did sort of a first experimental one a while back, and I enjoyed the heck out of it, which I didn't know that I would. But and then I've been doing this, and I've been enjoying the heck out of this. So yeah, I got to do more of that. But most of the stuff up there is video on demand, and I got to catch up on some of that because there's a few issues that I'm behind on.
Let me set up your unemployment date for tomorrow. Tomorrow, you're going to go at 11 a.m. Central Time. You're going to watch Legal Bites. You might see me. You might see some other lawyers on there. I don't know who's going to show up. It's going to be a great show. Whoever shows up, it's going to be great. And
at the very least, I will be there.
You're gonna, yeah, right. And you can go simp for Legal Bites and in her chat rather than mine, you disgusting degenerates talking about feed all the time. It's really gross. Then after that show, you're going to smoothly transition into my show at 1 p.m. Central Time tomorrow. And we're going to have various lawyers and panelists on as well. We're going to be discussing a whole lot of interesting topics. And look, you're going to be unemployed by the end of the day because you're going to be so enraptured by what you're watching. You're going to be like, oh my God, this is great. This is beautiful legal content all day long. I don't even need to go to work anymore. And these guys will represent me in my unemployment claim, to which I say, no, we won't, but we can probably refer you to a competent unemployment lawyer. I do want to share this real quick. Look, guys, Dominic Black has got a bad rap. And I've been saying this kind of from the start. People were like, oh, he testified against his friend, his brother. And that was my initial impression too. It really was. I was like, why is he testifying on behalf of the state? Why aren't these things going on? But as I watched his testimony, I watched this kid, and he's up there and he says what he needs to say. This guy's terrified. The felonies he's charged with, we're talking several years in a Wisconsin state prison, not county jail, not some community service time. He's facing prison time, and Binger is an unethical piece of literal fucking garbage. I don't care. Look, I'll mitigate a lot of what I say about various lawyers. Binger is garbage, and I will not back down from that. And if he wants to go ahead and challenge me on it, I will bring a can and throw him in it. And the can won't protest because it'll be like, you're home, Binger. You're home. You're a piece of garbage. I understand. So he has threatened this guy with all sorts of felony charges that will, if he is convicted, will put him in prison for a very long time. So he goes in, he says what he needs to do. But one thing I pointed out at the time of the trial, and I stand by it today, he gave Kyle a whole bunch of help on the witness stand. He talked about how chaotic the situation was, how he was afraid just being there, so that he retreated up to the rooftop. But Kyle wasn't able to do that. People told him, no, you got to be on the ground because you're medical. There's a big distinction between what Dominic Black was doing and what Kyle Rittenhouse had to do because of their different roles there. And everything I saw from Dominic seemed to be, I have to say a couple things, but everything else I'm going to give to the defense. With that, I want to present to you, Kyle raised a whole lot of money for his legal defense, something like $500,000 plus for his legal defense. Dominic Black has not had access to that. And that's one thing Barnes has talked about. You know, it really would have been great if they would have set up a joint defense agreement. Like, I don't know the logistics of that. I don't know the practicality of whether or not they tried that. What I do know is that Dominic didn't appear to take part in that, and he has a privately funded attorney, and they're facing a real issue here. So I'm going to send this Give, Send, Go link into the chat. If you guys feel compelled to support Dominic Black, he's the one who is stuck dealing with this issue from Binger. I will say on the record, without a hint, Binger, sue me, you motherfucker. This is an unethical, malicious prosecution. It's politically motivated. Binger is a giant piece of shit. He was politically motivated against Kyle. He lost against Kyle because his case is bad. He knew his case was bad, and he tried to lie to bring a fake case against this kid. And now that he doesn't have it, he's going after Dominic Black. And that is remember, Dominic Black went in for the state, and I guarantee you, I guarantee without a hint of doubt that Dominic Black's attorney had talked to Thomas Claire Binger and had made some sort of not official deal, but a partial deal. Now, when Judge Schrader says, no, I'm dismissing this charge against Kyle Rittenhouse, Dominic is charged under the exact same thing. The logical answer is go in, move for dismissal. The judge grants the dismissal on the exact same grounds. And Binger says, if you do that, I will punish you with an appeal. I will make you pay another $20, $50, whatever $1,000 it is for an appeal, because my little stupid ego is hurt because I couldn't win against Kyle, but I'm going to bury you even though you testified for me against your brother. What a fucker Thomas Binger is. Anyway, there's the Give, Send, Go. It's not GoFundMe, who's absolutely shitty right now, but please consider checking it out for Dominic Black. That's the big update, guys, is that yesterday there was a hearing. They went in there and Binger said, if you dismiss this, judge, I'm going to appeal you. I'm going to make this kid pay tens of thousands of dollars on appeal. And I hate this. I hate this prosecutor. Sorry. That's my little soapbox. If you guys have anything to add, I'm done.
I mean, 100%. I'm just, It's so frustrating to see him like peacocking in this situation where you can tell he's running a trial that should never have been run. And he's showing up every day with a different pin, flashing for the camera, showing off, trying to be this sort of personality. You can tell he's sort of trying to, I guess, launch a political career or something, or
Yep.
and
or a media career.
Yeah, and it's just so maddening to see him going after people who are obviously innocent. And I can't understand it, and I would love to see a world where that sort of thing was properly punished, where there were actually sanctions that I could expect to see happen for some of this stuff. Because when we have witnesses getting up there and he says, "Oh yeah, we didn't ask you to change your testimony," and the witness is going, "Yeah, you did." Like how?
I left out a part. I left real quick, Joe. I left out a part. He's charged with 2 felony counts. I mentioned this earlier, right? Because 2 people died, even though I think that's the improper charging. I think the proper charge is the transfer, not on the death. Binger offered a compromise plea deal of only 1 felony count. Right. So this motherfucker, he overcharges. He knows he's overcharging.
They always do that.
He offers the plea deal to get rid of the overcharge and go back to the original would-be proper charge if you could support it factually, but you can't. Sorry, I didn't mean to interrupt you, Joe. I just remembered that.
No, I was just remembering that when I was a child, I always thought it'd be so cool if I could dig a hole to China, because then if I ever wanted to visit China, I could just go through the hole and I can just like walk on through. And I don't know why no one ever dug it. And it would take a lot of digging. And what I was thinking is that if we ever tried such an expedition, and we probably wouldn't be able to make it very far, but whenever that project would stop and you get to that point, that's when you push Binger in, because there is no freaking hole deep enough for this scummy prosecutor who basically doesn't give a damn about people, about justice, about right or wrong. It's just, how do I better myself politically, economically, social standing? And it's just abuse and prosecutorial abuse with knowledge that this whole damn town is some family-run shenanigan, and they're basically completely slimy assholes. That's what it is. They're just completely slimy assholes. And there's no comeuppance. No one's looking into it and saying like, oh wow, we really should. Nothing's going to happen to him for all the prosecutorial abuses which happened during this past trial, which I mean were just shocking and stunning, and Fifth Amendment violations, basic civil liberties, not giving over proper evidence and doctoring up evidence and ignoring judge instructions about bringing in stuff that's clearly prejudicial and inadmissible, one thing after another. And all the signs we get, every sign we get is that he's able to walk this road because he knows there will never, ever, ever be anyone who questions this crap that he pulls, and that he can get away with without any possible repercussion. It's disgusting.
I agree.
He went to
I don't really have anything.
He went to the bathroom on me.
I know. I don't really have anything to add to any of that because
So let me explain to you guys how you shill, okay? Because I'm sorry, that was crap. All 3 of you, that was terrible. Oh my gosh! Listen to me. Okay,
nope, not going to change it.
To you. You guys need to follow Ian Runkle. Okay, Runkle the Bailey. First of all, the name itself is freaking cool. It is cool as hell. He has the coolest hair. Even sometimes Legal Bites looks over and she's like, "Damn, I wish my hair looked like that." And he gives legal insight that is amazing and brilliant with that soft, cool Canadian accent, and he gives you perspective that you're not going to get from anyone else. Legal Bites, let's face it, at the end of the day, how the hell can you not sign? If you're not signed up to her, I don't even know what to tell you anymore. I don't know what to tell you. How are you not signed up to Legal Bites? I mean, really? Why not? Me, what I tell you is this: when you're watching me, I'm going to make you laugh, or I'm going to make you really think hard about something, or I'll probably say something that's based AF. So for any of those bases, I'm sitting here. I come here for like 3.5 hours. I'm like, you know what? 15,000 people. I probably should walk out of here with 300 subs. I think I got like 6 of you to sign up. It's pathetic. It's pathetic. I don't know what's wrong with you guys. I can't keep coming back here night after night till like 3 o'clock in the morning. If all I can ring out of you guys, it's just like, like 25 subs or something like that. So I'm asking you, do me a favor. The only compensation I get is I see that stupid little number go up, and somehow that makes me feel as if, you know what, I'm growing. So I urge you, all 3 of us, click it now. Boom, boom, boom. There you go. That's how you do it. That's how you push it. I'm at 29,902 when I made that pitch. Okay. And I'm just going to say that really Nick is pretty much the greatest lawyer you've ever met. He's pretty much the greatest lawyer I've ever seen. The guy is a genius, and he's a marketer. He's entertaining. I'll bet there's like at least 20%, 25% of you who are not sub to him. I don't know what you're thinking. Why wouldn't you be? It's just crazy. That's all. Oh, hey, Nick.
I'm curious as to what was actually happening while I was gone that you saw me and switched to that thing. No, he was
giving us a shilling tutorial this time.
Look, I do not one policy I have on my channel is I do not promote a GoFundMe or anything like that unless I am willing to give to it. And I went to go look for my wallet, which I cannot find, which is great.
Here comes the Ridge.
Sorry. No. I'm not doing a Ridge wallet ad today.
But that's a perfect opportunity for it, though, is it not?
I know, but losing it is not the best ad for it. I'm just saying. It's the whiskey, by the way, that made me lose it. I am pledging right now. I am giving $250 to Dominic Black.
Wow.
Look, I do not ever advocate for a cause that I'm not willing to give to. Okay. And so right now I'm doing it
similarly, I will give to my cause. I'm going to sub now to Legal Bites, Runkel the Bailey, and to Nick Ricada. So
there you go.
Subbed already?
There you go. Yeah, that's pretty embarrassing.
At this point,
but
I'm
let
gonna
me
unsub from your channel for that.
I'm confirming it right now. The donation has been processed, and I will show you. I had to use my other browser because it had my credit card saved because I still can't actually find it. But here you guys go. You can see I have pledged $250 from Ricada Law, and my comment is Binger is garbage and a disgrace to all lawyers. Look, I'm not a guy who asks people to do things that I'm not willing to do myself. And this one is one I believe in. I think that Dominic Black has been unfairly characterized by a couple people. I was on Tim Pool's show yesterday, and I think that he put out a video about Dominic Black that was, let's say, lacking in awareness of the reality of the situation that he was in. That's the most charitable way I can say it. And I think that was an unfair characteristic of Dominic Black. And so look, I've presented it to you guys. You've seen the link. It's been in the chat. If you want to donate, go ahead. If you don't want to donate, 100% fine. But look, Binger is still being a piece of shit, and he's trying to take his loss against Kyle Rittenhouse, Mark Richards, and Corey Sherafisi out on the next target because that's who he is. And that should be obvious from how he conducted his trial. So,
Nicholas, this was really phenomenal, but I think I must have accidentally shown my foot on camera here because I'm getting all these questions about where my OnlyFans is. So I don't know how that happened.
Someone sent me an email the other day. They're like, my wife finds Joe attractive, and now I'm questioning all of my life decisions.
Yeah.
You really got an email like that, or are you just making that up?
I'm 100%
You need
serious.
to forward that on to me because that's pretty funny. That's pretty funny. Actually, well, that's probably not a conversation for online. So, yeah. So anyway, I just want to thank you for having me on here. I'm going to try and I'm going to try and get onto your stream tomorrow afternoon.
Tomorrow?
Yeah, just because I figure, I figure that your channel is red hot and some of it's got to rub off of me. eventually here. And if I don't
eventually, you've well over doubled your subscribers. Knock it off.
I didn't. The truth is, I didn't double. I actually went from I was at 4,100.
Actually,
I'm at 4,100. I think I quintupled technically.
No, yeah. You definitely
so yeah. No, I figure you're red hot, and I'm going to try and milk that. We are going to have to work out our schedules on everything here, because I had no idea that you were streaming tomorrow morning, Legal Bites, until he just brought it up, and I was actually thinking about streaming tomorrow morning. I'm not going to match up again. I'm not going to go up against you. But
I mean, you could have seen my tweet about it.
Yeah.
No, look, listen. I have created a lawyer grift thread on Twitter with all of us, and it's not just for me to post show links, so everybody should be using it in that way. Say, hey, here's an open invite. I think we are better when we collaborate. It elevates every show.
Amen.
And so
Amen. I love having you guys on. You are always welcome on anything I do. I think,
I'm not. Well, we'll talk about it later. But for now, I think this sort of mutual collaboration is a great way where we all build our independent channels and have everybody coming on. Because guys, we're all covering stuff that the other lawyers haven't even had time to see. And so coming in with varying levels of exposure, varying levels of expertise, we're going to be bringing a whole bunch of different insight and understanding to each of the issues that we're covering. So whatever time of day, like the idea is that we're going to have a bunch of drunk lawyers streaming at all hours of the day. Look, I'll be drunk, but everybody else can too. The idea that you'll be able to tune in at any time to one of our channels and get great content. That's what we're going for right now. And if it blossoms into something better, maybe that's in the future, and we'll see. Anyway,
I do need to get out of here. From my time, it's 4:12 a.m. So I got to flash out of here. You got like, a gross amount of super chats.
I got a bunch of chats to read, and I am going to read them. I'm going to read them.
And I thank your audience, because I've actually been interacting with your audience a lot tonight, and I've had a really great time here. And one of my favorite parts is when there's a moment that's so explosive that there's like 5 of us talking at once. I actually think that probably makes for like some of the best law tube moments, is like when we're all just completely hammering in at the exact same time. I don't know, those moments kind of amuse the hell out of me, but that's just my taste. I love you guys. I'll catch you later. Have a good night. Take care. Godspeed, and thanks again, brother.
Peace, brother.
Yeah, I'm gonna head out too, because I've got stuff that I'm gonna take care of.
I was gonna say, guys, I'm gonna read super chats. If you want to peace out right now, no one will think less of you. So
I should probably get some sleep, because I've been off in the desert running around shooting guns, having a great time, shooting all the things I can't at home, because
Alec Baldwin's assistants.
No, I was gonna say like an AR-15, which I haven't been able to shoot up here for like 2.5 years. Because
I'm not able to normally shoot an assistant or a director of photography, but apparently down in Alec Baldwin's production, you could just shoot director of photographies with impunity. So
that just makes me so annoyed. Here's the thing. Every time I'm picking up a rifle out there, I'm immediately going and checking it. It's like somebody's and this is a rifle that I've just used on a stage. I know it's empty because that was the last part of the stage. I'm going up to pick it up to move it to another spot, and I'm still checking it because it's been alone for a while, and who knows, right? This is just responsible behavior. This is the standard, is you check your, and there is no circumstance where I understand that the statement of claim or whatever the sort of originating document alleges that he wasn't even supposed to be pulling the trigger there. And so if that's the case, and again, that from my understanding is an allegation, it's unproven, we don't know yet, but then why would you? It's
no, I was watching I've been watching the show with my wife called Travelers. We're in the 3rd season, and one of the like lame characters gets a gun, and one of the traveler characters is like talking to the character about the gun and all this stuff, and talking about all and the traveler character grabs the gun. They're trained, right? And they they pull out the mag, they empty the mag, and then they clear the chamber, and they hand the gun back to the person who has no idea how to use guns. And they're like, okay, point it at me and pull the trigger. And if you can do that before I can take it away from you, then you're ready type thing, which is this super gay sort of standard, but it doesn't matter. That's irrelevant. What they don't say, and they're ostensibly teaching this person about gun safety, is I've given you the gun. You clear the chamber. I don't care if you watch the person clear the chamber in front of you. Basic gun safety. You clear the chamber. You check the mag. What if they missed one? You have no idea. Check it out. And they don't do it. And it's so freaking frustrating. It's like you're doing a show that clearly is having a sort of agendized approach to gun safety, and you're not doing proper gun safety. Every person who's handed a gun should clear the chamber, should check the rounds for themselves in case they're on Hollywood and they're dummy rounds or whatever and not blanks. They should be checking those rounds, not relying on an armorer. Sorry, that's my personal little tangent.
I mean, I said this in one of the sort of video on demand things. Right now the standard is the armorer just is the person who knows things, but I would think it makes sense to be like, hey, if you want to be an actor and involve yourself in productions that use guns, you should have some training. I did a similar video saying if you want to be a criminal defense or prosecution lawyer, you should have some training with guns so that you know that you can't do stuff like what Binger did. You know, that's shocking to me.
So you know that charging an AR-15 takes more than a literal frame on a video to do.
Yeah,
you can't actually charge, clear and charge around without a significant amount of effort. That takes a half of a second to a second, depending on your skill level.
I mean, some of the people out there could have run through that as fast as was suggested. But these are people who are like top of their game coming across the states to compete in an event. We're not talking like this 17-year-old kid. He's not John Wick. He's not this badass. Or at least they certainly didn't lead any evidence to suggest that. And I keep coming back to this. I think there's an ethical responsibility of the prosecution and of defense lawyers, is that if you're going to talk about what a gun can and can't do and rest your submissions on it, you need to be right. You can't just be making stuff up. The court would absolutely rip into me if I said something like, well, it's not possible to overdose on fentanyl. Who's ever heard of that, right? They'd rip me to pieces. They'd say, Mr. Runkle,
right.
Are you on drugs right now? Why are you lying to the court? Why, but that's the kind of equivalent to some of the statements that were made. Oh, there's no such thing as a left-handed gun. Are you kidding me?
Yeah. Right. Absolutely incorrect. But we'll be talking about one thing I want to do tomorrow for the stream is going through the Kyle Rittenhouse interview with Tucker Carlson, maybe going through the interview he had today. I don't remember what network that was on, but we'll be looking at some of the post-judgment statements of Kyle Rittenhouse, because now we can assume that all statements are made in contemplation of civil actions. But anyways, I want to give you guys the opportunity to leave because I know it's really late for Runkle and it's really early for Legal Bites. And yeah, there anything you want to say, Legal Bites, before you peace out?
No, that'll be about it. If you guys are interested in coming and checking out content on my channel, I'm going to have a live stream tomorrow, talking about, it's going to be kind of a packed live stream. So, Crystal Kaiser, Ahmaud Arbery, Ghislaine Maxwell, and Gruden versus the NFL. So we're going to touch on quite a few topics, probably not go as deep into them as we would if we were doing like a 10-hour live stream, but at least touch on them and kind of discuss them a bit. So we're
by the way, we've raised over $2,500 so far for Dominic Black.
Nice.
So thank you guys for doing that. And guys, check out Legal Bites stream tomorrow, 11 a.m. Central Time. And I bid both of my guests farewell as I delve into reading a whole lot of beautiful super chats.
All right.
All right.
See ya.
Good night.
See you guys later. Peace. Whoa. Well, ladies and gentlemen, you are stuck with me. You're stuck with me. We're off of this little headphone thing. And we're going to get going on this. I'm going to read a whole lot of these as fast as possible. Look, to everybody who super chatted, I love you. You make this show possible, and I do my absolute best to read all of the super chats. I have so many to read from the previous streams, and I'll be working on it. One thing I want to say is I am, if you did not see earlier, I am releasing segmented version of the Kyle Rittenhouse trial in full in its own playlist. And the opening statement of Thomas Claire Binger was released today at 10 a.m. tomorrow, which is 1 hour and plenty of time before Legal Bites is streamed tomorrow. The opening statement of Mark Richards with the N-words censored out for the purposes of YouTube. That will be uploaded tomorrow, 10 a.m. It will be there. If you want to check it out, please go ahead and do so. That playlist will eventually include all of the opening arguments, all of the testimony of the various witnesses in order in the playlist. And I don't know that they'll be uploaded in order because the next thing I have to upload is Kyle's testimony, but all of those things will be incorporated into a playlist for easy reference of any point of the trial. And they all include our commentary and analysis from the panel as it happens. My editor is putting in bonkers amount of hours, and I am happy to compensate him for those hours, but he is working very hard to get those things done, and I will be uploading them somewhere between 1 and 3 of them a day, depending on the length. You know, they take time to cut down and edit and to trim out our stupid commentary that is irrelevant to those issues. But I know that a lot of people have already watched the trial. They're not going to be watching these videos, but I wanted to provide an easy access point for any of those videos for people who want to go back and reference specific areas later, or who want to go back to those. And that's a practice I want to put in for any trial that we're doing in the future. But I will say that on future trials, I want to have them coming out in real time. But me and my editor were new to this sort of aspect of coverage. And so bear with us as we learn this process. And for the next trial, which I suspect is going to be Kim Potter, although I have heard Ghislaine Maxwell may have an audio feed directly from the court. If they don't have an audio feed, we may have a person in the court to observe. Keep posted on that, because I would love the law panel to cover Ghislaine. But in the event that we don't cover Ghislaine, Kim Potter, the taser cop, will be covered in full on this channel. I believe that is the next lawsuit that the next criminal trial that I expect to cover in its entirety. So, and Steve Cersosimo says, please follow up with Tim Pool on his offer. Yes, we'll be working to have, look, if we can't get the audio or the video from the trial, we'll be working on the next best thing. I've gotten more messages than I can even count about covering Ghislaine's trial, and we will not call her Ghislaine here. Look, on Ricada Media, Ricada Law, whatever you call it, we only use the proper French pronunciation, Ghislaine Maxwell. So we'll be talking about it in some capacity. I've gotten so many requests that I can't avoid it. But the full video trial we'll be covering, that I'll be covering, is Kim Potter, and I hope my law panel will be joining me. Okay. On to a whole bunch of chats. Mr. Armageddon says, if Kyle Rittenhouse was Santa, left media spin, man found stealing milk and cookies after several million home invasions, crossed every state line, only targeting homes of children, made a victims list and checked it twice. Mexican Flash says, in soy voice, squawk, all right, legal eagles, time to think like a lawyer and see why Kyle should be in jail. Quoting Legal Eagle, probably. Saturn Tube says, did you ask Tim about his chickens? I met Tim's chickens, sort of. They were sleeping. There were 14 chickens in a wonderful chicken castle that's bigger than many houses that I've ever seen. And they were huddled up in their little coop and they were sleeping. It was very nice. So he did not play guitar for the chickens, but I did see the chickens. Also, I'm listening to everyone on the panel was mind-dumbing besides you. Tim's the most unwatchable podcast ever. Damn. Shots fired at Tim Pool. DOG Beer says, hi, Nick, and happy harassment day. Who do you think Kyle has the best chance of winning a civil suit against if he decides to go that route? I don't know. Right now, my prospects on Kyle's civil suits are very low. I think it'd be interesting if he made a federal claim for a civil rights violation against Binger and Krause. That's 18 USC 1983 or 18 USC 242, the deprivation of civil rights, based on the deprivation of his Fifth and Sixth Amendment rights, as far as I can tell. But we'll see. His civil suits don't have to win to be useful. The audio leak is sealed from national security, so good luck with that. We'll see what we can do. Lix Dexia says, 10 years paralegal experience, Mill Pros, Med Mal, and corporate law. Send me to cover Ghislaine Maxwell case. Well, we'll see. I've gotten a couple emails about covering the Ghislaine Maxwell case. I'm going to be making some phone calls tomorrow. Wolfgang says, mostly peaceful watch party review of Legal Eagle. Wizard's First Rule says, late Freedom Fighter says, please tell me you had home cooked meal tonight and not chicken McNuggies. Lol. Yes, I made a pasta. I used thin spaghetti noodles. I had pork, ground pork with Italian seasoning and salt and pepper. And that was incorporated with garlic, cherry tomatoes, mushrooms, and red pepper. So crushed red pepper and garlic in the olive oil and the pork fat after quickly browning the ground pork. So you brown the ground pork, add garlic, add olive oil after taking the ground pork out so you don't burn it. Then you add in the mushrooms, cook those down. Then you add in the cherry tomatoes that are halved, because you can't have a full cherry tomato. That's degenerate. Halved cherry tomatoes. And then you add in a little bit of white wine to deglaze and reduce into a nice sauce. And then you add in the pork again. And then you add in the noodles and you toss it all together and some pasta water to emulsify with the oil in the pan. And you get this nice, wonderfully coated pasta with pork, cherry tomatoes, and mushrooms. And it's fucking delicious. And I made this up. I made this recipe up because I like to cook. So that being said, if you want to learn how to cook, I do cooking streams. The only way you can access my cooking streams is through recadalaw.locals.com. I guess you could technically kind of do it through the YouTube members only program. It is a possibility, but the best way is through recadalaw.locals.com. Don't give your money to YouTube for subscriptions. Give it to Locals. We're pushing towards 1,000 active members. We're almost there. And it is a growing community of wonderful little spurgs. So join us. Grimm's Bar sent me a unicorn. Isaac Bowles says, did you see the News Nation Now interview? I have not. Kyle shitting on his supporters. Whoever's counseling him is apparently also trying to bury him. That's been a question. David Hancock is counseling him, is potentially in charge of this stuff. I do not think Kyle should have done the Tucker interview. When he went on the Tucker interview, I do not think he should have said that he supports Black Lives Matter and all that shit. I think this is a stupid strategy, is completely unnecessary to Kyle Rittenhouse's ongoing activities, and the pandering needs to not happen. But I'm not his attorney, so I can't say anything. Mario Carter says Tim Pool plays guitar for his Legal Eagles. The Denialist says, what is this with the makers of Rittenhouse Rye? Where can I get a refund for a producer that cares that I'm celebrating? Wrong. Yes. Rittenhouse Rye, Heaven Hill. Heaven Hill is the distillery, or Heaven Hill is the company that releases the Rittenhouse Rye product along with others, has released a statement. It's absolute bullshit. And it just shouldn't happen. Like, nothing about it is right. I wrote a Twitter thread about it. It's pinned on my Twitter. I would appreciate likes and retweets on it. But Heaven Hill is mad that people are buying Rittenhouse Rye in celebration. So they're saying, thank you for giving us money, but please don't give us money and then use it in the way that we don't approve of, which is nonsensical. They're using the false premise that people are celebrating the deaths of Joseph Rosenbaum and Anthony Huber. Now, while I will celebrate the deaths of a pedophile and a domestic abuser, because fuck you for being a pedophile and fuck you for being a domestic abuser, while I will do that, I could say that most people are probably just celebrating justice. Kyle Rittenhouse was attacked. He was attacked by a pedophile. He was attacked by a domestic abuser. He was attacked by a routine criminal charged with gun crimes, but still in possession of a gun, which would be a subsequent gun crime, by the way. Notice that Kyle was not illegally carrying a gun, but Gage Grosskreutz actually was. He was attacked by monsters and he defended himself. No one should be condemned to die at the hands of monsters because of your political beliefs. So, to Heaven Hill, get a fucking grip, you weirdos. Shut your goddamn mouths and let people buy whiskey for whatever reason they want. Your job is not to comment on the Kyle Rittenhouse trial. Your job is to make whiskey and let people buy it in whatever volume and for whatever reason they want, you morons. But yeah, you can check out that whole story on my Twitter account. Guardian1032 says, yes, let's lawyer some shit. There you go. We can lawyer some shit. Giddy Fearer says, fluffer boy and late for shame. Jordan Jones says, Rittenhouse Rye made a public statement about purchasing their liquor for celebration. It's a marketing failure. It is. Look, any political statement, no matter which way you go, is a marketing failure. Always just market apolitically. Why would you do this? If I made a whiskey, you would never know how I leaned. You would just say, fuck pedophiles, buy my whiskey. That's it. That's the best marketing strategy I could possibly imagine. Brian Penn says, I wasn't the one who promised to pay, but here's a $5 for the facial abuse. Friggin' hilarious. I hope you guys enjoyed that. Dapper Wolf says, Nick, where were you at? Darnell, whatever guy just got off of bail, set to $5 million. Also, one of his victims, a child, died today. Did he actually go out on bail? Did he produce the $5 million? I don't think so. But maybe he did. Steve Sir Simo says, fun times on Timcast last night. Thoroughly enjoyed it. Oh, and for the question was, where were you at? I was flying home from Maryland. I went to visit Tim Pool, go on his show. They do their guests in person, which meant Sunday night, I left my home. I went to a hotel. I then got on an airplane Monday morning. I flew to Maryland. I had 1 hour of free time on Monday evening in which I went to a grocery store, bought a rotisserie chicken and some grocery store sushi because there's no fucking food by that hotel. And then I went to the Tim Pool compound, had a great show, very hospitable group. We had a fun time. And then I went back to my hotel. I did a locals live stream where I went to McDonald's and ate some chicken nuggets because I'm a degenerate and I was hungry. And then I fell asleep before even setting my alarm, got up, got on drove another hour and a half back to DC, got on a plane, and then drove 2 hours home. I've been traveling for 2 straight days. So that's where I was. Sorry, I would have been broadcasting if I could. I also did a live chat in my Discord. I had a meeting with my YouTube partner manager, and I did an interview with PJ Media, which will be up a little bit later in the week or Monday at the latest, I believe. I'm not sure what day it'll release, but guys, I am very, very busy. So that's what I've been doing the past 2 days. Very fucking tired. Jegs War Chief Dino. Oh, and by the way, tomorrow, I'm definitely going to be on my show. I may be on Legal Bites' show, but also in the evening or late afternoon, I'll be on Chrissy Myers' podcast. I think it's called The Wet Spot. Chrissy Myers is a female comedian. She's very funny. I've been with her on a couple different shows, and I like her very much. And we will be talking more Rittenhouse and other things. Also, the other day, I was on Eric July, also known as Young Ripa's show on YouTube. Guys, I'm putting in the hours. I'm putting in the hours for you. So there you go. Oh, and also yesterday morning, I was on before I got on my plane, I was on a Washington, D.C. radio show as well. So if you wonder where I am, working like a motherfucker. That's where I'm working. Jegs War Chief Dino God says, glad Nick and friends are tackling this tool. Oh my God, this is awesome. Lol says, Hoger volume. Okay. Taldrin says, question, the root cause of this Rittenhouse incident wasn't the fact that Rittenhouse had a rifle, but that the politicians ordered the police to stand down and allow the riot to happen. Where's their accountability? Have you ever known a politician or a police officer to be accountable for anything? No, of course you haven't. There's their accountability. Stella says, women aren't funny, me included. Look, you don't have to find Chrissy Mayer's podcast funny, but you do have to find me on it. Stegus says, Lord Moopies and my grandpa Dave passed away today. He was 92 and had his mind until the end. It would mean a lot to my family and I if you kept him in your prayers, and if you took a drink for him, he would appreciate it. He was a great man who was always there for me, and he was always a shining example of what a man should aspire to be. Quote, it is not death that a man should fear, but he should fear never beginning to live. Marcus Aurelius. Stegus, absolutely. Look, I'm toasted. I'm sorry I didn't see this earlier, but I can share a drink to that for sure. For sure. To Stegus and Lord Moopy's grandpa Dave. These are brothers. I've met one of them. Unfortunately, I don't remember which one it was. I think it was Moopy. I think it was Moopy that I met. Maybe I met both of them. Oh, God. Now I feel like a dick. I'm so bad with names. Anyways, to Grandpa Dave. To Grandpa Dave. A man of character, of integrity, and of supplementing the job of parents in raising competent and capable young men to go out and tackle the world, something that not enough people are doing out there in the world today. Our young men need to be equipped, and the only way to equip a young man is through an old man or an older man. And grandpas are wonderful, wonderful resources who remember a time before all of the bullshit and the nonsense of this current era. So remember thoroughly and favorably your grandfather. May he rest in peace. Cheers. Okay. Bear Business One says, praise the Don. Don lives matter. The Don is loved, just like Cecil. I should announce this. I'm going to be talking about this more. Guys, Anime Matsuri is a convention, if you're new here, that I go to, have been going to every year that it's run. It will be running this coming year in late July. Clear your calendars. Not only am I going to be at Anime Matsuri, but I am bringing a production that has never before been seen at Anime Matsuri, or to my knowledge, any convention. And it is not anime related, but it is top quality. So more of that will be coming out as I solidify plans. But guess what? Anime Matsuri 2022, late July 2022, is going to have something that you have not experienced at any convention of any kind before. And it will be phenomenal. I will be there. You all should be there as well. Cthulhu says, hey, been trying to send a super chat with a site that is supporting one of the kids that got run over by the BLM activists in Waukesha, but YouTube isn't letting me send the site. Cthulhu, email it to me. We'll talk about it tomorrow on the live stream during the day. Emily Wooten says, can we move from Rittenhouse to Ventavia whistleblower? Fenrir Lightgrove says, how tall is Tim? About 5'10". That's the thing. I have a real picture. Do you guys want to see the real picture of me and Tim Pool? Where the hell is it? God damn it. Here we go. I think it's here. Here we go. This will work. Here we go. So mind you guys, I am 6'2". So that'll factor into your mathematical autism equations. Oh, shit. That I am 6'2". Here we go. There it is. There's me with Tim Pool. Look at how happy he is to have me posing with him. Woo! There we go. But I think that's accurate, right? That's about 4 inches. 4 inches of head. Ignore the tall hair. But there you go. There you go. So you guys can see there. That's the answer for you. Yeah, he had no. So I asked him, I was like, oh, by the way, can we get a selfie? Right? Like, can we get a picture together? And he's like, sure. Yeah. And then he comes to stand by me and I throw my arm around him and do the thumbs up. Like, and he's like, what the fuck? Right. And Cash Patel took the picture of us. He takes the picture, gives it to me. And I said, that's the pose I use with all of my fans. I was like, gotcha. What up? So anyway, that was, it was beautiful. He had no idea what was coming. He had no idea what was coming. It was great. He was super nice, super hospitable. I have nothing but praise for the Tim Pool team, the Timcast team. And he was very gracious to do a picture that he clearly, look at his fucking face. He definitely doesn't want to do this picture, but he did it without hesitation. He was like, yeah, of course we'll do the picture. Not a big idea, or not a big deal. So he's great. Fenrir Lego says, how tall is Tim? And did he serenade you like the chickens? He did not. He did play a little guitar, but not too much. Lol nose question. Have you ever had a pimple in the nostril? Hate those. Yes. Oh, right. Like here. Oh God. Oh, right on that nerve cluster. Darth Crypto says, I broke more news about Dominic Black's situation. Binger's plan to appeal the gun law if he loses a motion. DM'd you that as well. Chase Thomas says, real AF. Semper Pie Eater Die says, do you plan to talk about Ghislaine Maxwell case? The list of her co-conspirators was released. Yes, we plan to talk about it. I don't know. It's going to be tricky. It won't look like Rittenhouse at all. We got to figure it out. TH5GH8G says, good logic, greater than Rekieta law. Get wrecked, nerd, and God bless. Look, it's okay to be wrong. Rem Savirem Poker says, can you please go on Joe Rogan? This would be the greatest. Yeah, I'll get right on that. Look, if Rogan invites me, of course, I'm going to go on his show. I think what he's doing is very important. I think Rogan is one of the, full disclosure, I hated Rogan as a UFC announcer, but he's one of the great interviewers of our time. And it's because of his style. He's a wonderful interviewer. He lets his guests dictate the show, and he defers to them and is an expert conversationalist in that context. And so yeah, if Joe invited me on, of course I would go on, but I'm under no illusions that Joe Rogan is going to reach out and invite me on the show. But if he wants to, Joe, by the way, I think I'd make a good guest. That's all. Contrarian 420 says, you've been very quiet on the mandate nonsense for a libertarian. Plan to take this vastly important topic back up. Look, I've been very, very busy covering other topics. I have a limited amount of bandwidth, but one of the guests on my panel, Matt Wilson, has an active federal lawsuit against the federal vaccine mandates. And maybe I can bring him back on to talk about it. But the short story right now is that the Fifth Circuit shot down the mandate. So it has a injunction that is valid in every state against it, at least as far as to federal contractors anyone regulated by OSHA. The OSHA law has been the OSHA regulation has been put on a temporary injunction, but the temporariness of the injunction, it's now a permanent injunction until the pendency of the action. So potentially several years. But we got to wait and see how that goes, ultimately. But one of my panelists during the Rittenhouse trial is an attorney named Matt Wilson. He has his own separate action against that mandate, and we'll see how that goes as well. But we might be talking to him soon. D. Watt says, did Tim sing to the chickens? No, chickens were asleep. Albert Wesker says, talk about the racist BLM attack in Wisconsin, please. That's tomorrow. That's tomorrow during the daytime show. Stephen Oglesby says, you guys are amazing. It's like getting a free law degree, not applicable. Says, talk about the BLM Christmas Rammer. BTL Video Production says, why not get Legal Eagle on a show about this? Nick versus Eagle. Look, I don't invite people on my show for the purpose of them getting blasted by me or the chat. If Legal Eagle would like to come on, he is invited for sure. But I think he would be coming into a hostile environment, and my channel is not about bringing people on to annihilate them. I've said over and over, I do not like debates. I do not like that format. I think it's ripe for abuse, especially on social media. Because look, I'll debate any motherfucker on the planet on any subject, but once you put it onto YouTube or social media, you're not debating anymore. You're performing, and that is an issue that is separate. So if Legal Eagle wants to come on, he's welcome. But I'm not going to bring him on here for me to berate him. Todd Larson, thank you for the donation. Steve Sursosimo says, the facial abuse reference, it was freaking beautiful. Snubber 13 says, ranting monkey had the pleasure of Sims tonight. Is he always this nuts? Look, Sims is a giant cuckold. It's hard to express who Sims is without determining that he likes to watch other men have sex, which is weird. I don't know how else to describe him, but Sims used to troll this chat, and he got blown out. He got ignored after a while, and then he disappeared from the earth, but he has been showing up around other people. Sims is a desperate soul looking for attention, looking for validation, and he has not found it. So I don't know what to say other than that. Knucklefist says facial abuse master grifter. Guys, I thought I'm getting shit on that facial abuse drop. I thought that was relatively well worked into the conversation. I waited for an opportunity. I said, okay, they have now mentioned property issues involving private property. I can now create this situation in which someone might be broadcasting facial abuse in their front lawn. And look, if an 11-year-old walks by and watches facial abuse, they may turn into a degenerate. And look, if you want to turn into a degenerate, facialabuse.com. I don't know what else to tell you. If you want to become a disgusting, horrific human being, and who doesn't, that's where you go do it. But I would suggest, instead of facial abuse, go to Antifa abuse, because it's funnier. Andrew Clark says, bring on Maulers, since you're EFAPing this video. Kolya Dante says, in the Crystal Kaiser case, it's difficult to defend yourself against a sleeping man by shooting him in the back of the head. Also not exactly escaping sex trafficking when you drive the dead John's car back to your pimp. Yeah, that's the thing about her case. And that's why I haven't commented too much. I'm not fully aware of the facts. Game Freak PHI Wong says, wait, Antifa abuse is a thing? Not only is Antifa abuse is a thing, all of the actresses on Antifa abuse are literally verified, avowed Antifa. Do with that information what you will. Felipe Brevard says, I'm banned from cinemas here in Quebecistan, but what you do is way better. Anyways, fight on, America, so your light can shine and reach here. Chris Harris says, Christopher Irvin, jailed since March, no bail. ATF charged him in Jacksonville, Florida. Civil asset forfeiture, charged with evading bank reporting, possessing a machine gun conversion device. So there you go. Patrick DeCellis says, look at the pinned comment on his video for corrections. No, thank you. Other people can do that. Chase Thomas says, Nick, are you stoked for the Sonichu prison saga? Yes. Daniel No Name says, Democrats getting facts wrong as always. Dapper Dave 2021 says his video is as solid as Binger's presentation was. CC says it was still free as of yesterday when I ordered mine. Leo Post says, look at Legal's pinned comment. He made a correction. Uriah Wright says, so Nick, what's the boxing match with Legal Eagle? That'd be unfair. I have a reach advantage. I Hate Yankee says, photo chat interview win as soon as he's available. Hopefully sometime this week. Talix 001 says in Richard's voice, objection, Your Honor. This Legal Eagle guy is clearly the love child of Bill Nye, the science guy, and Pee Wee Herman. Comic Nut 64 says, Nick, no offense, but punching down on this Binger clone isn't fair either way. I used the last of my government money on the same AR Kyle used. Kyle, your local pedo. Mario Carter says, Fluffer Boy 2004 versus Legal Eagle. Who's the bottom? Fluffer Boy. Sean says, would it be legally defensible? Because listen, Legal Eagle makes like 10 Binger salaries a year at least. Sean says, would it be legally defensible to think in a self-defense case that I wanted to stop the assailant instead of using lethal force? If you're going to use lethal force, you have to intend to use lethal force. If you intend to use less than lethal force and then use lethal force, you are potentially culpable of a criminal act. Tall Skinny Geek says, Binger looks way fluffier than Richards. Healthy Fiesta says, thank you for all the coverage. Elliot Smith says, legal feeble. Cowboy Shit says, dude looks like a fit. Good logic. Pseudoscience says, Nick, I'm new to your channel. When do you sleep? Not enough. Also, after his coverage of Kavanaugh and his defense of Captain Marvel, this guy's kind of nauseating. True. Not applicable says his wife likes a beta that dresses alpha. Mario Carter says they've been madmen long before the verdict. Mesmerizer says Barnes got that shirt at Dan Flash's using his per diem. Blasphemous Atheist says he looks like a knockoff Ryan Reynolds. Gunblade says, could Legal Eagle get sanctioned if he gives bad advice in his videos? No, and he should not. He should not. By the way, have you ever seen his take on Captain Marvel extra scene? Yes. That's what really attracted me to making fun of Legal Eagle. Woo! G says Legal Eagle and Binger get off the same aesthetic. Giant Brian says, I have a question. If I was a juror and Binger pointed his gun at us, would we be able to complain to the judge? You can complain to the judge, but not criminally. Sloppy Joe says Legal Beagle is popular because he hates Trump. He pushes the right narrative. Base Shaman says, congrats, Nick, on all the new subs. Now, when are you going to purge the normies with your Chris Chan coverage? That wouldn't purge the normies. One Drexel show will do it. And that may be coming up around Thanksgiving time. I gotta check with him, but Drexel may be coming out for Thanksgiving. And if that's the case, if Drexel comes out for Thanksgiving, oh boy, we will have an interesting show. Sloppy Joe says, wait, no shit. Mean Sarton says Legal Eagle is the McDonald's of legal analysis. Michael says prosecutors should be indicted on falsified evidence. Dapper Dave. Nick, stop the grift. Envy. This guy plays a lawyer. Leia something says we are enjoying the live stream while drinking legendary Duke bourbon. T says cheers. Dude, Duke bourbon is good shit. Edward says, Nick, I watched some of David Pac-Man's waiting for the verdict. He mostly covered the protesters outside and was banning people. You did it way better. Look, one thing you'll learn on this channel. I do everything way better because I do me and I do honesty. Jonathan Duger says, when I began watching, I thought that was Ryan Reynolds. Ruben Prime, welcome to Lawyer Status. Tactless says, Legal Eagle looks like a partner of Wolfram and Hart. Don't you bring Angel. References here. Michael says, please explain the difference between self-defense laws between Texas, Florida, and California, New York. The CCL, but other states might not recognize it. How to handle. You got to check on CCL reciprocity. That's a separate issue from self-defense. Self-defense is typically the same because it derives from common law and the understanding that everyone has a fundamental right to self-defense, but some states do handle it a little bit differently. I don't know how to handle it other than to check those states individually for their laws, but CCL reciprocity is readily available on Google. VK 72.01K says, love your coverage of the Rittenhouse court cases. Thank you. And Buff says, good logic. Please check your Twitter DMs. My name is Mark Buff. Mandalore Wise says, please break up this word vomit to untangle whatever he's attempting to say. John Hatt. Look, I'm going to do, I'm planning on doing an individual video on demand of the Legal Eagle video, a summary of it, if you will, that should help out with that stuff. John Hash says, why is self-defense considered a privilege? It's an innate human instinct to preserve oneself. How is that not a human right? Because it's statutorily granted the privilege. I wouldn't read too much into it. Self-defense is a human right. That's why the law exists. But the privilege of self-defense is a question of law. Mario Carter says, Kyle was dressed provocatively. Quote, German Shepherd. Seek the light. Welcome to paralegal status. Zachary White says, Legal Eagle. More like smirky turkey. This is a bunch of gobbledygook. Lazarus Rex says, what Binger did to the jury was brandishing. Vexner 3 says, every freeze frame makes Legal Eagle look like a scared meerkat. You just know he's the kind of guy who stares at himself in the mirror every morning. So, oh my God, this is awesome. Lol says GG. P Fuss. I met someone tonight who said Rittenhouse who? Fubadoo says poopsies. Weber J says Kyle never said he pointed the gun at Gage's feet. He said he lowered his weapon when Gage raised his hands. Dash Dash says, yeah, but this bookshelf, though. Darth Crypto says, I keep screaming at my phone when you're misremembering details and using all my might not to spam your DMs. Darth Crypto, I don't misremember details. You misremember me misremembering details. How dare you? Jonathan Lindsay says, for calling me out, but only so much you can say in 200 characters without trying to spam. So he says, has anyone else mentioned or noticed the HD drone footage wasn't released by FBI? Didn't show up until trial after Gage took the stand and essentially ended the prosecution's case. Jesse Bear says, Kyle admitted on Tucker the receiver jammed and he had to force the receiver closed. So Gage actually saw him clear a jam, which is interesting because on the video, I don't see him clear the jam. Do you guys, they went frame by frame through the video and I didn't see him clear the jam in any way. Tamara Holloway says, can Zeminski be charged with murder for his illegally firing his gun, causing Kyle to pop JoJo, skate ho, and arm blow? Wishful thinking. He possibly could, but he won't. LawTube Clip says, what shade of yellow would everyone describe Yellow Pants Man pants as? Look, slightly diluted urine. General K Corn Pops Corn Yeet says, I have a hard time thinking slamming the forward assist on his AR fixed his failure to feed. Brian Wilson says he was also showing the car source video in slow-mo only. Katie says, can't the FBI just ignore the rules and lock him up anyway? I am from Denmark, so I don't know, but Biden seems more and more likely like a dictator to me. They can ignore the rules and charge him, but he has counsel and money behind him and public interest. Those are the 3 bars to malicious or unjust detention. First, innocence. Second, money. Third, public interest. Those are the things. The Real Bamboonga says, I'm usually not a huge legal fan, but he's been being pretty thorough. Dumbing it down to my level is just icing on the cake. I have a lot of dumb. Look, the problem is if you have a lot of dumb, he didn't dumb it down for you. He lied to you. That's the problem with legal. Razor 39T says lots of comments on vid call Kyle an active shooter and therefore the 3 victims have the right to stop the threat. Slippery slope. Everyone then becomes an active shooter once they stop the prior one. Comedic. J. Oz says 10 out of 10 legal bites. Cody says, I don't think self-defense laws need modifying, but I think we need to strengthen laws against vigilantism. What's the panel's take on that? Look, vigilantism doesn't need laws. Personally, I would say they don't need strengthened laws because vigilantism is generally illegal. The actual act of being a vigilante, which would be something happens and someone goes out to rectify the thing that happens without legal authority to do so. I don't think we need stronger laws on that. We have plenty of laws on that. The reality is most people are not vigilantes. And so that's why you don't see a lot of vigilantism prosecutions. Bainling says, Nick, can you get Officer Brittany Bay on the show? I could reach out, but I don't know if I want to. The chat, oh my gosh, I don't know if you have enough semen in your body to sustain the show. Julia Riley says, as someone on the left, frustrated with many I know didn't watch the trial. As a gun owner and Second Amendment advocate, I got to shut up around friends. Julia Riley, let me humbly suggest, as a gun owner and Second Amendment advocate, you're no longer on the left. You are, and you are welcome. You are merely a libertarian like me. It's an okay, small L, not a big L. Big L libertarians are ridiculous, but a small L libertarian. Matt Clausen says, Nick, treat yourself to $100 worth of McAllen abuse. Cheers. Will do, buddy. Thank you. Christopher says, as someone who works in the energy industry, garbage burns brighter than legal does. Redbird says, feet. Dark Phoenix says, legal bites is as beautiful as Good Logic's beard. Gosh, you guys and your simpery for legal bites is embarrassing. In fact, I have to go to the bathroom again because people make fun of me. They're like, oh, you're old man bladder or whatever. But you have to understand, I am drinking diuretics. I'm drinking diuretics along with just liquid. I'm going to play this little intermission song. I'll be back in just a minute after I go to the bathroom.
Paradigm of absolute control. And that's why we're just out here doing simple things, pointing out that we're meant to be in nature and be natural. And this is where we find the source that God made to transcend the new world order. And that's why they want to try to keep us out of it.
I've had enough of They literally under rocks. They have green, and they run around screaming, saying they want it, baby. I have them on video. Hillary's in the creepy stuff, man. She sleeps in the same room with that creepy woman of mother wears a foot over. That woman number one is ugly. Imagine how bad she smells, man. I'm told her and Obama just stink. Obama and Hillary both smell like sulfur. Spirit gets close to that evil and I feel we don't need noise and rising against the billions burning. The fair was tapping. I'm so pissed. We're gonna stare your daughter at the mall. We're gonna stare your.
What the hell is going on with this fucking song? I don't know why it was I don't know what's happening. Something was broken there. So sorry about that. No, I didn't play it twice. Something was messed up with the actual playback. That's why I was pausing. That was fucking weird. I did not click play twice. God damn it. On Streamlabs, you can't, or StreamYard, you can't click play twice. It doesn't matter. It doesn't matter. Anyway. Okay. Back to this. I don't know why that was being weird. My internet is, I think my computer needs to be rebooted. Kyle Lundgren says, I'm not going to pause every 5 seconds. Pauses every 2 seconds. Batman's pet goldfish. Woo. Says, it's very evident that Legal Eagle doesn't re-record his lines for bad takes at the very least. D-Watt says, did you see Tim sing to his chickens? No. Mazith says, Legal Eagle is unhinged. Don't you remember his FOIA request against Trump over the Ukraine phone call? I do. He did not do well in those, but he raised a lot of money for them. Tyler Ventura says, Kyle spent the day at Mar-a-Lago with Trump in Florida. What a wild ride this kid has been on. Again, the optics of all of this. I'm pro BLM. I'm this and this and this. Oh, I'm also going to visit Trump. Like, pick a narrative and stick with it. You're alienating both sides. It's not a good idea. Tyler Ventura says, Vanch Agarwal says, Legal Eagle closes the door with his hip. Really now says, so is this where all the drunk lawyers hang out after hours? Yes. Steve Sir Sosimo says, isn't it about time for a drink? No, I've had too many. Justin Roberts says, for the best intro ever by Uncivil Law, 10,000 out of 10. Caddy says, by the way, GoFundMe are allowing fundraisers for the Christmas parade guy. Thoughts on this? They might just not have gotten around to banning him yet, but it's disgusting. It's disgusting. Notice how the Christmas parade guy is like, the media is scrambling to apologize for this guy and to say, oh, right wing is making this a thing. This motherfucker murdered 5 people. Kyle Rittenhouse shot in self-defense and killed 2 monsters. And we're supposed to declare these, like the disparate treatment. It's evident, right? If you're paying any attention, it's evident. Okay. Chris Mann says, can we not call Rosenblum a man? A man doesn't mess with children. BMO says, it was provocation. Nick just admitted Kyle's strip for the diddler. Tyler Ventura says, Barnes' outfit is as real as Kyle is free vibe. 63 Rambler says, what if someday Legal Eagle red pilled himself? Impossible. Sam Zero says, there is no India. That's true. India is fake. I hope you guys know that by now. Metal Gear Taxes. I don't trust people who talk and act this way. They act like robots. It's weird. Anyway, oh, hi, Rags. Pun intended says, name your panel, Rekida's life. Legal interpretation for everyone. Adam Riley says, the Rittenhouse trial was all a long con by Backdoor Binger to have the car source on Cross and bust him in a fraud. A true hero he is. Simone9937 says, in German, Kreuz means arm, so Grosskreuz means large arm, which is rather unfortunate. Really now says, being military, Kyle did better than that night than most of the people I've served next to. Tyler Ventura says, there's footage from the Fox News feed of Kyle holding in laughter when Richard says the hocus pocus line. Try and find it. Logan Orr says, drunk, got to work at 4 a.m., but here I am being a good Lowen. Quicks says, it's a schooner. Oh, you poor ignorant soul, it's a sailboat. Teresa Child says, your coverage of the trial was great. I enjoy how the lawyers on your panel support each other, keep supporting each other, and we'll keep supporting all of you. Yeah, that's the thing about the legal YouTube community is we're generally friends. Living in Sacramento says, verdict is that Legal Eagle is guilty of not watching the trial. Felipe Burke says, you guys rock. Ricada, you better be sharing all these donations. We do not share donations. That is not a thing. I would never ask anybody to pay me to be on a show. They do not ask me to pay them. That is why we promote each other's channels. That's why we say, hey, go check out this person, go look at their things, go see if you like their coverage. Because we do not do the sharing thing. We're not communists here. Never should be a communist. Jay Brown says, dude is actually acting like a lawyer you call for your traffic tickets. Robert Butler says, I think barely Legal Eagle and Little Binger got a law degree from the same place, a cereal box. Gunblade Knight says, I can see you got your one token on for this stream. It's nice to see Uncivil Law representing the Louis Anderson lookalikes. Guy Vermectin says, cry havoc and let loose the fog of war. PFUS says, what is your legal analysis of Kyle's chat with Tucker? Tomorrow. Z. Michael Gelke says, Barnes is 100% right. This can't be self-defense when he's fleeing. It's at best citizen's arrest and not with probable cause or reasonable force. Bird Bath Bash is wondering if someone in the mob started yelling active shooter. Would that have added any weight to Binger's strategy? They did. They didn't say active shooter, but they said things like it. Get that guy. He shot that guy. Devoa Bear says, as I read comments on Legal's video, I think it should be grateful YouTube removed the dislike counter. Denny RN says, God, I love Ricardo's late night wee hours law school. Pinky says, don't they have to declare the intent to arrest before initiating violence? I don't know. Siren Zero says, platoon, only thing that kill Barnes is Barnes. Matt Deckard says, my expert opinion for Barnes regarding Legal Eagle shirt and tie. Yes, from Target. True. The jacket can totally be from 5'8" and under in Beverly Hills. Chris Mann says, here's Kyle's state of mind. I shot him. Oh, shit, I shot him. Police, go to police. Mario Carter says, JoJo is survived by his 5 children. Fucking stop that. Galactic Emperor Shulam says, Superman is bulletproof. That sign is very misleading. Tactless 86 says, Legal Eagle looks like a partner at Wolfram and Hart. Someone else said that earlier, or maybe you did. Maximus Grove says, did you see that Gage G's DUI from October 2020 is on YouTube? I've seen it, but I haven't watched it. Malachi says, Smeagol is almost as sleazy as Binger and Krause. Won't Be Famous says, I have my Bluetooth headphones in and just hear Ricada absolutely losing it. These last 5 minutes or so of Legal Eagle's video is going to be entertaining. Tara Rayner says, Ricada Law, Kyle and his mother met with Trump either yesterday or in the last few days. They look so happy. Can't wait to see Nathan DeBrewer on here. Rob Price says, Legal Weasel is the second biggest asshole in the world. The first is the blue whales. It can stretch to 10 feet. Let's give a heart to Alita. 10 says Ford Escape commercial here. Brian Polito says, ha ha ha, you can't say 1352. You can. You can. Flash the Mystic says, wahoo. Finally caught the legendary roasting of vocabulary bloated poser opportunists. Looking forward to more Ricada. John Beck says, Veggie Grill sucks. Derek Mullen says, the lamp in Legal Eagles video is a replica of lamps that has been used in films for 40 years. More than likely, a Hollywood person produces his videos. Oh, yeah. Oh, yeah. 1.7 million subscribers, making tons and tons and tons of money. And most importantly, one thing to remember, Legal Eagle, and this, I respect this hustle. He is bringing hundreds, if not thousands of clients to the firm in which he works. And if they have him doing any legal work, they're fucking dumber than anyone else. He should be doing nothing but producing video content that will drive traffic to the law firm. It's beautiful. Dr. Diddler says reasonable doubt is the reason Casey Anthony got off. Her defense lawyer adequately confused the jury with it. Yeah. Well, they couldn't prove that she actually killed the girl. At worst, they could prove that she did some weird shit with the body. They never proved she killed the girl. Redrick Lasera says, I just wanted to share that a Democratic group cut ties with their social media person after they tweeted about the Waukesha thing, saying car was probably defending itself. I can't help but find it kind of funny. Not only that, that Democratic person, the weird, ugly fucking woman who was behind those tweets, turns out she had a DUI. Actually, she had multiple DUIs, and someone even tweeted, isn't it time for this again for her next DUI? Just a gross, disgusting person. And then she goes on and bitches, no one ever cared about me at any other time. Hey, maybe do something fucking useful and someone will care about you. You may not get 1 million people on Twitter to care about you, but someone will. Just be useful instead of being whatever you are. Rob Moreno says, almost 3 a.m. here, finishing off about a 25-year alt, more enjoying the stream. It's the longest 24-minute video review, and I love it. Newspace is glad to see the gang back together. You need to find out how to make a team-themed fair use. Ricada is Face, Barnes is Hannibal. Who is Mr. T? And Murdoch? I don't know. Mario Carter says, God works in mysterious ways. Some days he puts maps in the path of your bullets. Others, he gets you a full acquittal with shit legal defense. Cool Guy Aspie says, utilizing your right to self-defense makes you a survivor and observer of Second Amendment, not a hero. Putting out fires and providing medical makes you a hero. Tyler Ventura says, Kyle was the only guy with the balls to go down there and say, not in my town. Heroic, if you ask me. Mandy Karavika says, Joe Shadow Legends. Come play the new RPG game. The shadow cast by the Dark Lord grows longer with each day. Only hope stands in defiance. You answer the summons of the Arbiter to liberate the realm with good logic. Kyver Dam says, one could also argue that he's an unknowing hero to victims of kitty diddlers and domestic abusers. Carson Depp says, check out Clifton Hicks' Ballad of Kyle Rittenhouse. Reality Now says, all the folks in your chat simping for legal bites. I feel bad for her. However, judging by the chat, she could have a very successful feet OnlyFans. Legal Bites is very married. She's very, very married, guys. Gallifreyan Refugee says, I don't think he's a hero. I think he's a human in a horrible situation that had to defend himself. Do you think he did very well? Speaking as someone who was in the military, I was impressed. PFUS says they wanted to fight. They did what they did to feed their families. Hyper Strike says Kyle's only mistake was overestimating the beneficence of his fellow man. Turin says, is this live or just real life? Z. Michael Gelke says, gasoline to a match party. Even his analogies imply Kyle wasn't the cause of these events. And Important says, Kyle's young, innocent, and thought he was invincible. But above all, he was a Boy Scout, and I'm tired of people not seeing that. Eugenius Bear says, Legal Eagle brought dick to a porn shoot. 10 says, decentralized, transparent commentary and debate is the future. Thank you for all your effort. We hear you and are watching. Kyle Lundgren says, Barnes, can I work for you? I've never watched Suits. Next, he says, Legal Iron Sights. Panel's been great. Almost makes me think lawyers are human. They're not. Angry Bellsprout says, Joe Horn is a Texas hero. Eugenius Bear says, what killed George Floyd? Derman 875 and C Goody are both Derman joined at lawyer status. C Goody sends YouTube channel memberships are for the gays. Sign up to ricadalaw.locals.com and support him on there instead. Brought to you by channel membership free message. Your mental illness is every time you pause legal weasel, he looks like a mob boss talking to his goons. Red C says, where's lockpicking lawyer? It's a good question. Where the fuck is he? Declan Reed says, legal eagle upon learning Latin. The Rittenhouse defense argument doesn't elevate to the standard, also known as Wingardium Leviosa. Nightwave Radio. Hey, said, what's up, buddy? I have to disagree. This dude has a lot of books behind him. Now, granted, he said his camera's focused to make them look blurry, so I'm confused as to what books they are, but they're clearly books. Do you, Mersh? Do you see this shit? Do you see all these fucking books? My book, look, Mersh, these fucking books, these books over here, these cost more than his fucking books. My books cost way more. Way better books. Way better books. Asior says Devin Nunes. Look, I met Kesh Patel, who's Devin Nunes' former staff member. Waldemar says, gotta play the Billy Madison Award, no point scene. Disgruntled Deed says, when's it going to snow? Already snowed in Minnesota. We already had a half-inch of snow. It melted, but we had it. We had a half-inch of snow. It was terrible. Terrible. What snow so early in the year? It's really gross. I don't want to have it. Bronson Folieri says, wanted to share some nice music with you in chat. Search on YouTube, Moondog 1969 full album. God bless you, Nick. Everybody. Hope everyone enjoys the music. CH1 PPZ says, Kyle wasn't justified by testimony, but the fact that everything is recorded these days, as much as I hate modern tech, it saved Kyle here. Eugenius Bear says, just another Binger boat, buddy. Viteus says, Washington Statute RCW 9A.16.110. I don't know what that means. Squeeb says, would you go on Timcast again? 100%. You seemed annoyed with Tim at times, in my opinion, but I enjoyed it. How was the experience? No, 100%. I wasn't annoyed. Look, I'm used to talking because I run my show and he runs his show. So I had to wait for him to finish a point or someone else to finish a point out of respect for their setup. I prefer a little more rough and tumble, a little more overlapping voices and stuff like that, but it was good. And yes, I would go back. Abuba22 says he is trying to cover the hickey Chad gave him. Dino Fry says, I'm drinking a Berkalatic Islay and playing Forza Horizon 5 while I listen instead of studying for my agency and partnership final. Good. Russell R. Thank you. AJ Cook says, under my interpretation of the law, auto-translated in my head to reasonable minds may disagree. Good stream, but I might need therapy now. Legal Eagle gave me an experience beyond limits, pain, pleasure, inadvisable. CC says, to be honest, I just want to see more legal kitties. Very fair. Pastor Flash says, you need to play your toilet break song for Rankle. Joe brought up that too. I need to reboot my computer because for whatever reason, we're getting some fucking delays on anything internet related. Dino Files says, after COVID School of Law for 3.5 semesters, I'm pretty much resigned to graduating where Biden did. Make me feel better about that. You know what they call the person with the lowest graduating score in law school? A lawyer. A lawyer. Feel good about it. Law school. I don't know if you're talking about law school. Law school, undergrad, postgrad. These are not good barometers of success. They're good barometers of how well you did in college, and your real life will not be college. For one, there's a whole lot less cheerleaders in real life than there are in college. That's all I'm saying. Squid says, catching up on the stream, I found Legal Eagle last year and quit watching as soon as his video showed that he has TDS and is extremely biased. Creed Guardsman says, go sub to Good Logic. He is what Nick used to be. He does his sub goal parties. He drinks at the promised like donation numbers, and he has Drex on now. Well worth the watch. Definitely go check him out. Hot Creamy Fart says, what if Binger prosecutes the Waukesha monster? Guys, I tried to keep up with drinks, and to be fair, this is my 9th drink. We have 9,000 likes. I've drank half of this 9th drink. I'm going to get to the other half, but when I closed my eyes, it hurt me. It's a lot of drinks. Hot Creamy Fart says, what if Binger prosecutes the Waukesha monster? Angry Baneling says, disbar Binger, but also rebar Binger multiple times. Sparky's Tech Corner says, Ricada Law, if everyone donates 10, that's 110,000 with all the views. Yes. If everyone does something, it's a lot of people, but we don't get that. Quick says, do you believe this is the only time he's been shady for that matter? The entire practice of prosecution? No. Mario Carter says, Joe is auditioning to be Nick's second wife. Raid of Storm says, have you heard of the Rittenhouse drink? A chaser and 3 shots? Yes. Who You Drew says, is it just me, or should Legal Eagles stay in their lane and review more movies like Legally Blonde? Pissed Off Patriot says, Nick, what's your take on the Arbery trial? The guy's guilty because he shot him 3 times, not just once. He can't prove citizen's arrest. I think the citizen's arrest thing's a big deal. I think he'll be found guilty. I don't personally have an opinion. There's that one's under the law. It's not easy either way, but under just common sense, it's pretty either way. Like someone's robbing your neighbor, you go after him. Deborah Wolf says, time to suffer, Nick. If this video has more than 10,000 likes, you need to watch High Guardian Spice and now He-Man on Twitch Live. I don't have more than 10,000 likes. In fact, the chat has stalled at a measly 9,000. I don't think they can even get to 10,000 likes, so don't do that. Pete Hill says, make sure you add the donation link to the show description. That sounds like a lot of work at this point in time. Adam Rhodes says, shout outs to Flufferboy 2004. Also, are we allowed to go full Nearman in super chats? Check out Adam Rhodes 536 on YouTube. You are allowed to do whatever you want. Lakasai Foodie Can says, back in the chair days of Vic, I sent you an image of me with my contract law book. Thanks for responding. Took a year off, but this whole shit is firing back up to finish law school in Australia. By the way, thank you. You're welcome. Go do it. Seth Kaiser says, can I mod? I do for Legal Mindset and Legal Bites. Probably, but not when I'm falling asleep and hammered. Great Lakes Audit says, ever want to get into constitutional law with auditors? I don't know. Name 530 says, I wonder what the legality of selling whiskey packaged with a dose of Lake City penicillin 50 BMG would be. Jennifer Watts Studio says, will you join Nate for the Arbery verdict today? I don't know if I will. Probably not going to be awake. Josh Laycock says, donated 500 Aussie dollar dues to Dominic. Americans do not understand how lucky they are to have the Constitution. We are fucked here in the Souther colony. Keep fighting for your freedom. Look, Josh, RIP to you being in Australia. Guys, an update on Jacob Blake. We're at $43,078. That means something like $3,200 has been raised, which is amazing. Iggy Bailey says, Tim is shorter than Nick. Nick is shorter than me. I'm not shorter than you. Stop it. Merrick Kolodzijek says, please more Legal Eagle debunked. He's quite a figure. Look, he said he's going to release another video on the subject, and I will make fun of it. Max says, Legal Eagle is the guy who argued Captain Marvel electrocuting and robbing the Don with self-defense. Looking forward to this. Get Ricada on EFAP. Yeah, put me on Mahler show. Mahler, you motherfucker. You fucking Englishman. Bring me on. Still Sleeping says he didn't clear the jam rack, the gun. He just pushed the forward assist to bring the bolt into the battery. Joe Schmobius says, if you ever represent me, please drink this much and make them business pay. Bob Piffle says, great job, Nick and panelists. You ought to do a review of famous cases, one a month throughout the years, starting with the bullshit trial of Christ. Keep up the good work. Maybe. Adrian Jones says, when are you and Drax reviewing the Cowboy Bebop live action? It would be hilarious, just like your reactions as trailers were. Oh, fucking Christ. Crusader says, Nick, please don't be blood sports. That was so gay. I'm not blood sports. I don't do blood sports. What are you talking about? Hollister Ranch Real Estate says, any land use YouTubers prepping for an imminent domain action at our California ranch? Pacific Legal Foundation is supporting us. Insane hearing this week. Gage's Phantom Bicep says, I'm a little late, just over an hour in. An awesome guest to try and get the defense video expert to give testimony he was actually going to give. Break down what he was talking about in sound links. I've actually sent an email to John Black asking him for that very thing. Miser Heart says, imagine being me and having this playing while I was asleep and having that and having a repeating nightmare in my dream. What did I wake up to? Rajveer says, if I go to Anime Matsuri and cosplay as you, Nick, do you think I could get mistaken for being anti-Semitic? Yes. Do it. Do it, Rajveer. Come to Anime Matsuri. What the fuck is wrong with you? Pablo Lojo says, video would be more funny if you object to the arguments of the state in Richard's voice. Thanks for the educational value. We're almost done. Gonzo Sarge says, bro, I remember the events of Kyle's shoot. Before shot one was fired, videos of he and his buddies were being posted in which they said he supported BLM. Just want to make sure nobody was hurt. Ted Comment says, why Legal Eagle is such a dweeb? Crusader says, daytime stream too. Don't burn yourself out, Nick. I won't. I've been wanting to add a daytime stream forever, and I finally started working it out. Plus, we have a new audience of people for the daytime. Eagles Paw Gaming says, can you do the book thing, but as Richards? No. Deborah Wolf says, almost at 10,000, Nick. He-Man and High Guardian. Spice. And we're at only 9,251 likes. Don't say we're almost at 10,000. We got a long way to go. I think there's some Streamlabs donations. Are you serious? Fucking hell. Oh no. Those are way old. This is my old one. I don't know how to even get to the current. I don't know how to do Streamlabs. I got disconnected and it's trying to connect through my old one that's banned. Guys, I'm going to take it out of the description. Don't donate through Streamlabs. Don't. They banned me. They're shit. Maybe eventually I'll add Stream Elements or something. I don't know how to even find it. Fen says, woke up and at 7 a.m. you're still streaming. You deserve this cash. And Alexander Havas says, when do you sleep? Right now. Thank you guys for hanging out with me. I'm going to bed. I hope you guys have a good night. Peace.